For respond number 6 in this case.
My lord, I represent respond number 8.
For respond number 6 in this case.
Court is not audible, my lords.
ಹೌದು ಹೌದು ಆಯ್ತು.
ನಾನು ಒಂದ್ಸಲ ರೂಲಿಂಗ್ ಕೊಡ್ತೀನಿ ಸ್ವಾಮಿ, ಒಂದ್ 3 ರೂಲಿಂಗ್
ನಿಮ್ ಮೇಲೆ
ಡಿಲೇಗ್ ಹೇಳ್ರಿ.
ಏನಿದೆ ಅಲಿಗೇಷನ್ಸ್
ನಿಮ್ ಮೇಲೆ ಅಲಿಗೇಷನ್ಸ್ ಹೇಳ್ರಿ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ.
ಅಲ್ಲ, leakage. So there is meritorious case.
ಹೌದಲ್ಲ?
After 8 years of
whatever it may be, maybe the
meritorious cases should not be thrown out from the docket
on the ground of delay.
Delay each day because the merits are secondary. First of all, the condemnation of delay, the seriousness of offense.
We'll deal with.
Police also knowing that, the department also knowing that the seriousness.
ಏನೋ ನೀವೇನೋ ಹೋಗಿರ್ಬೇಕಲ್ಲಿ ನಾ ಮಾಡ್ದಂಗೆ ಏನೋ ಒಪಿನಿಯನ್ ಕೊಡ್ದಂಗೆ
ಫೈಲ್ ಹೋಗಿಲ್ಲ ಸ್ವಾಮಿ. ವೆಂದೆ ಇಲ್ಲಿ
ಒಪಿನಿಯನ್ ಕೊಡ್ದಂಗೆ ಅಡ್ಜಸ್ಟ್ ಮಾಡಿರ್ಬೇಕು ನೀವು. ಮತ್ತೆ ಅವ್ರ್ಯಾಕ್ ಬರೀತಾರ ಹಾಗಂತ ಇಲ್ಲಿಗಲ್ ಅಟೆಂಪ್ಟ್. ಮತ್ತೆ ಈ ಸರ್ಕಾರದಲ್ಲಿ ಏನೇನ್ ನಡೀತಾವ ನಮಗೇನ್ ಗೊತ್ತಲ್ಲ ಅಂತ ಅನ್ಕೊಂತಿದ್ದೀರಾ? ಮತ್ತೆ it is an offense against the society. Court has to take note of the delays concerned, but we are going to impose cost on the prosecution department as well as the government in not taking the decision in filing the appeal in time.
The proper update may be this update is not enough.
ಹ್ಮ್.
Proper affidavit will be.
ಪ್ರಾಪರ್ ಬೇಕಾಗಿಲ್ಲ, ನಾವು ಅದನ್ನೇ ಹೇಳ್ತೀವಿ. ಇನ್ ಇಂಜಿನಿಯರ್ಸ್ ಮೆಥಡ್ ದೇ ಹ್ಯಾವ್ ಅಡಾಪ್ಟೆಡ್ ನಾಟ್ ಎಕ್ಸ್ಪ್ಲೈನ್ ದಿ ಡಿಲೇ ಬೈ ಕಾಸಿಂಗ್ ಆಫ್ ಡಿಲೇ ಇನ್ ದಿ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಆಸ್ ವೆಲ್ ಆಸ್ ಇನ್ ದಿ ಗವರ್ಮೆಂಟ್ ಅಂತ. ಗವರ್ಮೆಂಟ್ ಗೆ ಹೋಗಿದ್ದು ಯಾವತ್ತು ಡೇಟ್ ಫೈಲ್ ಡೇಟ್ ಕೊಡಿ ನಮ್ಗೆ.
ಅವ್ರು ಹೇಳಿದ್ರು 27/9/24 ಹೋಯ್ತು.
27
27/9/24.
24 ಅದ್ ಅಲ್ಲಿ ಇಲ್ಲ ರೀ, ಅವ್ರು ಕಳ್ಸಿಕೊಟ್ಟಿರೋದೇ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅಲ್ಲಿ 27/9
ಹೌದು ಸ್ವಾಮಿ.
ಅವ್ರು ಕ್ಲಿಯರ್ ಮಾಡಿರೋದು ಯಾವಾಗ?
ಅದೇ
ಅವ್ರು clear ಮಾಡೋದು ಅವ್ರು ಬಂದಿದ್ದು ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಬಂದಿದ್ದು 16/5/24 ಅಂತ ಹೇಳ್ತಾರೆ.
16/5 ಆಯ್ತ್ರಿ, ಒಪಿನಿಯನ್ ರಿಸೀವ್ ಮಾಡ್ಕೊಂಡ್ರು. ಜಡ್ಜ್ಮೆಂಟ್ ಯಾವಾಗ ಹೇಳಿ?
Judgment date
22/4 ಏಪ್ರಿಲ್
25/4.
25/4 ಹೌದಲ್ಲ?
ಹೌದು ಸ್ವಾಮಿ.
ಅಲ್ಲಿ ಇವರು ಪಿಪಿನೇ ನಾವು ಮೋಸ್ಟ್ಲಿ ಒಪಿನಿಯನ್
PP opinion ಕೊಟ್ಟಿದ್ದು
ಪಿಪಿ ಆರ್
6/5.
ಸಿಬಿಐ ಡೈರೆಕ್ಟರ್
6/5.
16/5 ಅವರು ಇನ್ ಟೈಮ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಹೌದು, ಇಲ್ಲಿ time
16/5
ಆಗಿದೆ.
ಅಂದ್ರೆ ಒಂದು 15-20 ದಿವಸದಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅವ್ರನ್ನ ವಿ ಕೆನಾಟ್ ಫೈಂಡ್ ಫಾಲ್ಟ್ ವಿತ್, ಬಟ್ ದಿ ಮ್ಯಾಟರ್ ವಾಸ್ ಪೆಂಡಿಂಗ್ ಬಿಫೋರ್ ದಿ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಫ್ರಮ್ 16/5/24 to 27/9/24 ಹೌದಾ? ಫಾರ್ ಆಲ್ಮೋಸ್ಟ್ 4 months ಪ್ಲಸ್. ಮತ್ತೆ ಗೌರ್ಮೆಂಟ್ ಗೆ 27/9 ಬಂತು. ಗೌರ್ಮೆಂಟ್ ಅಲ್ಲಿ ಯಾವಾಗ ಕ್ಲಿಯರ್ ಆಗಿರೋದು ಹೇಳಿ? ಅಪೀಲ್ ಫೈಲ್ ಮಾಡಿದ್ ಬೇಡ, ಗೌರ್ಮೆಂಟ್ ಅಲ್ಲಿ ಒಂದು ನೋಟಿಫಿಕೇಶನ್ ಇಶ್ಯೂ ಮಾಡ್ತಾರೆ, ಈಸ್ ಎ ಫಿಟ್ ಕೇಸ್ ಅಂತ. ಯಾವಾಗಲ್ರಿ ನೀವ್ ಹೇಳ್ಬೇಕು ಅಶೋಕ್ ನಾಯ್ಕ್.
20
ಇವರು ಯಾರು ಕೊಟ್ಟಿಲ್ಲ, ಆ ಸೆಕ್ರೆಟರಿ ಹೋಮ್ ಸೆಕ್ರೆಟರಿ ಇರ್ಬೇಕು ನೋಡಿ.
22/2025
22
ಗವರ್ಮೆಂಟ್ ಆರ್ಡರ್ ಆಗಿದೆ.
ಯಾವಾಗ?
22/2025 ಇಲ್ಲಿ ಇದರಲ್ಲಿ
2022 ನಾ?
ಹೌದು ಸರ್.
25
22
ಅಲ್ಲಿಗೆ ಸೆಪ್ಟೆಂಬರ್ ಇಂದ ಹಿ ಸ್ಲೆಪ್ಟ್ ಆನ್ ದ ಫೈಲ್ ಟಿಲ್ ಫೆಬ್ರವರಿ.
ಹೌದು ಸರ್.
ಹೌದಾ?
ಹೌದು ಸರ್.
ಯಾರು ಪರ್ಮಿಷನ್ ಕೊಟ್ಟವ್ರ ಅದನ್ನ? ಅವ್ರಿಗೆ ಹಾಕನ ಕಾಸ್ಟ್. ಸೀರಿಯಸ್ ಮ್ಯಾಟರ್ ಇದ್ದಾಗ, ಪೇಪರ್ ಲೀಕೇಜ್ ಇದ್ದಾಗ, ವೈಸ್ ಈ ಸ್ಯಾಟ್ ಆನ್ ದಿ ಫೈಲ್ ಫ್ರಮ್ ಸೆಪ್ಟೆಂಬರ್ 2024 ಟು ಫೆಬ್ರವರಿ 25. ಈ ಅಪೀಲ್ ಫೈಲ್ ಮಾಡಿದ ಅವಾಗ ಮತ್ತೆ 22/4 ಆಮೇಲೆ ಮತ್ತೆ ಇವರು ಆಯ್ತು, ಇವ್ರದೇನೋ 72 ಒಂದ್ 2 ತಿಂಗಳು
ಇಲ್ಲಿ ಸ್ವಲ್ಪ ಲೇಟ್ ಆಗಿ ಹೆಚ್ಚಿಗೆ ಏನು ಆಗಿಲ್ಲ ಸರ್. ಗವರ್ಮೆಂಟ್ ಲೆವೆಲ್ ಅದು ಪ್ರೊಸೆಸ್ ಆಗಿದೆ. ಯಾಕಂದ್ರೆ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಯಾವುದೇ ಸ್ಪೆಷಲ್ ಪಬ್ಲಿಕ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನಾವು ಪ್ರಾಂಪ್ಟ್ ಆಗಿ ಕಳಿಸಿ CID ಇಂದ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಹೋಗುತ್ತೆ. ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅಲ್ಲಿ 4 ಇಲ್ಲಿ ಯಾಕಂದ್ರೆ ಕ್ರೈಮ್ ಪ್ರೊಸೀಡ್ಸ್ ಬಗ್ಗೆ ಡಿಸಿಷನ್ ಕೊಟ್ಟಿಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್. ಆವಾಗ ದೇ ಗೋ ಆನ್ ಫೈಲಿಂಗ್ ಕ್ಲೇಮ್ ಪಿಟಿಷನ್ಸ್. ಆವಾಗ ವೆನ್ ಐ ಕಾಲ್ ಫಾರ್ ರಿಪೋರ್ಟ್ ಫ್ರಮ್ ದೇರ್ ವಾಟ್ ಹ್ಯಾಪನ್ಡ್ ಅಬೌಟ್ ದಿ ಅಪೀಲ್ಸ್ ಅಂದಾಗ ಇವರು ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಗಾಟ್ ಅಲರ್ಟೆಡ್.
ಈಗ
4 ತಿಂಗಳು
ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅಲ್ಲಿ 4 months ಅಂಡ್ ಡಿಲೇ
ಹೌದು ಸರ್.
ಆಗಿದೆ.
ಹೌದು.
ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಅಲ್ಲಿ ಯಾರು ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಡೈರೆಕ್ಟರ್ ಆಫ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ತಗೋಬೇಕ ಡಿಸಿಷನ್ ಯಾರು?
ಅಲ್ಲ, ಡೈರೆಕ್ಟರ್ ಅಲ್ಟಿಮೇಟ್ಲಿ ಡೈರೆಕ್ಟರ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್
ಹೌದಲ್ಲ?
ಹೌದು, ಅವರೇ ಆಪರೇಟ್.
ಅವರಿಗೆ ಹಾಕೋಣ ಕಾಸ್ಟ್. ಲೆಟ್ ದೆಮ್ ರಿಕವರ್ ಇಟ್ ಫ್ರಮ್ ಎನಿ ಲ್ಯಾಪ್ಸಸ್ ಆನ್ ದಿ ಪಾರ್ಟ್ ಆಫ್ ಎನಿ ಅದರ್ ಆಫೀಸರ್.
ನಾನೊಂದು 3 ರೂಲಿಂಗ್ ಕೊಟ್ಟಿನಿ ಸ್ವಾಮಿ. ಅದ್ರಲ್ಲೂ
ruling?
ಏನ್ ಹೇಳ್ತಾರೆ ಅಂದ್ರೆ ಜಸ್ಟ್ ಗವರ್ಮೆಂಟ್ ಇಂದ ಸ್ವಲ್ಪ ಟೇಬಲ್ ಟು ಟೇಬಲ್ ಹೋಗ್ಲಿಕ್ಕೆ ಲೇಟ್ ಆಗುತ್ತೆ ಅಂತ.
ಟೇಬಲ್ ಇದ್ರೂ ಟೇಬಲ್ ಅಲ್ಲಿ ಬಾಕಿ ಇದೆಲ್ಲ ಫೈಲ್ ಒಂದೇ ದಿವಸದಲ್ಲಿ ರಾತ್ರಿ ಕ್ಲಿಯರ್ ಆಗ್ತವೆ ಫೈಲು ನಿಮ್ ಸರ್ಕಾರದಲ್ಲಿ. ಇದಕ್ ಮಾತ್ರ ಟೇಬಲ್ ಟು ಟೇಬಲ್ ಬರ್ತದ?
ಐ ಡೋಂಟ್ ಡಿಫೆಂಡ್
ಟೇಬಲ್ಗೂ ಏನಾರು ಟೈಮ್ ಇದೆಯಾ ಅಥವಾ ಬೇರೆ ಏನಾರು ಇದೆಯಾ ಯಾರ್ಡ್ ಸ್ಟಿಕ್?
Mr. Counsel, the judgment was pronounced on 25/4/2024. The matter was referred to public prosecutor 6/5/2024. Opinion ಕೊಟ್ರೆ ಅವತ್ತು.
ಅವ್ರು ಕೊಟ್ಟಿರೋದು.
ನಂತರ COD ಆಫೀಸರ್ಸ್ ಒಪಿನಿಯನ್ ಕೊಟ್ಟಿದ್ದು 9/5/2024.
ಹೌದು ಸ್ವಾಮಿ. ಪ್ರಾಂಪ್ಟ್
ಅಲ್ಲಿಂದ 16/5/2024 ಗೆ ಡೈರೆಕ್ಟರ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಬಂತು. ಅಲ್ಲಿಂದ 27/9/24 ಡೈರೆಕ್ಟರ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಅಲ್ಲೇ ಉಳಿತು ಫೈಲ್.
ಅದು ಕ್ಲೇಮ್ ಪಿಟಿಷನ್
ಟೇಬಲ್ ಟು ಟೇಬಲ್ ಎಲ್ರಿ ಬಂತು ಪ್ರಾಸಿಕ್ಯೂಷನ್?
ಅಲ್ಲ, ಇಲ್ಲ ಇದಕ್ಕಲ್ಲ, ಇದ್ರ ಬಗ್ಗೆ ಅಲ್ಲ.
ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಟೇಬಲ್ ಟು ಟೇಬಲ್ ಎಲ್ಲಿ ಬಂದು?
ಇಲ್ಲ ಅಲ್ಲಿ ಅದ್ರ ಬಗ್ಗೆ
ಡೈರೆಕ್ಟ್ ಟೈಮ್ ಇಲ್ಲ, ಬರೀ ವಸೂಲಿಗೆ ಮಾತ್ರ ಟೈಮ್ ಇದೆ. ನಿಮ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಪ್ರಾಸಿಕ್ಯೂಟರ್ಸ್ ಗಳಿಗೆ ಏನ್ ಹರಾಸ್ ಮಾಡ್ತಾರೆ ಅಂತ ಗೊತ್ತಾ ನಿಮ್ಗೆ? ಗೊತ್ತೇನ್ರಿ? ಗೊತ್ತಾ ನಿಮ್ಮ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಡೈರೆಕ್ಟರ್ ಆಫ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಏನೇನ್ ಮಾಡ್ತಾರೆ ನಿಮ್ ಪ್ರಾಸಿಕ್ಯೂಟರ್ಸ್ ಗಳಿಗೆ ಅಂತ?
ಗೊತ್ತಿಲ್ಲ. ನಾನು ಐ ವಾಸ್ ಆಲ್ಸೋ ಇನ್ ದಿ ಪ್ರೊಸೀಡಿಂಗ್ ಫಾರ್ 25 years. ಆಮೇಲೆ ವಾಲಂಟರಿ ತಗೊಂಡೆ.
ಹೌದು, ಈಗ ಏನ್ ಮಾಡ್ತಾರೆ ನೀವೇ ಎದೆ ಮುಟ್ಕೊಂಡು ಹೇಳಿ ನಮ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅದೇನು ನಡೆಯಲ್ಲ ಅಂತ.
ನಾನು ವಾಲಂಟರಿ ರಿಟೈರ್ಮೆಂಟ್ ತಗೊಂಡೆ.
ಅದಕ್ಕೆ ಹೇಳಿದ್ದು. ಎದೆ ಮುಟ್ಕೊಂಡು ಹೇಳಿ ನಡೆಯಲ್ಲ ಅಂತ.
ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ ನಾನು ಕ್ಲೇಮ್ ಪಿಟಿಷನ್ ಹಾಕಿದ್ಮೇಲೆ ದೇ ಗಾಟ್ ಅಲರ್ಟೆಡ್. ಅವ್ರು ಕ್ಲೇಮ್ ಪಿಟಿಷನ್ ಹಾಕ್ಲಿ ಶುರು ಮಾಡಿದಲ್ಲ ಸರ್.
ದುರಂತ ಏನ್ ಮಾಡೋದು ಸರ್ಕಾರ ಹಂಗ್ ಮಾಡ್ತಾರೆ, ಏನ್ ಮಾಡೋದು? ಈ ಡೈರೆಕ್ಟರ್ ಆಫ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಅಪಾಯಿಂಟ್ ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ ವಸೂಲಿ ಮಾಡ್ಕೋತಾರ. ಕೇಳಿ ಪ್ರೆಸೆಂಟ್ ಡೈರೆಕ್ಟರ್ ಆಫ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಏನ್ ಮಾಡವ್ರೆ ಅಂತ. ಈ ಕಿತ್ತಾಟ ಬೇರೆ. ಮೊನ್ನೆ ಎಲ್ಲ ನೋಡಿದೆ ಪೇಪರ್ಲಿ, ಯಾರು ಜಡ್ಜ್ ಯಾರು ತರಂಗಿಲ್ಲ, ನಮ್ಮನ್ನೇ ತರಬೇಕು ಅಂತ ಏನೋ ಒಂದು ರಿಟ್ ಏನೋ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆಗ್ತಂಗಿದೆ BNSS ಚಾಲೆಂಜ್ ಮಾಡ್ಕೊಂಡು. At least district judge ಆರ್ ಹೋಗಿ ಕೂತ್ಕೊಂಡ್ರೆ ನೆಟ್ ರಿಪೇರಿ ಮಾಡ್ತಾರೆ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್. ಹಿಂದೆ ಎಲ್ಲ ಶಂಕರ್ ಹೆಗಡೆ ಅವರೆಲ್ಲ ಇದ್ರು.
ಹೌದು.
ಹೌದಲ್ಲ?
Yes,
ಹೆಂಗಿತ್ತ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್?
Correct. Yes.
ಈಗ ಹೆಂಗಾಗಿದೆ ನಿಮ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್? Earlier, at the rank of principal district judge was the director of prosecution. ಹೌದಲ್ಲ? ಅದನ್ನ ಕಿತ್ತಾಕಿ ಈಗ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಮಾಡ್ಕೊಂಡ್ರು.
One submission, man. The only ground that they are taking is because the government. That's why they are.
Supreme Court has made it clear. Litigant may be a public, a state, or may be a private person. They cannot be a separate yardstick. That is the law. Howda? That is the law. Now we will impose the cost. The persons who are responsible for the not filing the appeal in time, in taking the decision. We will not throw the appeal on the ground of that there was a delay. It is a serious matter. Leakage of question paper. It affects the whole state. That to PUC students. That is the life change stage. Hodilla. My daughter is also experienced.
After 8 years of.
More. Sixteen ಇರಬಹುದು ಅವಾಗಲೇ.
2016 sir.
Second PUC chemistry paper. Now she is pursuing MD now.
ಅದು investigation reveals all question papers.
10 ವರ್ಷ ಆಯ್ತು. 5-6 ಅದು ಕೋವಿಡ್ ಅಂತ ಒಂದು 6 ವರ್ಷ
FIR
MBBS ಆಯ್ತು.
FIR with respect to question paper leakage
3
of
ವರ್ಷ
chemistry.
6-3-9 ಅಲ್ಲಿಗೆ ಬರುತ್ತೆ. ಮೋಸ್ಟ್ಲಿ ಅದೇ ಇರಬೇಕು. ಕೆಮಿಸ್ಟ್ರಿ ಪೇಪರ್ ಯಾವ್ದ್ರಿ?
Chemistry ಅಂತ FIR ಆಗಿತ್ತು, but investigation revealed all question papers. Chemistry ಅಂತ FIR ಆಗಿತ್ತು ಸ್ವಾಮಿ, ಆದ್ರೆ ಎಲ್ಲ question leak ಆಗಿದೆ.
All
investigation revealed. ಅವನ A4 ನೇ ಹೋಗ್ತಿದ್ದಲ್ಲ.
We are going to deal with in hand, whoever it may be. Whoever it may be. 2016, probably 16. Casual ಬಿಟ್ಟು ಡಿಲೇನು ಕೊಡಿ ಮೇಡಮ್. ಏನ್ ಕಣ್ಮುಚ್ಕೊಂಡ್ ಮಾಡ್ತಾರ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಂತ ನಿಮ್ಮವ್ರ ಅಫಿಡವಿಟ್ ಹಾಕೋದು ಇಲ್ಲಿದೆ ಮೇಡಮ್. ಅದು ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್, ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್, ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್, ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್, ಕಂಡೋನೇಷನ್ ಆಫ್ ಡಿಲೇ. ಯಾರು ಅಪೀಲ್ ಇದು ಕಂಡೋನೇಷನ್ ಅಫಿಡವಿಟ್ ಹಾಕಿರೋದು ಯಾರು?
ಡೈರೆಕ್ಟರ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್.
ಡೈರೆಕ್ಟರ್ ಆಫ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್
ಅಂಜನಾ, ಡೆಪ್ಯೂಟಿ ಡೈರೆಕ್ಟರ್.
ಇವ್ರಿಗೆ ಮೋಸ್ಟ್ಲಿ ಇವ್ರಗಳಿಗೆ ಇನ್ಫೈಟಿಂಗ್ ಇವರು ಈಗ ಒಬ್ಬರಿಗೆ. ಹೌದಾ?
ಇವರೇ ಡೈರೆಕ್ಟರ್.
ಇಲ್ಲ ಅವ್ರಿಗೆ ಕೊಟ್ಟಿಲ್ಲ, ಬೇರೆಯವ್ರ ಕೂರ್ಸವ್ರೆ. ಸರ್ಕಾರಗಳು ಏನ್ ಮಾಡ್ತಾವ ಗೊತ್ತಾಗುತ್ತಲ್ಲ, ಸೀನಿಯಾರಿಟಿ ಇಲ್ಲ, ಎಲ್ಲ ಸೀನಿಯಾರಿಟಿ ಬರೀ ಇದು. ಡೆಪ್ಯೂಟಿ ಡೈರೆಕ್ಟರ್ ಅದಕ್ಕೆ ನಾನು ಹೇಳಿದ್ದು, ಇದು ಪ್ರೆಸೆನ್ಸ್ ಆಫ್ ಚೀಫ್ ಜಸ್ಟಿಸ್, ಚೀಫ್ ಮಿನಿಸ್ಟರ್ itself I said duty of the public prosecutors, if even state government commits any mistake, the duty of the public prosecutor to tune them. ಕಿವಿ ಹಿಂಡಬೇಕು ಸರ್ಕಾರದ ಅಂತ. ಈಗ ನಾವು ಇನ್ಫೈಟಿಂಗ್ ಬಿಟ್ವೀನ್ ದೆಮ್, ಡೆಪ್ಯೂಟಿ ಡೈರೆಕ್ಟರ್ ಅಂಡ್ ಡೈರೆಕ್ಟರ್ ಫಾರ್ ನಾಟ್ ಗಿವಿಂಗ್ ದಿ ಪೋಸ್ಟ್. ಈಗೇನ್ ಮೊನ್ನೆ ಎಲ್ಲ ಪೇಪರ್ ಓದ್ದೆ, ಯಾವ್ದೋ ಒಂದು ಪೋಸ್ಟ್ಗೆ ಇದಕ್ಕೇನೆ ಈಗ ಮೋಸ್ಟ್ಲಿ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಜಡ್ಜ್ ಮಾಡ್ಬೇಕು ಅಂತೇನೋ ಮಾಡೋರು, ಡೈರೆಕ್ಟರ್ ಆಫ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್. ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡ್ಕೊಂಡು ಹೋಗೋರು. ತೊಳಿ ಎಲ್ಲಿದ್ದಾರೆ ರೀಸನಿಂಗು? ಹೇಳಿ ನೀವು ರೀಸನಿಂಗ್. 9/5/24 ಆಯ್ತು.
ಅಷ್ಟೇ ಸರ್ ಲಾಸ್ಟ್.
16/5. Later from this office, the opinion was sent to the government on 27/9/24. That delay was not explained. Rest of the delay is caused in the government level ಅಂದ್ಬಿಟ್ರು. ಅವ್ರದ್ದು ಹೇಳಿಲ್ಲ, ಗೌರ್ಮೆಂಟ್ ಹೇಳಿಲ್ಲ. ಅಷ್ಟೇ ಒಂದೇ ಪಾರ.
ಹೌದು ಸ್ವಾಮಿ.
Objections of R2, R4, R9. ಹೇಳ್ರಿ ರೆಲೆವೆಂಟ್ ಪ್ಯಾರಾ ಯಾರು R2, R4, R9 ಅದೇ ಸೇಮ್ in between the delay has not been explained. ಹೌದಾ? That is this objections.
Every day of delay.
ಆಯ್ತು ನೀವ್ ಒಂದ್ ನಿಮಿಷ ಇರ್ರಿ ಕೇಳ್ತೀವಿ ನಿಮ್ಮನ್ನ.
ಇಲ್ಲ ಆ ರೀತಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಇನ್ನೊಂದು
Statement of objections by R3 ಯಾರು? R3 objections ಹಾಕಿದ್ರಲ್ಲ ಇಲ್ವ ಅವರು R3 ನವರು? ಇಲ್ಲಿ ಮಿನೆ
I am for
R3. Yes.
Asim Malik.
In my memo citation, page number 41 madam.
Citation ಈಗ ಕೊಟ್ಟಿದ್ದೀರಾ ಮತ್ತೆ ಹಾಕಿದ್ರ objection ಜೊತೆ ಹಾಕಿದಿರಲ್ಲ? ಯಾವ್ದು ಡೆಡ್ ಬೈ ಕರ್ನಾಟಕ ಹೌಸಿಂಗ್ ಬೋರ್ಡ್ ಅಂಡ್ ಅದರ್ಸ್ ಅದಾ?
Yes, please. Para 115. However, as is manifest from the entire discussion above, for the purposes of condemnation of delay in terms of section 5 of the Limitation Act,
Sufficient cause.
the delay has to be explained by establishing the existence of sufficient cause for the entirety of the period from when the limitation began till the actual date of file. In other words, if the period
This
of
is the
limitation is 90
judgment
days,
judgment of Honorable Justice Pardiwal judgment. ಹೌದಾ?
please madam.
ಹೌದಾ?
ಇನ್ನೊಂದು 3 ಜಡ್ಜಸ್ ಬೆಂಚ್ ಒಂದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ನವರು ಹೇಳಿದ್ದಾರೆ ಸರ್.
Please, madam.
Post Master General. ಆಯ್ತು.
It's relying on post master.
This court is having conscience about those two judgments. Honest.
Therefore, all the days of delay. No,
ಅಲ್ಲಿ-
even in the day of limitation.
ಈ ಶಿವಮೊಗ್ಗ ಕೇಸಲ್ಲಿ ಎಷ್ಟು ದಿವಸ ಡಿಲೇ ಇತ್ತು ನೋಡಿದೀರಾ ನೀವು? ಎಷ್ಟು ದಿವಸ ಇತ್ತು ಡಿಲೇ? 3000 6000 ದಿವಸ ನೋಡಿ. ಇಟ್ ಕೆನಾಟ್ ಬಿ. ಈ ಶಿವಮೊಗ್ಗ ಕೇಸಲ್ಲಿ ಜಸ್ಟಿಸ್ ಪರ್ದಿವಾಲ್ ಅವ್ರ ಜಡ್ಜ್ಮೆಂಟ್ ಏನ್ರಿ ಓದ್ರಿ ಅಲ್ಲಿ? ಹೌದಾ? ಯಾಕೆ ಬಾಯ್ ಬಿಡ್ತಾ ಇಲ್ಲ ಕೇಳಿದಾರೆ ಉತ್ತರ? 3000 ಚಿಲ್ಡ್ರೆ ದಿವಸ ಇದೆ ಅದೇ ಜಡ್ಜ್ಮೆಂಟ್ ತಾನೇ ನೀವು ಓದ್ತಾ ಇರೋದು ಈಗ? ಪ್ಯಾರಾ 140, 141, 142 ಹೋಗಿ 250 ಇಂದ 261 ವರೆಗೂ ಓದಿದಾರೆ ನೋಡಿ. ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇರೋದು ಡಿಲೇ ವಾಸ್ 3000 and odd. Subsequently one more judgment 6000 and odd. This court also applying those two judgments rejected the delay applications earlier. ಆಯ್ತಲ್ಲ? ಇಲ್ಲಿರೋ delay only 257 days. This yardstick cannot be applied to the same. Next.
Entire sessions file after the 8 years has been exonerated.
8 years ಆದ್ರೂ ಆಯ್ತು. ಎಷ್ಟು ದಿವಸ ಒಳಗಡೆ ಎಷ್ಟು ದಿವಸ ಇದ್ರಿ ಹೇಳ್ರಿ? ಒಳಗಡೆ ಎಷ್ಟು ದಿವಸ ಇದ್ರಿ ಟ್ರಯಲ್ ಆಗುವಾಗ? How long you are in jail? ನೀವು ಹೇಳಿ. Objections ಮತ್ತೆ ಕೊಡೋದಿಲ್ಲ. ಲಾಸ್ಟ್ ಟೈಮ್ 2-3 times ಬಂದಿದೆ. Objections not filed. Then ಎಷ್ಟು ದಿವಸ ಇದ್ರಿ ಒಳಗೆ? ಏನಾದ್ರು ಇದ್ರ ಒಳಗಡೆ? ಎಷ್ಟು ದಿವಸ?
A1 ಮಾತ್ರ ಕೆಲವರು.
A1 ಮಾತ್ರ.
ಬಾಕಿಯವರೆಲ್ಲ
5.5 years ಇದ್ರು. A1 ಮಾತ್ರ.
A1 ಮಾತ್ರ.
ಇಲ್ವಾ? ಯಾರು A1 ಯಾರು?
A1 ಕಿಂಗ್ ಪಿನ್ ಆಫ್ ದಿಸ್ ಸಿಂಡಿಕೇಟ್ ಕುಮಾರಸ್ವಾಮಿ ಅಂತ. ಸಕ್ಸೆಸರ್
ಕುಮಾರಸ್ವಾಮಿ ಅಲಿಯಾಸ್ ಕುಮಾರ್ ಅಲಿಯಾಸ್ ಕಿರಣ್.
Successor of previous kingpin Shivkumar alias Guruji. Since 2008, they are involved in such public examination.
Statement of objections of R12. Statement of objections by R7, 13 and 14. Told.
For R6, my lord.
Yes, madam, you are appearing for whom?
R6, my lords, I filed my objections to IA for condemnation of. Yes, yes.
Vadavadagi.
Yes,
R5.
yes. R5, my lords, sir. R6, my lords.
Have you filed your statement of objections? R5 or R6?
R6, my lords, Manjunath.
Madam, your name is shown as R5. Tushar Vadavadagi for R5.
Yes, yes. Yes, yes. I have filed my statement of objection. Oh, I apologize. I filed my office statement of objections, my lord.
Already you have filed objections. R5.
Yes, my lord. I filed the objections.
There is a delay of 257 days.
I'm for R8, my lords.
This appeal. Vella citations, sir. Postmaster General, Uttar Pradesh, State of Kerala. Yes. How serious about this case? Huh? 257 ದಿವಸಕ್ಕೆ ಇಷ್ಟೊಂದು citation ಕೊಡ್ತಾರಲ್ಲ, how serious this case ಅಂತ.
Is a good case for
Want to, huh?
sufficient evidence is there.
Come out from clutches ಅಂತ.
Sufficient. Sufficient evidence is there.
ಇಲ್ಲ, better affidavit ನಾವು ಕಾಯ್ತಾ ಕೂತ್ಕೊಳ್ಳಕ್ಕಲ್ಲ, we'll impose the cost on them.
Better case for conviction.
ಹಾ?
ಒಳ್ಳೆ ಎವಿಡೆನ್ಸ್ ಇದೆ ಸ್ವಾಮಿ.
ಅದ ಆಮೇಲೆ ನೋಡೋಣ. ಫಸ್ಟ್ ಎಷ್ಟು ಹಾಕ್ಬೇಕು ಕಾಸ್ಟ್ ಹೇಳಿ.
I appear for R8, my lords.
Director of Prosecution as well as the ಸರ್ಕಾರ ಎರಡಕ್ಕೂ separate ಕಾಸ್ಟ್ ಹಾಕ್ತೀವಿ. ಎಷ್ಟು ಹಾಕ್ಬೇಕು ಹೇಳಿ ಮಿನಿಮಮ್. ವೈ ದೇ ಈಗ ಬಂದಿಲ್ಲಿ ಕನ್ವಿಕ್ಷನ್ ಕೇಸ್ ಅಂತ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಿರಲ್ಲ, ವೈ ದೇ ಹ್ಯಾವ್ ನಾಟ್ ಟೇಕನ್ ದಿ ಡಿಸಿಷನ್ when the matters are placed before the prosecution department as well as the government.
ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಇಮಿಡಿಯೇಟ್ ಫೈಲ್ ಹೋದ್ರೆ ಬೇಗ ಆಗ್ತಿತ್ತು ಸ್ವಾಮಿ.
ಇಮಿಡಿಯೇಟ್ ಆಗಿಲ್ಲ, ಅಲ್ಲೂ 4 ತಿಂಗಳಾಗಿದೆ. ಸರ್ಕಾರದಲ್ಲೂ ಅಷ್ಟಾಗಿದೆ. ಸರ್ಕಾರಕ್ಕೂ ಹಾಕ್ಬೇಕು, ಇಬ್ರಿಗೂ ಹಾಕ್ಬೇಕು. ಎಷ್ಟು ಹಾಕ್ಬೇಕು ನೀವೇ ಹೇಳಿ ಬೇಗ ಹೇಳ್ರಿ. ಕೌನ್ಸಿಲ್ ಏನೋ someone wants to make submission through VC.
My lords, I appear for R8, my lords. I have also filed my statement of objections. In the last
ಹಾಕಿದ್ದೀರಾ?
Yes, my lords.
ಹಾಕಿದ್ದೀರಿ?
Yes, my lords.
ಆಯ್ತು ತೋಳ್ ಆಯ್ತಲ್ಲ ಮೇಡಮ್. ಲಾಸ್ಟ್ ಸೆಂಟೆನ್ಸ್ ಹೇಳಿ. In filing the appeal and in the appeal in paragraph in the application in paragraph number 3, when the Deputy Director of Prosecution has filed the affidavit in support of condonation of delay application, in paragraph number 5 stated that Office of the Director of Prosecution and Government Litigation received the opinion of the SP Special Enquiry CID Bangalore on 16/5/24, and later from this office the opinion was sent to the government on 27/9/24, and further sworn to an affidavit that rest of the delay is caused in the government level. Having perused this affidavit, the Deputy Director of Prosecution in an ingenious method only stated the receipt of papers on 16/5/24, and opinion was sent to the government on 27/9/24, and in between 16/5/24 to 27/9/24 nothing is stated with regard to the delay in taking the decision and sending the opinion to the government, and also stated that rest of the delay is caused in the government level. And when the papers were sent to the government on 27/9/24, and the Department of Home also sat on the file, seven and a half months ಬರಲ್ರಿ, 27/9 ಅಲ್ವಾ? ಅಲ್ಲಿಗೆ ಅಕ್ಟೋಬರ್, ನವೆಂಬರ್, ಡಿಸೆಂಬರ್, ಜನವರಿ, ಫೆಬ್ರವರಿ, ಆಲ್ಮೋಸ್ಟ್ 5 months sat on the file for a period of 5 months from September to February, and nothing is stated with regard to the delay caused for a period of 5 months in the affidavit, and hence the respondents' counsels in their respective statement of objections have categorically contended that the delay caused in the Director of Prosecution Department as well as in the government has not been explained.
Government
Respond number 2, 4, 9 and respond number 3, respond number 5,
7,
and respond number
7, 13,
12 and respond number 7, 13 and 14 have filed the objection statement independently, and main
Eight also filed,
grounds
my
in the
R8
ನೀವು ಯಾವಾಗ
also.
ಹಾಕಿದ್ರಿ?
I filed it
ಹಾಕಿದ್ದೀರಿ?
in last date of hearing before the open court, my lords.
ಓಪನ್ ಕೋರ್ಟ್
Yes, my lords.
ಇಲ್ಲ ಏನ್ ನೋಡ್ರಿ. ಅಂಡ್ R8 ಹಾಕೋಬಿಡಿ. R8 common objections are raised that the delay has not been properly explained, and so also the delay in the Department of Prosecution as well as in the government is not explained, and hence each day delay has not been explained, and the same set of objections are raised by the respondents counsel. ಇದೆಯಾ ಸಾಕದು ಎಲ್ಲ ಮಾಮೂಲಿ ಅದೇ ಇರ್ತದೆ. Next, the counsel appearing for the state relies upon special public prosecutor relies upon the judgment of the apex court in Oriental Aroma Chemical Industries Limited versus Gujarat Industrial Development Corporation 2010 within bracket 5 SEC 459, and relying upon this judgment ಯಾವ ಪ್ಯಾರ ಹೇಳ್ತೀರಿ ಹೇಳಿ?
ಇಲ್ಲಿ ಕಂಟಿನ್ಯೂಷನ್ ಆಫ್ ಡಿಲೇ
ಯಾವ ಪ್ಯಾರ?
ಪ್ಯಾರ ನಂಬರ್
8.
ಪ್ಯಾರ ನಂಬರ್
is made in paragraph number 8 that law of limitation is founded on public policy. The legislature does not prescribe limitation with the object of destroying the rights of the parties, but to ensure that they do not resort to dilatory tactics and seek remedy without delay. The idea is that every legal remedy must be kept alive for a period fixed by the legislature. Stop. To put it differently, the law of limitation prescribes a period within which legal remedy can be availed for redress, the redress of legal injury. At the same time, the courts also are bestowed with the power to condone the delay, if sufficient cause is shown for not availing the remedy within the stipulated time. The expression sufficient cause employed in section 5 of the Limitation Act 1963 and similar other statutes is elastic enough to enable the courts to apply the law in a meaningful manner which subserves the ends of justice.
4.
The council also relied upon judgment of the apex court in Inder Singh versus State of Madhya Pradesh within bracket civil 6145 of 2024,
number 4
reported in 2025. Para idರಲ್ಲಿ
ಪ್ಯಾರ ನಂಬರ್ ಇಂದ್ರಜಿತ್
and the council appearing for the
ಪ್ಯಾರ ನಂಬರ್ 14
special PP
ಪ್ಯಾರ ನಂಬರ್ 14
paragraph 14 that there will be no quarrel on this principle of law that delay cannot be condoned without sufficient cause, but a major aspect which has to be kept in mind is that if in a particular case the merits have to be examined, it should not be scuttled merely on the basis of limitation.
Next page is to 4.
The council also relies upon the State of Haryana versus Chandramani 1996 ARSC 1623 and referring this judgment brought to notice of this court paragraph number 4 wherein also an observation is made that it is notorious and common knowledge that delay in more than 60% of the cases filed in this court, be it be by private party or the state, are barred by limitation, and this court generally adopts the liberal approach in condonation of delay, finding somewhat sufficient cause to decide the appeal on merits. It is equally common knowledge that litigants in the state are accorded the same treatment, and the law is administered in an even-handed manner. When the state is an applicant for condonation of delay, it is common knowledge that on account of impersonal machinery and the inherent bureaucratic methodology imbued with the non-making, file pushing, passing on the buck ethos, delay on the part of the state is less difficult to understand, though more difficult to approve, but the state represents collective cause of the community. Axiomatic that decisions are taken by officers, public agencies, proverbially at slow pace, and encumbered process of pushing the files from table to table and keeping it on table for considerable time, causing delay, that intentional or otherwise, that is a routine considerable delay of process of their making decision is a common feature. The same is observed in this judgment. The counsel appearing for the respond number 2, 4, 9 and 11 relies upon the judgment of 2012 within bracket 3 SEC 563 Postmaster General and other sources Living Media India Limited paragraph and brought to notice of paragraph 29 and 30. 27 ಏನ ಅಂಡರ್ಲೈನ್ ಮಾಡಿದಿರಿ ಆಯ್ತು 29 and 30 wherein an observation is made that it is right time to inform all the government bodies comma their agencies and instrumentalities that unless they have reasonable and acceptable explanation for the delay and there was bona fide effort comma need to accept the usual explanation that the file was kept pending for months, years due to considerable degree of procedural red tape in the process. The government departments are under a special obligation to ensure that they perform their duties with diligence and commitment. Delay is an exception and should not be used as an anticipated benefit for the government departments. And also brought to notice of this court paragraph number 30 wherein also an observation is made that there was no proper explanation offered by the department for the delay except mentioning of various dates comma according to us the department has miserably failed to give any acceptable and present reasons sufficient to condone such a huge delay. Yes, this is delay
481 days.
Huge antar adke 481 days. Next, the other judgment also relied upon by reporting 2014 within bracket to Supreme Court cases 422 State of Uttar Pradesh versus Amarnath Yadav. ಇದು 481 days ಅಲ್ಲ ಹೆಂಗೆ ಎರಡು ಒಂದೇ ಬರಲ್ವಲ್ಲ 480
ಅಲ್ಲ ಫಸ್ಟ್ ಒಂದು 481 ಸೆಕೆಂಡ್ ಪೇಜ್ ನಂಬರ್ 16 ಅಲ್ಲಿ 647 days.
And there was a delay of 641 days and 647 days and the apex court taking into note of Postmaster General versus Living Media Limited has deprecated such practice on the part of the council also relies upon the judgment 2024 within bracket 17 Supreme Court cases 267 State of Kerala versus Akshaya Jewelers delay that there were delay of 399 days refusal to condone the delay where no proper explanation was made out supporting affidavit for the satisfaction of the court even before the high court no proper explanation offered for condonation of delay and council relies upon the observations made by the court in paragraph number 5 and 8. Next, the council appearing for the R3 relies upon the judgment of the apex court Shivamma dead by LRs versus Karnataka Housing Board versus 2025 SEC online SC 1969 wherein there was a delay of 3000 ಇದೆಲ್ಲ 3000 ಚಿಲ್ಲರೆ ದಿವಸ ಇರ್ಬೇಕು ನೋಡ್ರಿ ಇದರಲ್ಲಿ 3966 days and also in this judgment apex court reiterated that there cannot be two different aspects whether the appeal is filed by the state or by the private party and same yardstick to be applied and also heavily come across against the state when there was a huge delay is concerned and council relying upon this judgment each delay has to be explained properly. Also relies upon the judgment of Postmaster General versus Media India Limited 2012 3 SEC 563. The same judgment was relied upon by the council for appearing for the R2, 4, 9 and 11 and same principle is applied. Other area citations yardaru then citations illala having heard the appellant counsel and also the counsel appearing for the respondents and in keeping the objections raised by the respondents and also the reasons assigned in the application for condonation of delay we have given anxious consideration to the material on record. And point that arise for the consideration of this court are whether the state through special public prosecutor has made out the ground to condone the delay of 257 days in filing this appeal. What order? Having perused.
One submission.
Ah.
On behalf of the government, there is no inordinate delay that may be taken.
Correct.
ನೋಡ ಅಲ್ಲಿಂದ ತುಂಬಾ ಏನು ವೇಳೆ ಟೇಬಲ್ ಟು ಟೇಬಲ್ ಇವೆಲ್ಲ ಆಗತ್ತಲ್ಲ, ವಿಧಾನಸೌಧದಲ್ಲಿ ಸ್ವಲ್ಪ ಲೇಟ್ ಆಗತ್ತೆ ಸ್ವಾಮಿ ಜನರಲಿ. ಅಲ್ಲೇ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅಲ್ಲಿ
MLAs
ಅಲ್ಲ ಆಗಲ್ಲ, ಅಫಿಷಿಯಲ್ ಬ್ಯೂರೋಕ್ರಾಟ್ಸ್ ಅಲ್ಲಿ ಇರುವಾಗ ಸ್ವಲ್ಪ ಲೇಟ್ ಆಗತ್ತೆ. ನೋ ಇನಾಟ್ ಡಿಲೇ ಆನ್ ಪಾರ್ಟ್ ಆಫ್ ದಿ ಗವರ್ನಮೆಂಟ್. ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್
first stop. Let them stop dancing to the tunes of the rulers. ಗೊತ್ತಾಯ್ತಲ್ಲ? Let them stop dancing their tunes. Having considered the application as well as statement of objections, and this court has to take note of the charges leveled against the respondents before the trial court. That is accusation made against the respondents. That is, prosecution asserts that accused number 1, accused number 2, and accused number have a history of pilfering question papers since 2000. The accused engaged in a criminal conspiracy, routinely committing theft from strong rooms in sub treasuries by bribing employees, with the aim of obtaining financial gain through the sale of the question papers to the prospective students and their parents. And also it is a case of the accused persons have indulged in leakage of paper for monetary gain, and hence the charge sheets are filed against them. For the offences 411, 454, 457, 380, 381, 461, 116, 120B, 201, read with section 109 of PC, section 23, read with section 115 of Karnataka Education Act 1983, section 13(1)D and 32 of the Prevention of Corruption Act, and section 31 within Roman 2, 32, 34 and 35 of Karnataka Control of Organized Crime Act 2000. Madam, you would get in paragraph 22. Having considered the accusation and also the material on record, particularly taking into note of affidavit on the part of Deputy Director of Prosecution, and this court already pointed out in paragraph number 3, reasons are given for continuation of delay. And having perused the material, dispute judgment was passed on 25/4/24, and opinion was given immediately by the prosecutor. On 16/5/24, the case was conducted before the trial court, but file was lying before the prosecution department from 16/5/24 to 27/9/24 for a period of 4.5 months. But no reasons are given by the Deputy Director of Prosecution by filing the charge sheet. What prevented in taking a decision for a period of 4.5 months? And there is a lapsus on the part of the prosecution department in not sending the opinion to the government 4.5 months. And hence it is appropriate to impose the cost on the prosecution department, that is Director of Prosecution, to pay the cost, which would be ascertained, which would be considered during the later part of passing an order. The other affidavit also, the content of the affidavit in paragraph number 3 says that the other delay is rest of the government. Also it is clear that file was sent to the government on 27/9/24 by the prosecution department, and government also sat on the file for a period of 5 months, 27/9/24 to 2025, for taking a decision and issuing the notification of almost 5 months. And also the principal secretary of the department is also responsible for delay is concerned. Delay of almost 5. Also to pay the by the principal secretary of home department, which would be determined while considering the application. The main contentions of council respondents appearing respondents that delay has not been explained properly, but delay is mentioned in the outcome of it, but not in detail explained the same. With regard to the delay at the hands of the prosecution department as well as the government, and no doubt the principles laid down in the judgment which relies upon the case of Shivamma case where there was a delay of 900 and ಮೇಲೆ ಹೇಳಿದ್ವಿ ನೋಡಿ 67 66 days ಏನೋ ಇದೆ. And he said principle cannot be applied in the case on hand and delay of only 257 days. No doubt counsel appearing for the respondent relies upon respondent number R2 or R2, R4, R9 and R11 relates upon the judgment of Postmaster General, and the same citation was also relied upon by the counsel appearing in the R3, wherein there was a delay of more than 600 and odd days delay. And so also in other two judgments also there was a delay of 481 days delay. Earlier, Postmaster General 481. Just 427 days, and in subsequent judgment 481 days, and in the judgment of the state of Kerala 399 days delay. And also these citations which have been relied upon by the council appearing for the state also referred supra Rental Aroma Chemical Industries Limited as well as Inder Singh versus state of Madhya Pradesh and state of Haryana, wherein also discussion was made with regard to the government taking decision and pushing the file from table to table, it may cause us delay. Having considered the principles laid down in the judgments referred supra and also taking into note of the factual aspects of the case, it is a case of leakage of paper of second PUC and indulging in such acts, and when such gravity of the offences are alleged against the respondents, and the court cannot throw the file at the time of consideration of the delay is concerned, and there was no any inordinate delay, only delay is 257 days. And also while filing the appeal by the state must get the opinion from the prosecutor who conducted the case at the trial level, and thereafter the same has to be sent to the prosecution department, and then prosecution department to the government, and that process will take place. But admittedly there was a delay on the part of the public prosecutor's office as well as in the government, and the same can be taken note of. And when such being the case, the court also while taking the decision in legal jurisprudence, particularly in India, the principle that meritorious cases should not be thrown out at the threshold emphasizes prioritizing substantial justice over procedural technicalities. While laws like the Limitation Act 1963 set strict time frames for filing cases to ensure finality, courts often adopt a liberal approach to condoning the delays if the case has strong legal merit and the delay is reasonably explained. And particularly, the Supreme Court of India has noted that while delay cannot be condoned without cause, the merits of the case should not be scuttled merely by limitation. And having taken note of the principles laid down in the judgments referred supra as well as the present case on hand, and the prosecution charges against the accused persons is nothing but affects the entire students' fraternity, and the same is allegation of indulging that leakage of question paper. It affects the lakhs of people, lakhs of students, that to a meritorious students, and when such being the case, and delay of 257 days could not take away the case of the prosecution department, and hence the delay is condoned subject to imposing of the cost on the respective persons who have not taken the decision in time in a serious case of leakage of question paper, and hence we answered the point accordingly. In view of the discussions made above, we pass the following order. The delay application is allowed on cost of rupees 2 lakh. Out of that, the prosecution department is payable. That is the director of prosecution, an amount of rupees 1 lakh, and also an amount of rupees 1 lakh by the Home Secretary, Principal Secretary to the Home Department. The liberty is given to the director of prosecution as well as the Home Secretary to collect the first pay the cost and then collect the same from the persons who sat on the file in not processing the same. This matter for admission on 25th. 26th. ಆಯ್ತು 26th.
25th of
7 SPP.
ಏನಾರು ಇದೆಯಾ ಮೇಡಮ್ ಕೇಸಲ್ಲಿ? ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿ ಮತ್ತೆ ಅವ್ರಿಗೆ ಬಂದು ಲಾಯರ್ ಹಿಡ್ಕೊಂಡು ಇಲ್ಲಿ ಕೇಸ್ ಇದ್ರೆ ನೋಡೋಣ. ಪ್ರಾಮಿಸ್ ಟು ಮ್ಯಾರೇಜ್, ಆಮೇಲೆ lack of evidence for taking her to lodge and failure to collect the CCTV footage undermines the presence of accused and prosecutrix in the lodge. Two different versions of medical report of two hospital creates doubt about the sexual intercourse by the accused. So even the psychiatrist who conducted counseling of prosecutrix has only stated that due to the act of her loved one, she undergone depression. He has not whispered that in view sexual assault by the accused. The prosecutrix undergone depression as elaborately discussed above. Prosecution has failed to prove that the accused has committed rape on the false promise of marriage and it may amounts to breach of promise.
PWP is the owner of the lodge, but given a statement like exhibit 13. There is stated.
PW1 ನೋಡ್ರಿ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಚಾಸ ಒಂದೂರು ಅವರು ಆರೋಪಿಯನ್ನೇ ಮದುವೆ ಆಗೋದಾಗಿ ಹೇಳಿ ಮನೆಯಲ್ಲಿ ಗಲಾಟೆ ಮಾಡುತ್ತಿದ್ದಾಳೆ ಎಂದು ಕಾರ್ಕಳ ಪೊಲೀಸ್ ಠಾಣೆಗೆ ನಾನು ದೂರು ನೀಡುತ್ತೇನೆ ಅಂದರೆ ಗೊತ್ತಿಲ್ಲ. ಮಲ್ಕಿ ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ಸಹ ಚಾಸ ಒಂದೂರು ಅವರು ಆರೋಪಿಯನ್ನೇ ಮದುವೆಯಾಗುವುದಾಗಿ ಚರ್ಚೆ ಆಯಿತು. ಫರ್ದರ್ ಸಿ ಹ್ಯಾಸ್ ಸ್ಟೇಟೆಡ್ ದಟ್ ನನಗೆ ಹಾಗೂ ನನ್ನ ಗಂಡನಿಗೆ ಚಾಸ ಒಂದೂರನ್ನು ಆರೋಪಿಗೆ ಮದುವೆ ಮಾಡಿಕೊಡಲು ಇಷ್ಟ ಇರಲಿಲ್ಲ. ವಾಟ್ ದಿ ವಿಕ್ಟಿಮ್ ಸೇಸ್ ಮೇಡಮ್? ನನ್ನ ಮಗಳು ಮಿಚೆಲ್ ನರ್ಸಿಂಗ್ ಕೆಲಸ ಮಾಡಿಕೊಂಡವಳು ಮುಲ್ಕಿಯ ವಾಸಿ. ಏನ್ ಹೇಳ್ತಾಳೆ ಅವಳು? ವೆದರ್ ಸಿ ಹ್ಯಾಸ್ ಸಪೋರ್ಟೆಡ್ ಮೇಡಮ್? Claim to be working in Dubai. Accused claimed to be working in Dubai. They acquainted with each other through mobile chatting. He met her at a church. He revealing that he was actually a bus driver in Golden Bus. He promised marriage, claiming to own land. On the same day, the accused took the prosecutrix on his bike to Malki so-and-so temple, offering her a Coca-Cola that made her dizzy. He then tied her to the back with shawl and took her to a lodge, where she regained conscious to find herself bloody and naked and realizing she had been raped.
Huh? 2 occasions she has been taken to the lodge and that is supported by the lodge owner.
ಏನು 2 ಸರಿಲೂನು made her to consume
Consume and once ಕಟ್ಟಿ
ಮತ್ತೆ ದಾಟ್ರಿಗೇನು ಕರ್ಕೋಕಾಗುತ್ತೆ ಮೇಡಮ್? ಇವಳು ಕನ್ಸೆಂಟ್ ಇಲ್ದಲೇನೆ. ಎಷ್ಟು ವಾಟ್ ಈಸ್ ಹರ್ ಏಜ್?
26.
Her age is 26.
She was staff nurse.
Staff nurse also.
PM staff.
Then whether the prosecution theory can be believed, madam?
The promise
Yena
of marriage.
juice ಕೊಟ್ಟನಂತೆ Coca-Cola that made her dizzy.
They are Facebook friends and on the promise to marriage she has gone along.
She knows the consequence. She knows consequence at the age of 26. ಹೌದಿಲ್ಲ?
Is concerned with the misconception that he married. When the marriage talks.
What misconception, madam?
ಹೇಳಿದಾರೆ.
She is aged about 26, madam. She knows what is the consequence. And the theory of that, after making her as dowsy, then took her to the lodge. Whether the theory can be believed?
Denied, Your Honor. In a further statement, she has denied that, yes.
ಅಲ್ಲೇನು ಹೇಳಿದ್ದಾರೆ ಅಲ್ಟಿಮೇಟ್ ಆಗಿ ಅಡ್ಮಿಷನ್ ಮಾಡಿದ್ರೆ ಏನು ಅಂದ್ರೆ ಅಟ್ಲೀಸ್ಟ್ ಕೇಸಲ್ಲಿ ಏನಾದ್ರು ರಿವರ್ಸ್ ಆಗಂಗಿರ್ಬೇಕು. ಅಟ್ಲೀಸ್ಟ್ ಯಾಕೆಂದ್ರೆ ಅಪೀಲ್ ಅಲ್ಲಿ ರಿವರ್ಸ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ದಿ ಯಾರ್ಡ್ ಸ್ಟಿಕ್ ಇಸ್ ಡಿಫರೆಂಟ್ ಇನ್ ಎ ಕೇಸ್ ಆಫ್ ಅಪೀಲ್ ಇಸ್ ಕನ್ಸರ್ನ್ merely because making of case each otherwise ಇಲ್ಲ perfection ಇರಬೇಕು ಅಪೀಲ್ ಅಲ್ಲಿ. Accused showed her the photos and videos which depicted her in a issue notice against the respondent ಬರ್ಲಿ ನೋಡೋಣ ಅವ್ರೇನು ಹೇಳಿ. And in the meanwhile registry is directed to notice on madam IA and also on main against the respondent. In the meanwhile registry is directed to get the SAR. This matter on first week al kodi 5-3 ಬರುತ್ತಾ ಅಷ್ಟೊಳಗೆ ಅಥವಾ ನೆಕ್ಸ್ಟ್ ಸೆಕೆಂಡ್ ವೀಕ್ ಕೊಡ್ತೀರಾ? ಆಲ್ರೆಡಿ 376 ಇದಲ್ಲ ವಿಕ್ಟಿಮ್ ಮಾಡ್ಬೇಕಿತ್ತಲ್ಲ, ಮಾಡಿದೀರಾ? ಆಯ್ತು ಮಾಡ್ಬೇಕಲ್ಲ ವಿಕ್ಟಿಮ್ ಪಾರ್ಟಿ. 376 ಇದ್ದಾಗ
ಹಿತೇಶ್ ವರ್ಮಾ
ನೋಡಿ ಯು ಟೇಕ್ ಡಿಸಿಷನ್. ನಾವು ನೋಟಿಸ್ ಆರ್ಡರ್ ಮಾಡಿರ್ತೀವಿ. 5-3 ಬೇಡ ಮೇಡಮ್, ಎಷ್ಟು ಅಷ್ಟೊಳಗೆ ಬರುತ್ತಾ? 12-3
Serial number 8. Narayan Swamy came.
CD of 49 days in filing.
Please.
Other side first time ಅಥವಾ
First time.
ಫಸ್ಟ್ ಟೈಮ್ ಆಯ್ತು. ಯಾರು ಅಡಿಷನಲ್ SVP takes notice. Heard on number 1 of 26 for condonation of delay of 49 days in filing, and additional SVP orally opposes the application that delay has not been properly explained. Having considered the application as well as reasons, and this appeal is against the conviction appeal, and hence delay of 49 days is condoned. List this matter for consideration of IA number 2 of 26 on ಯಾವಾಗ ನೋಡ್ಕೊಳ್ತೀರಾ ಮೇಡಮ್? ನೆಕ್ಸ್ಟ್ ವೀಕ್ 25-2.
whether number 2 has preferred any appeal?
Please.
A2 ಹಾಕಿದಾನ ಅಪೀಲು?
ಹಾಕಿದೆ.
ಅದೇ ಅದ್ ನಂಬರ್ ಕೊಡಿ.
2577.
2577 of 25.
Please.
The other accused also filed an appeal in criminal appeal number 2577, correct? Of 25, and hence registry is directed to put up
2559, please.
2559.
9 of 20.
2559, madam, ಬರ್ಕೊಳ್ಳಿ. Of 25, and hence post the same along with this appeal. On 25-2.
26, please.
26-2, ಆಯ್ತು.
ರೀಸೆಂಟ್ ಆಗಿ ಮಾಡಿದ್ರು ಸರ್, ನಿಧಿ ತೋರಿಸ್ತೇನೆ ಅಂತ ಹೇಳಿ ಒಂದು ಮರ್ಡರ್ ಮಾಡಿದಾರಲ್ಲ, ಸೇಮ್ ಇನ್ವೆಸ್ಟ್ಮೆಂಟ್ ಮಾಡಿ ಕೊಡಬೇಕಾಗುತ್ತೆ.
ಈಗ ನಿಧಿ ಕೇಸ್ಗಳು ಜಾಸ್ತಿ ಆಗ್ಬಿಟ್ಟವಲ್ಲ. ನೆಕ್ಸ್ಟ್ ವಿನೋದ್ ಕುಮಾರ್. ಇದು ಫಸ್ಟ್ ಟೈಮ್. Additional SPP is directed to take notice. Heard on IA number 1 of 26 for, and there is a delay of 240 days in filing. And counsel appearing for the state additional SPP orally opposes the application on the ground that delay has not been explained. And having considered this appeal is against the conviction appeal, and also the reasons assigned in the application, delay of 240 days is condoned. List this matter. ಇನ್ನೊಬ್ರ
Another. Respond number 2 ಇದೆ.
ಅಲ್ಲ ಇಬ್ರಿಗೂ ಹೋಗ್ಬೇಕು ನೋಟಿಸ್ ಅದೇ. ಹಾ ಆಯ್ತು. R2 ನಾ
Defective component.
ಹಾಗಾದ್ರೆ ಡಿಲೇ ಕಂಡೋನ್ ಇಲ್ಲ, ಯಾಕಂದ್ರೆ R2 ಇದಾರೆ. Issue notice against R2 and in the meanwhile registry is directed to get the records of the SR. This matter 12-3.
Great.
Admission matter 10.
Serial number 8 ಅಲ್ಲಿ ಬೇಡ ಸರ್. PCR ಬೇಡ ಇದರಲ್ಲಿ.
ATR ಹೇಳಿದ್ವಲ್ಲ, ಅದ್ರಲ್ಲಿ ಹೇಳಿದ್ವಲ್ಲ. ಹಿಂದಿಂದ್ರಲ್ಲೂ ಸೀರಿಯಲ್ ನಂಬರ್ 8 ಅಲ್ಲೂ ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್ ಹೇಳಿದೀವಲ್ಲ. ಹಾ ಕನೆಕ್ಟೆಡ್ ಇಲ್ಲ, ಡೇಟ್ ಕೊಟ್ಬಿಟ್ಟಿದ್ವಿ 26. ಕನ್ವಿಕ್ಷನ್ ಅಪೀಲ್ ಆಕ್ಚುಲಿ ಇದು ಕನ್ವಿಕ್ಷನ್ ಅಪೀಲ್ ಏನ್ ರೆಕಾರ್ಡ್ ಬೇಕಾಗಿಲ್ಲ, ಹೆಂಗಿರೋ ಅಡ್ಮಿಟ್ ಮಾಡ್ಲೇಬೇಕು ಅದು. ಹಾ ಇರ್ಲಿ ಬಿಡಿ, 12-3 ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀವಿ. 80 ಏನ್ ಬೇಡ, ಯಾಕೆಂದ್ರೆ ಶಾರ್ಟ್ ಡೇಟ್ ಇದೆ. ಅವೆಲ್ಲ ಮಾಡೋದಾರು ಮಾಡಿ, ಅಷ್ಟೊಳಗೆ ಬಂದ್ರೆ ಬರ್ಲಿ, ಇಲ್ಲ ಅಂದ್ರೂ ವಿತೌಟ್ ರೆಕಾರ್ಡ್ಸ್ ವಿ ಕ್ಯಾನ್ ಹಿಯರ್.
10. SPP Sharat Chandra.
A2 absconded. ನಿಮಗೇನು ಟೈಮ್ ಕೊಡೋ ಪ್ರಶ್ನೆ ಇಲ್ಲ. ಸ್ಟೇಟ್ ಹ್ಯಾಸ್ ಟು ಮೇಕ್ ಔಟ್ ಎ ಕೇಸ್. ಅಡ್ಮಿಷನ್ ಬಿಟ್ವೀನ್ ದಿ ಕೋರ್ಟ್ ಅಂಡ್ ಅಲ್ಲ ರೀ, ಡೇಟ್ ಗಿವನ್ ಮ್ಯಾಟ್ರು. ನೌ ಯು ಆರ್ ಸೀಕಿಂಗ್ ಟೈಮ್. ಕಾಸ್ಟ್ ಹಾಕಿ 10,000 ಕೊಡೋಣ ಡೇಟು ಹೇಳಿ. ಇಟ್ ಈಸ್ ಲೆಫ್ಟ್ ಟು ಯು. ದೇ ಹ್ಯಾವ್ ಟು ಮೇಕ್ ಔಟ್ ಎ ಕೇಸ್ ಫಾರ್ ಅಡ್ಮಿಷನ್. ಹೇಳಿ ಮೇಡಮ್. A1 and A2 murdered wife ಅಲ್ಲ, wife of PW6. PW2 3 6 are interested witnesses. PW1 is an independent witness. ಹೌದಾ? ಗ್ಯಾಂಗ್ ರೇಪ್
32 ನಲ್ಲಿ.
32 to 35. ಏನೋ 7,500 ರೂಪಾಯಿ ಕೊಡ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಿ ಕೆಲ್ಸದ ದುಡ್ಡು.
Subsequently, the notice on the stay of the parents of the deceased was released from the custody. But what has happened is subsequently he got married after 6 months after the death of this victim. And his wife has got married again, second wife. The second wife is also has died. The case is going on against the present PW6 for the murder of this second wife. Suspecting that these caused the death.
ಈಗ period 2 ಪ್ರಕಾರ the deceased died in the morning at 11:30 AM.
In the morning.
And as per the evidence of period 6, the victim was alive till 7 PM ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ.
What is the evidence of the medical records? ಡಾಕ್ಟರ್ ಏನ್ ಹೇಳ್ತಾರೆ? ಟೈಮ್ ಸಿನ್ಸ್ ಡೆತ್ ಏನ್ ಹೇಳ್ತಾರೆ ಡಾಕ್ಟರ್? PM ಕಂಡಕ್ಟ್ ಮಾಡಿದಾಗ whether it goes back to 11:30 AM or victim alive at 7 PM ಅಂತ.
And according to period 3,
murder was committed at 12 PM.
Midnight.
In the night.
Time since 3 to 4 hours to consumption of last movement. Time since death. Time since death consumption of last meal. Cause of death is asphyxia as a result of combined effect of smothering and manual strangulation.
Time since death to
3 to 4 hours.
3 to 4 hours after consumption
Of last meal.
ಲಾಸ್ಟ್ ಮೀಲ್. ಇದು ಯಾವಾಗ ಕಂಡಕ್ಟ್ ಮಾಡಿದ್ದೀವರು PM ನ at what time?
When the conducting of postmortem is 3:35 PM to 5 PM on 18/8/2016.
ನೆಕ್ಸ್ಟ್ ಡೇ ಹೌದಾ? ಬಟ್ in the previous day PW 3 ಪ್ರಕಾರ 7 PM ವರೆಗೂ ಇದ್ರು. ಬಟ್ ಪೊಲೀಸ್ ಕೇಸ್ ಪ್ರಕಾರ ಬೆಳಗಿನ 11:30. ಅದೇ 9 o'clock. ಕೆಲವರು 10 o'clock, 12 o'clock. How you are going to match the timings, time since death?
He opens the door and he finds his wife dead on the bed. There is another witness who speaks about the presence of this PW6 along with his wife. But that witness does not speak about the presence of accused number any other accused person. The seizure of clothes, the instance of these accused persons will bloodstained clothes. The report states that the victim's blood report is B. Accused blood report is B positive number those blood. But the victim's blood report is O. But with regard to the episode report, will also shows that the bloodstained clothes are O positive number.
O positive, that means deceased blood.
Deceased blood and the accused clothes.
Accused cloth ಅಲ್ಲೂ ಅದೇನೆ O positive ಏನೆ, O positive ಏನೆ.
ಹೇಳಿದ್ದಾರೆ ಸರ್ PW 1, 3.
But only interested witnesses ಅಂತ PW 2, 3, 6.
1, 2, 3, 6.
ಅಲ್ಲ PW 1 is an independent witness.
ಹೌದು.
He's the one who's actually lodged the complaint. He's the one who speaks about PW6 being present at the time of the death of his wife. Suspecting that since there are regular fights between the deceased and PW6, he suspects he hears some voice from when he's standing out. He hears some voice screaming words of the lady. But he thinks that it's regular fight that is going on between PW6 and the deceased. That's why he does not pay attention. But sometimes PW6 comes out of the house and informs this witness that my wife has died on this. At that time, the also PW1 does not speak about the presence of this accused person. He only speaks about the presence of the husband, PW6. And the IO lordships has not collected any CDRs. There is no work done by the IO. The IO's evidence says that he knows PW6. IO's evidence is only there. Speaks about the recovery of these clothes of the accused persons.
But accused cloth ಅಲ್ಲಿ blood group of deceased are found. ಹೌದಾ? O positive blood was found in the cloth of the accused. Then accused has to explain how the blood group of the deceased found in his cloth, but he has not given any such explanation.
And the accused is also supposed to he has sustained some injuries, so the certificate was also produced. He has also sustained injuries.
How he has sustained injury, madam?
Regarding that, there is no explanation.
ಮತ್ತೆ ಏನ್ ಇನ್ಸಿಡೆಂಟಲ್ ಅವನು ಇದನ್ನ ಆಗುವಾಗ
That is not.
ಅದು ತಂಬು ಮತ್ತು ಕಲ್ಲಿಂದ
ಚಂಬು
ವೆಸಲ್.
ಅದೇ ತಂಬು.
But what is actually
ಅಲ್ಲ,
compared?
what is his explanation? How he has sustained injuries? ಮತ್ತೆ ಕೊಡ್ಬೇಕಲ್ಲ ಇಂಜುರಿ ಎಕ್ಸ್ಪ್ಲನೇಷನ್.
P7 and P8 on certificate.
Matter requires reconsideration. We'll admit. ನೋಡಿ. Heard the counsel appearing for the state as well as counsel appearing for the respondent and having considered the reasoning of the trial court, matter requires reconsideration. Admit. The registry is directed to get the records of the trial court and prepare the paper book within 8 weeks from the date of securing of records from the trial court. The respondent is directed to execute a bond for rupees 1 lakh with one surety before the trial court to the satisfaction of the trial court within 2 weeks from today. ಹೋಗಿ ಬಾಂಡ್ ಬರ್ಕೊಡಿ.
ಒಬ್ನೇ ಆರೋಪಿನ?
ಅವನು ಅಬ್ಸ್ಕಾಂಡ್ ಆಗಿದ್ದಾನೆ. A2 is absconded. Trial only against A1. A2 absconded ಇಲ್ಲಿ ಬರ್ಕೊಂಡಿದ್ದಾನೆ. Absconded.
11. Prasanna Rao.
11.
302 kerosene.
On record has.
Kerosene and killed her.
Chip
Kilo
withdrawal,
3, 4,
memo
5.
for withdrawal. We are filing memo for withdrawal, your lordship, as we have given NOC to the client, your lordship.
ಅಲ್ಲ NOC ಕೊಟ್ರಿ ಏನು ವಿಡ್ರಾ ಮಾಡ್ತಾ ಇದೀರಿ? ಅಪೀಲ್ ನ ವಿಡ್ರಾ
Petition.
ಮಾಡ್ತೀರಾ?
ಹೌದು ಸ್ವಾಮಿ.
ಏಕೆ?
Petition. IA withdraw ಮಾಡ್ತಿದ್ದೇವೆ.
ಅಯ್ಯೇ ವಿಡ್ರಾ ಮಾಡ್ತಿದ್ದೀರಾ? ಅಲ್ಲ ನೀವು ಒಂದ್ಸರಿ NOC ಕೊಟ್ರೆ ಯು ಕೆನಾಟ್ ವಿಡ್ರಾ ದಿ ಅಯ್ಯೇ. ಕೊಡಿ ಏನು ನೋಡೋಣ.
NOC ಕೊಟ್ಬಿಟ್ಟಿದ್ದೇವೆ.
ವಿಡ್ರಾ ದಿ ಪಿಟಿಷನ್ ಅಂತಾನೆ ಇದೆ ಅಂತೆ. Prasanna Rao, the undersigned counsel for appellant hereby submit that NOC has been issued to the appellant in the present case. Hence, I request this honorable court to permit me to withdraw the petition in the ends of justice. ನೀವೇಂಗ್ರೆ ವಿಡ್ರಾ ಮಾಡ್ತೀರಿ? ಅವ್ರು ಬೇರೆಯವ್ರ ಲಾಯರ್ನ ಇಟ್ಕೋಬಹುದು ಬಂದು.
I'm a proxy counsel, your lordship. He has asked me to hand over the copy.
Ask him to come to court.
Please, your lordship.
Pass over.
ಅದೇ ವಿಡ್ರಾ ಮಾಡಕ್ ಬರುತ್ತೆ.
ಅಪೀಲ್ ವಿಡ್ರಾ ಮಾಡಿದ್ರೆ ಹೋಯ್ತು. ಮತ್ತೆ
ಅದು convicted prisoner.
convicted prisoner. Pass over.
Number 12.
Appearing for respondent number 1 and 2, your lordship.
Offense under 302, your lordship. Conviction is granted for 304, subclause 2 years, 7 years.
304 part 2.
Grandchildren of the
Sir,
deceased, your
ಈ
lordship.
ಕೇಸಲ್ಲಿ the honorable judge has not discussed
Lordship,
how we come to self-evaluation.
304 2 ಬರುತ್ತೆ ಅನ್ನೋದಕ್ಕೆ ಏನು ಹೇಳೇ ಇಲ್ಲ.
Judgment ಅಲ್ಲಿ ಮಾಡಲ್ಲ ಸರ್. Only here on here.
Not the first attempt.
Here on sentence ಅಲ್ಲಿ 302 to 304 part note ಮಾಡ್ಕೊಂಡು.
ಸೆಂಟೆನ್ಸ್ ಅಲ್ಲಿ ಮಾತ್ರ. ಫಸ್ಟ್ ಕನ್ವಿಕ್ಷನ್.
ಆಮೇಲೆ ಇದು ಹೆಂಗೆ
302 ಗೆ
ನೋಡಿ ಈಗ ಬರುತ್ತೆ ಸರ್. ಈಗ ನಾನು ಸುಮಾರು ಕೇಸ್ ಮಾಡೋದು ನಾನಿಂದ ಅಮರಣ್ಯ ಅವರನ್ನು ಮಾಡಿದೆ. ಇವತ್ತು ಮೂರಲ್ಲ ಕೇಸ್ ಇದೆ ಸರ್. ಇವತ್ತು ಮೂರಲ್ಲ. ಇಲ್ಲಿ ಜಡ್ಜ್ಮೆಂಟ್ ಓವರ್ ಡಿಸ್ಕಸ್ ಇದೆ. ಈಗ ಮತ್ತೆ ಅದಕ್ಕೆ ಎವಿಡೆನ್ಸ್ ಬೇಕಲ್ಲ ಸರ್.
ಅಡ್ಮಿಟ್ ಮಾಡೋಣ. ಅಡ್ಮಿಟ್ ಮಾಡಿ
ಸರ್
ತಗೊಳ್ಳಿ. ಏನೋ ಹೇಳೋದಿದೆಯಾ ಮೇಡಮ್ ನೀವು?
Your lordship, the accused number 1 and 2.
ಕೋಪ ಸಾಲ ಮಂಟಪಿನಾ?
Please, your
ಹೇಳಿ.
lordship. Your lordship, accused number 1 and 2 has come before the honorable court and has been, their sentence has been suspended and the bail has been granted to both the accused, your lordship. And the prosecution could not support, could not prove the motive, your lordship.
ಅಲ್ಲ ಮೇಡಮ್, conviction is for the offense punishment from 302 read with section 34 of IPC.
304 part 2 ಗೆ
how can the
conviction.
presiding officer once convicted for the offense punishment
Prosecution could not prove the charge.
in the case within the 304 part 2?
Your lordship, the prosecution could not prove the charged.
Not answering to court question. Accused was convicted for the offense punishment section 302. Whether the trial judge awarded the punishment to the 302 or in 304 part 2 in the sentencing.
304 part 2.
Sentencing ಅಲ್ಲಿ.
Yes.
ಅದನ್ನೇ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. How could? Conviction is for 302.
But he has not given proper.
302 ಗೆ punishment ಕೊಡ್ಬೇಕಲ್ಲ.
ಹೌದು.
ಸೆಂಟೆನ್ಸ್ ಅಲ್ಲಿ 304 part 2 ತರ್ತಾರಲ್ಲ ಹೆಂಗೆ?
Lordship, ನೀವೇ ಅದನ್ನ ಮೆಮೊ ಕಳಿಸಿ.
ಜಡ್ಜ್ಗಳು ಹೆಂಗೆ ಅಂದ್ರೆ ಇವರು ಎಲ್ಲ ಬರೀ ಡೈರೆಕ್ಟ್ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಜಡ್ಜ್ಗಳಾದ್ರೆ ಪರವಾಗಿಲ್ಲ, ಅಟ್ಲೀಸ್ಟ್ ಏನೋ ಗೊತ್ತಿಲ್ಲ ಅನ್ಬೋದು.
Your lordship, ಇದಕ್ಕೆ ಹರಸಾಹಸ ಮಾಡಿ 6 ತಿಂಗಳ ನಂತರ ನಾವು ಎಕ್ಸ್ಪ್ಲನೇಷನ್
ಸೀನಿಯರ್ ಡಿವಿಷನ್ ಆಗಿ ಆಮೇಲೆ ಪ್ರಮೋಷನ್ ಆಗಿ ಡಿಜೆ ಆಗಿರೋರು, ಇವ್ರದೆಲ್ಲ ಪ್ರಮೋಷನ್ ವಿಡ್ರಾ ಮಾಡ್ಕೋಬೇಕು ನಾವು.
ಪ್ಲೀಸ್ your lordship. Your lordship, accused number 2 criminal appeal 2197 of 24 ಅಲ್ಲಿ ಬಂದಾಗ
ಕನ್ವಿಕ್ಷನ್ ಮಾಡುವಾಗ್ಲೇನೆ ಇಟ್ ಇಸ್ ಎ ಕೇಸ್ ಫಾರ್ 304 part 2 ಅಂತ ಅಂದ್ರೆ ಪರವಾಗಿಲ್ಲ. ಕನ್ವಿಕ್ಷನ್ ಫಾರ್ 302 only.
But sentence has been passed for 304 304 part 2, but proper explanation ಕೊಟ್ಟಿಲ್ಲ.
ಕಳ್ಸೋಣ, ಟ್ರೈನಿಂಗ್ ಕಳ್ಸೋಣ.
And there is no,
ನನ್ಗೇನಿಲ್ಲ, ನಾನು ಬರಿತೀನಿ, ನನ್ಗೇನ್ ಯಾರು ಬೈಕೊಂಡ್ರೆ ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ. ಐ ಆಮ್ ನಾಟ್ ಫಾರ್ ದಿ ಯಾರು ಬೈಕೊಳ್ತಾರೆ ಅಂತಲ್ಲ. ಇಟ್ ಇಸ್ ದಿ ಕ್ವಶನ್ ಆಫ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್.
Please your lordship.
ಮರ್ಯಾದೆ.
Please your lordship.
ಹೌದಿಲ್ವಾ?
ಹೌದು.
ಇನ್ನೊಂದ್ಸರಿ ಬರ್ದೆ ಅಂತ ತಗೊಂಡೋಗಿದ್ರು ಕೋರ್ಟ್ಗೆ, ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ಹೋಗ್ಲಿ ಟ್ರೈನಿಂಗ್ ಹೋಗ್ಲಿ, ಇವ್ರನ್ನೆಲ್ಲ ಏನ್ ಮಾಡೋದು ಇಟ್ಕೊಂಡು? ದೇ ಆರ್ ದಿ ಲಯಬಿಲಿಟೀಸ್ ಟು ದಿ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್, ನಾಟ್ ದಿ ಅಸೆಟ್ಸ್. ಒಂದ್ ಕೇಸ್ ಅಲ್ಲ ರೀ, ಇಲ್ಲಿರೋ ಕೇಸ್ಗಳೆಲ್ಲ ಅವರವೇ ಇವತ್ತು ಎಲ್ಲಾದ್ರಲ್ಲೂ ಹಿಂಗೆ ಮಾಡವ್ರ.
and there is no discussion with regard.
ನೋ ಡಿಸ್ಕಷನ್ ಅಟ್ ಆಲ್. ಏನಕ್ಕೆ ತಂದ್ರಿ 304 part 2ಗೆ? ಎಂತದು ಇಲ್ಲ ಅದ್ರಲ್ಲೂ ಇದ್ರಲ್ಲೂ. ಅಲ್ಲ, ಈವನ್ ಡಿಸ್ಕಷನ್ ಮಾಡಿದ್ರು ಕೂಡ ಅದನ್ನ ಮಾಡಕ್ ಬರಲ್ಲ. ಸೆಂಟೆನ್ಸಿಂಗ್ ಪಾಲಿಸಿಲಿ ಅದ್ ಮಾಡಕ್ ಬರಲ್ಲ. ಕನ್ವಿಕ್ಷನ್ 302 ಹಾಕಿದ ಮೇಲೆ Told, heard the counsel appearing for the appellant and also the counsel appearing for the state. Having perused the records, it discloses that accused was convicted for the offence punishable. Accused persons are convicted for the offence punishable under section 302, read with section 34 of IPC. And while imposing the sentence, the trial court brought the same for 304 part 2 and sentenced to undergo for imprisonment for 7 years. And the same is patently an erroneous order is passed by trial court. The matter requires reconsideration. Admit. The registry is directed to get the records of the trial court and prepare the paper book within 8 weeks from the date of securing the trial court records. In view of observations made by this court, call for explanation from the PO for convicting the accused for the offence 302, read with section 34 and sentencing him for 304 part 2 in the operative portion within 1 week from today, and place the explanation before this court on. ಯಾವ್ದಾರು ಒಂದು ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್. 1 week ಬಿಟ್ಟು. ಅಷ್ಟೇ.
Grateful your lordship.
19(2) ನಾ?
Grateful your lordship.
30. ರಾಘವೇಂದ್ರಕ್ಕೆ.
I appear for respondent.
1 to 5 acquitted. ಏನ್ ಗ್ರೌಂಡ್ ಏನ್ ಮೇಡಮ್?
Trial court has found that no documents have shown for the capacity of the complainant and their family for demand of dowry and
ವಿಟ್ನೆಸ್ ಯಾರು ಹೇಳಿದ್ದಾರೆ ಮೇಡಮ್? What is the evidence of PW2?
Injured ಯಾರಿದ್ದಾರೆ?
ಇಲ್ಲ, injury ಇಲ್ಲ. There is no injury.
No injury.
There is 6 months delay.
So 307 ಅಟ್ರಾಕ್ಟ್ ಆಗುತ್ತೋ ಇಲ್ವೋ? ಆಗಲ್ಲ. ಇದೆ ಸರ್.
307 ಇಂಜುರಿ ಬೇಕಾ ಮೇಡಮ್?
attempt at this, there is no complaint or anything to that effect.
While invoking section 307, only to make out a case that there was an intention to take away the life, even without causing any injury also, that is within the mind, that is inside the mind. ಹೌದಿಲ್ಲ? ಮತ್ತೆ ನೀವು 307 ಅಟ್ರಾಕ್ಟ್ ಆಗಲ್ಲ ಅಂದ್ಬಿಟ್ರಿ. ಫಾರ್ ಎಕ್ಸಾಂಪಲ್, ಕೊಲ್ಬೇಕು ಅಂತಲೇ ತಗೊಂಡ್ ಮಚ್ ತಗೊಂಡ್ ಬೀಸ್ತಾನೆ, ಆಕೆ ತಪ್ಪಿಸ್ಕೊಬಿಡ್ತಾಳೆ ಏಟ್ನ, ಅವಾಗ ಇಂಜುರಿ ಆಗಲ್ಲ. ಬಟ್ ಮೆನ್ಸ್ರಿಯಾ, ದಟ್ ಈಸ್ ಇನ್ಸೈಡ್ ದಿ ಮೈಂಡ್. ವಾಟ್ ಈಸ್ ಇನ್ಸೈಡ್ ಇಸ್ ಮೈಂಡ್ ಶುಡ್ ಬಿ ಲುಕ್ಡ್ ಇನ್ ಟು. Not the question of simple injury or grievous injury or sustained any injury. Henry?
The case of the prosecution is he tried to forcefully make her consume some tablets anta. When she refused to do it, pillow ತಗೊಂಡು ಸ್ಮಾದರ್ ಮಾಡಿ ಸಾಯಿಸಕ್ಕೆ ಅಟೆಂಪ್ಟ್ ಮಾಡದ ಅಂತ. But there is delay of 6 months in filing the complaint itself. There is no explanation to it. Although the incident has happened in the limits of ಇಲ್ಲಿ ವೈಟ್ಫೀಲ್ಡ್ ಲಿಮಿಟ್ಸ್ ಅಲ್ಲಿ.
ಆಯ್ತು, ಸ್ಮಾದರಿಂಗ್ ಮಾಡಕ್ ಟ್ರೈ ಮಾಡಿದಾಗ ಏನಾದ್ರು ಇಂಜುರೀಸ್
ಇಲ್ಲ
ಆಗಿಲ್ಲ?
ಇಲ್ಲ ಏನೂ ಇಲ್ಲ.
ಏನು ಇಲ್ಲ.
ಏನೂ ಇಲ್ಲ.
ಮತ್ತೆ
There is no question of it is not the case of the prosecution that she was admitted to hospital ಎಲ್ಲ ಹೋಗಿದ್ಲು ಅಂತ ಏನೂ ಇಲ್ಲ.
at least
After later
ಕಂಪ್ಲೇಂಟ್ ಕೊಡ್ಲಿಲ್ಲ.
ಇಲ್ಲ ಕಂಪ್ಲೇಂಟ್
ಕೊಡದ ಹೋದ್ರುನು ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಟ್ರೀಟ್ಮೆಂಟ್ ತಗೊಂಡಿದಾರಾ?
ಇಲ್ಲ ತಗೊಂಡಿಲ್ಲ.
ಮತ್ತೆ
it is nobody's case that she went to hospital.
ಹಾ.
Even there is no scratch also. ಆಪರೇಷನ್ ಇತ್ತು ಅದು ಏನೂ ಇಲ್ಲ.
ಯಾರ್ ಮುಂದೆ ಮಾಡಿದ್ರು ಮೇಡಮ್? ಅದನ್ನ ಯಾರು ಹೇಳಿದಾರೆ? PW3 ನ ಯಾರದು 3?
ಅತ್ತೆ ಸೋದರ ಅತ್ತೆ ಇಬ್ಬರಿಗೂನು.
ಅವ್ರು ಬಿಟ್ಟು ಇಂಡಿಪೆಂಡೆಂಟ್ ವಿಟ್ನೆಸ್ ಯಾರಿದ್ದಾರೆ?
ಅವರು ಹೇಳೋದಿಲ್ಲ, ಸೋದರತ್ತೇನು ಹೇಳಲ್ಲ.
ಒಂದ್ ಕೋಟಿ ಕೇಳಿದ ಬಗ್ಗೆ ಯಾರು ಹೇಳ್ತಾರೆ ಮೇಡಮ್? ಬೇರೆ ಇಂಡಿಪೆಂಡೆಂಟ್ ವಿಟ್ನೆಸ್. ಫಸ್ಟ್ ಆಫ್ ಆಲ್ ನಿಮ್ದು ಡಿಲೇ ಇನ್ ಲಾಡ್ಜಿಂಗ್ ದಿ ಕಂಪ್ಲೇಂಟ್, ಹೌದಾ? After thought only sets up the witnesses, that to a relative witnesses. PW3 is a relative of the victim, howda? Maternal aunt. And then independent witness yara helidara? (307) invoke ಮಾಡಿರೋದು ಏನಕ್ಕೆ ಅಂದ್ರೆ accused number 1 attempted to give her sleeping tablets, and when she resisted, tried to commit her murder by pressing her face with a pillow and thereby committed an offense 307 ಅಂತ. ಇಂಜುರೀಸ್ ಇಲ್ಲ, ಇನ್ಸಿಡೆಂಟ್ ಗೆ ಇಮಿಡಿಯೇಟ್ ಆಗಿ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿಲ್ಲ. ಮತ್ತೆ ಪಂಚಾಯತ್ ಯಾರು ಹೇಳಿದ್ರು ಮೇಡಮ್? Victim and father. Omnibus allegations, general in nature.
ಇಬ್ಬರಿಗೂ ಡೈವರ್ಸ್ ಆಗಿದೆ. ಈಗ ಡೈವರ್ಸ್ ತಗೊಳಕ್ಕೋಸ್ಕರ ಅಲಿಗೇಷನ್ ಮಾಡಿದ್ದಾರೆ ಅಂತಾನೆ ಅಡ್ಮಿಷನ್ ಇದೆ.
ಈಗ ಡೈವರ್ಸ್ ಆಯ್ತಾ?
ಇಬ್ಬರಿಗೂ ಡೈವರ್ಸ್ ಆಗಿ ಸಪರೇಟ್ ಆಗಿ ಮದುವೆ ಆಗಿ ಇಬ್ರು ಸಪರೇಟ್ ಆಗಿದ್ದಾರೆ.
ಅದೆಲ್ಲ even madam, relative witness evidence can be relied upon, but only if it is reliable. ಒಂದು. ಎರಡನೇದು, ಅಟ್ಲೀಸ್ಟ್ ಮದುವೆ ಮಾತುಕತೆಗಿದ್ದಾಗ ಯಾರೋ ಒಬ್ರು ಥರ್ಡ್ ಪರ್ಸನ್ ಇದ್ದೇ ಇರ್ತಾರೆ. ಅವ್ರನ್ನ ಯಾರನ್ನಾರು ವಿಚಾರಣೆ ಮಾಡಿದಾರಾ? ಇಲ್ಲ, ಯಾರು ಇಲ್ಲ, ಇಂಡಿಪೆಂಡೆಂಟ್ ವಿಟ್ನೆಸ್ಸೇ ಇಲ್ಲ, ಹೌದಾ? ಮದುವೆ ಮಾಡಕ್ ಸೇಲ್ ಮಾಡಿರ್ಬೋದು ಪ್ರಾಪರ್ಟಿನ. ಯಾವಾಗ ಸೇಲ್ ಮಾಡಿದ್ದದು? ಮದುವೆಗಿಂತ ಮುಂಚೆನಾ? ಪ್ರಾಪರ್ಟಿ ಮಾರಾಟ ಮಾಡಿದ್ದ ಇವನಿಗೆ ಕೊಟ್ಟವನೇನಕ್ಕೆ ಏನಿದೆ?
PW2 is the father, 3 is the aunt, and 5 is the one of the relatives. All relatives.
Who speaks about the marriage talk with regard to the section 3 of DP Act? Only interested witnesses? What about section 4 subsequent to the marriage, if they have demanded ಏನ್ ಮಾಡಿದಾರೆ ಮೇಡಮ್? ಯಾರು ಇಲ್ಲ ಇಂಡಿಪೆಂಡೆಂಟ್ ವಿಟ್ನೆಸ್ ಮತ್ತೆ?
Ask for a house in a good locality in Bangalore also. Is the father who is deposed.
PW 1 to 10 ನಲ್ಲಿ ಯಾರಾದ್ರೂ prior to the marriage whether they have participated except this interested witnesses illa. Subsequent to the marriage also to invoke section 4 any of the witnesses says that in my presence they have demanded the dowry subsequent to the marriage also illa.
All are family members.
Only relying upon family members. Third.
ಫಿಸಿಕಲ್ ಹರಾಸ್ಮೆಂಟ್ ಆಗಿದೆ ಅನ್ನೋದ್ರ ಬಗ್ಗೆ ಏನಿದೆ ಎವಿಡೆನ್ಸ್ ಏನಿದೆ?
ಇಲ್ಲ ಏನು
That stray incident.
ಸ್ಟ್ರೇ ಇನ್ಸಿಡೆಂಟ್.
Stray incident that too 6 months back. ಅಲ್ವಾ? ಮತ್ತೆ ಯಾವುದು ಇಲ್ಲ.
So all allegations are in general and omnibus in nature.
Third, heard the counsel appearing for the state as well as counsel appearing for the respondent. The factual matrix of case of prosecution is that ಆಕೆನ examine ಮಾಡಿದಾರ?
ಮಾಡಿದ್ದಾರೆ.
ಆಕೆನ PW1. That the PW1 is the wife of accused number 1. And accused number 2 is the father-in-law. ಹೌದಾ?
ಹೌದು.
Accused number 3?
Father-in-law sister.
Father-in-law's sister. And accused number 4 is the
daughter.
Daughter of?
Daughter.
Huh?
Daughter of.
ಅದೇ daughter of accused number 2. ಹೌದಾ?
ಹೌದು.
One regarding the proposal. PW1 had then invited the accused to the house and they visited, and soon after their negotiation even after a week there was no response, and hence father of the PW1 asked his sister PW3 to gather information regarding the willingness of the accused, and PW3 said to have then informed the father of the PW1 that the accused had accepted the marriage proposal subject to the condition that parents of the PW1 would give in cash rupees 1 crore and 1.5 kg gold, a house in a good locality in Bangalore. The father of the PW1 is said to have accepted the offer, but he had sought 2 years time to get a house in Bangalore. The second accused is said to have contacted the father of PW1 and expressed that he intends to purchase a site at Whitefield and hence demanded rupees 1 crore. The second and fifth accused are said to have come to the house of PW1, a father of PW1, during September 2011. When the father of PW1 is said to have tendered rupees 1 crore in cash. The father of the PW1 had kept the amount ready by selling immovable properties and borrowing hand loans. PW3 and CW4 and Sri Sangameshwara, CW5 family friend of father of PW1, were also present when the amount was tendered. The accused has demanded that the engagement ceremony be arranged at Chittoor. On 6/10/2011, engagement ceremony was proposed to be held. The invitees were to be given silver Deepada Kamba. The parents of the PW1 had then shown the golden ornaments to the accused, who are said to have objected for the ornaments as antique and expressed to get ornaments with new design and diamond. The father of the PW1 had again borrowed loan and had purchased golden ornaments and had organized engagement ceremony, spending rupees to 10 lakhs. The first accused was given bracelet and diamond ring. On 5/12/2021, the marriage was performed at the MTB Kalyana Mantapa, for which father of PW1 is said to have spent rupees 60 lakhs. First of rooms in Samhita suites were reserved for the invitees. After the marriage, PW1 had gone to the house of accused at Chittoor. The second accused is alleged to have demanded the father of PW1 rupees 10 lakhs for arranging reception at their house. The newly wedded couple had come to Bangalore for living. The first accused is alleged to have demanded that the father of PW1 to give rupees 1 lakh for suitable accommodation. A flat was taken on rent in Samhita Blossom in Mahadevapura. The father of the PW1 is said to have purchased movables for the family by spending rupees 5 lakh. In the apartment, it was only the couple who were living. The PW1 had after come to know that the first accused was alcoholic. The first accused had then started demanding rupees 2 crores for his business and meted out cruelty, both physical and mental, to PW1. The accused number 2 to 5 supported and instigated the first accused to assault PW1. The first accused is alleged to consume alcohol and break the bottle and asked PW1 to remove the glass pieces. The father of the PW1 is said to have tendered rupees 40 lakh every 40,000 every month to the first accused to be invested in chit. A total of rupees 3 crore 60 lakh was tendered, that was later and discovered to have been utilized for the personal use of the first accused. PW1 was beaten up for questioning the first accused regarding misappropriation of money. The PW1 had informed her parents, who had convened panchayat at Bangalore and Chittoor. The accused did not come to Bangalore, and when PW1 and her parents had gone to attend panchayat at Chittoor, the accused are said to have picked up quarrel and used vulgar languages against them. The accused are alleged to have asked PW1 to persuade her mother to sell the building at Channasandra and give them the sale proceeds. That on 4/9/2012, PW1 was threatened of her life if she failed to bring the money. That on 5/9/2012, the first accused alleged to have picked up quarrel on the same issue again. The first accused had deserted PW1 in the apartment and he had returned to Chittoor. The first accused had imposed a condition that only if she gave him the money, he would return to the apartment, which was not possible, and hence the father of PW1 had taken her to his house. The first accused had in the meanwhile vacated the apartment and had received the advance amount. The first accused had obtained another flat in the nearby apartment opposite to the house of accused number 4 and 5. The accused number 1 and 4 used to get together at the house of first accused for consuming alcohol. On 2/12/2012, wife of while PW1 was at home, the first accused alleged to have attempted to force her to consume some pills against her will. When PW1 had refused to swallow the pill, the first accused, using pillow, had tried to suffocate her, but PW1 was somehow capable of pushing the first accused and ran out from the house to rescue herself. This act of the first accused was on the direction of accused number 5. On 11/3/2013 at 9 p.m., the first accused is alleged to have come to the house of the parents of PW1 and threatened PW1 that if she failed to bring the money, she could remain in her parents' house. On 6/6/2013, a case was lodged with the Banshankari police. The first accused is alleged to have taken away 26 to 27 items of golden ornaments from the lockers in City Union Bank and IDB Bank. The accused persons were secured and framed the charge against them, and they plead guilty. They did not plead guilty and claims trial, and hence PW 1 to 10 are examined and document exhibit P1 to 42 are marked. The exhibit D1 to 9 series are also marked. The trial court, having considered the material available on record, comes to the conclusion that there was a delay in lodging the complaint for about 6 months, and that too complaint is filed belatedly, and none of the witnesses speaks about all these charges leveled against the accused, and the witnesses who have been examined are the relative witnesses. No independent witnesses were examined with regard to the conducting of panchayat at Bangalore and Chittoor, and comes to the conclusion that not a case for convicting the accused for the offences which have been invoked against the accused, and hence acquitted the accused 1 to 5. The counsel appearing for the state, that is HCGP, would vehemently contend that the trial court committed an error in acquitting the accused for the offences and not accepting the evidence of PW 1 to 3, though they are the interested witnesses and their evidence is reliable. And fails to take note of even prior to the marriage, demand was made only after the satisfaction. Engagement was done and subsequently performed the marriage by spending huge amount of rupees 60 lakh, and also given money for making accommodation, and all these materials were spoken by the PW 5 and 7, who are the punch witnesses, have supported the case of prosecution, and the evidence of PW 2, father of the victim, and evidence of PW 3, aunt of the victim, and PW 4 is the mother of the victim, and PW 6 is the friend of PW 2, have stated about the demand for dowry by the accused persons. And all this evidence are not considered by the trial court in a proper perspective, and hence it requires admission. Per contra, the counsel appearing for the respondent accused would submit that the alleged allegation of taking away the life and incident was long back, but complaint was given after 6 months, and there was no any material before the court with regard to the prior to the marriage. There was a demand and acceptance, and subsequent to the marriage also demand and acceptance. Nothing is placed on record. The witnesses who have been examined are interested witnesses, and no one independent witnesses are examined for having held the panchayat at Bangalore and also at Chittoor. And those stated that independent witnesses have participated in the panchayat, none of the witnesses examined, and hence trial court rightly taken note of evidence available on record is not sufficient. Having heard the appellant counsel and also the counsel appearing for the respondent, and also considering the material available on record, admittedly PW 1 to 4 are relative witnesses, and PW 6 is also a friend of PW 2, and no independent witnesses were examined before the trial court. In order to invoke section 3 and 4 of DP Act also, there must be a positive evidence before the court that prior to the marriage there was a demand and acceptance, and even subsequent to the marriage also, to invoke section 4 of DP Act, there must be a demand and acceptance, and none of the independent witnesses were examined before the court. The evidence which have been relied upon by only particularly PW 3, and PW 3 is also the maternal aunt of the PW 1, and father and mother have been examined, and none of the independent witnesses are examined. The allegation made in the charge sheet also that panchayat was held at Bangalore and Chittoor, and to that effect also no independent witnesses were examined, and particularly taking into note of factual aspects of the case, there was a delay of 6 months in lodging the complaint. The allegation is also that an attempt was made to take away the life, and an attempt was made to give her sleeping tablets, and when she registered, tried to commit her murder by pressing her face with a pillow, and in order to substantiate the same also, no treatment was taken in the hospital immediately after the incident, that is on 2/12/2012, and there were no any injuries, and in order to substantiate that said attempt was made also, nothing is on record. All these factors were taken note of by the trial court while considering the material on record, and in the absence of consisting evidence, and even though the witnesses PW 1 to 4 and 6 are the relatives and friends of the complaining party and their evidence is also not reliable. And when such being the case, we do not find any ground to admit the appeal and hence no grounds to admit the same. In view of the discussions made above, we pass the following order. Appeal is dismissed.
Vandana PL.
Three or two, they were on bail throughout the trial. The case entirely rests only on circumstantial evidence, my lord. More so, there is absolutely no connectivity.
ಅಲ್ಲ separate appeal ಹಾಕಿದಾರಾ? ನಂಬರ್ ಯಾವುದು ಕೊಡಿ.
A1, 7 and 8.
ತಾವು ಲಾಸ್ಟ್ ಟೈಮ್ ಅದನ್ನ ಕನೆಕ್ಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಹೇಳಿದ್ರು.
ಯಾವ್ದು ಹೇಳಿದ್ವಾ?
ಹೌದು.
ಮಾಡಿಲ್ಲ ಅದು?
ಐ ಬಿಲೀವ್ ಲಾರ್ಡ್ಶಿಪ್ ಸೆಡ್ ಇಟ್. ಅವರೇ ಹೇಳಿದ್ರು ಕೋ-ಅಕ್ಯೂಸ್ ಹಾಕಿದ್ದಾರೆ ಅಂತ. ಆಮೇಲೆ ಅವ್ರ ನಂಬರ್ ಕೊಡಿ ಅಂತ.
ಡಿಲೇ ಕಂಡೌನ್ ಮಾಡಿದೀವಿ ಅಷ್ಟೇ.
ಅಲ್ಲಲ್ಲ, in fact, my lord, they said that there are other
state
appeals.
Submit that co-accused has filed criminal appeal number 2554 of 25. ಅದು ಲಿಸ್ಟ್ ಆಗಿದೆ. ಲಿಸ್ಟ್ ಆಗಿದೆ. ಇನ್ನು ಬೇರೆ ಇದೆಯಾ? 13? ಯಾಕೆ ಇನ್ಸ್ಟಾಲ್ಮೆಂಟ್ ಅಲ್ಲಿ ಹೇಳ್ತೀರಿ? ಕಳಿಸರಲ್ಲಿ ಹೇಳಿದ್ರೆ ಅದು ಲಿಸ್ಟ್ ಆಗ್ತಿತ್ತಲ್ಲ. ಯಾವಾಗ? ಲಾಸ್ಟ್ ಟೈಮ್ ನೀವು ಅಪೀಲ್ ನಂಬರ್ 2554 ಇದೆ ಅಂತ ಹೇಳಿದ್ರಿ, ಅದನ್ನ ಲಿಸ್ಟ್ ಮಾಡಿದ್ವಿ. ಆಯ್ತು ನೋಡಿ. SPP additional SPP would submit that other co-accused have also filed an appeal in criminal appeal 1393 of 25, 1902 of 25. ಯಾರಾಗ್ಲಿ ಮೇಡಮ್, accused ಅಲ್ಲ, co-accused ನಾವು 1902 ನು ಇದೆ.
ಈ ಅಪೀಲ್ ನಲ್ಲಿ ಇದೆ 4 accused number. 4, 5 and 6, my lord, is this appeal.
ಯಾವುದು?
446.
ಅದು 146. 456.
ಹೌದು, 456. ಇವತ್ತಿರೋ ಅಪೀಲು
2554 ಯಾರ್ದು?
A2 and A3.
A2 and A3 ಹೌದಾ? A1 ಅಪೀಲ್ ಯಾವುದು?
A1, A7 and A8.
ಅವ್ರೀಗ ಬೇರೆ ಹಾಕಿದ್ದಾರೆ.
ಆಗ್ಬೋದು.
And hence list those two cases also along with these petitions.
ಅದು ರಾಂಗ್ ಇದೆ ಮೇಡಮ್. ನೀವು ಹೇಳ್ತಾರದು 1902 ಎಲ್ಲ ತಪ್ಪಿದೆ, ಬೇರೆ ಇದೆ.
ಅಲ್ಲ ಮೇಲೆ
ಅಲ್ಲಿ ಒಂದು ಫ್ರಂಟ್ ಆಫೀಸ್ ಇವರು ಎಲ್ಲರೂ ಕನ್ವಿಕ್ಟೆಡ್ ಇದ್ದಾರೆ. ಈಗ 5 ಜನ ಹಾಕಿದ್ದಾರೆ, ಇನ್ನು 3 ಜನ ಹಾಕಿಲ್ಲ.
ಈಗ ಹಾಕಿದಾರಂತಲ್ಲ, ಈಗ ನಂಬರ್ ಕೊಟ್ಟರು ಮೇಡಮ್. ಅದರ್ 2 ಅಪೀಲ್ಸ್ ಯಾರು ಫೈಲ್ ಮಾಡೋದು ಮೇಡಮ್?
ಅಲ್ಲ, ಅದು ರಶ್ಮಿ ಮೇಡಮ್ ಹೇಳಿದ್ದನು ಐ ಥಿಂಕ್ ಮೈ ಲಾರ್ಡ್ ಮೈ ಕಲೀಗ್ಸ್ ಹ್ಯಾವ್ ಚೆಕ್ಡ್ ಇಟ್.
A1 A7
ಅಲ್ಲ, ತಪ್ಪಿದೆಯಾ ನಂಬರ್ಸ್ ಅವ್ರು ಕರೆಕ್ಟ್ ಆಗಿ ತಿಳ್ಕೊಂಡು ಹೇಳಿ ಮೈ ಲಾರ್ಡ್. ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ರೆಕಾರ್ಡ್ಸ್ ಇಟ್ ಇನ್ ದ ಆರ್ಡರ್ ಶೀಟ್. ಸಮ್ ಆಫ್ ದ ಮ್ಯಾಟರ್ ವಿಲ್ ಬಿ ಲಿಸ್ಟೆಡ್.
ಫ್ರಂಟ್ ಆಫೀಸ್ ಅಂತ ಇರುತ್ತೆ, ಅಲ್ಲಿ ನಂಬರ್
2554 ಇದೆ. A2 ಇದೆ, ದಟ್ಸ್ ಕರೆಕ್ಟ್.
ಕೆಲವರೆಲ್ಲ ಜೈಲ ಫಿಲ್ಮ್ ಹಾಕ್ತಿರ್ತಾರೆ.
ಮೇಡಮ್ ಇಲ್ಲಿ ಚೆಕ್ ಮಾಡ್ಬೋದಾ
ಮೇಡಮ್? ನೀವೇನ್ ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ, ಈಗ ಒನ್ ಆಫ್ ದಿ ಅಕ್ಯೂಸ್ಡ್ co-accused ಫೈಲ್ಸ್ ಎನಿ ಅಪೀಲ್ ಅಂತ ಅಂದ್ರೆ ನಿಮ್ಗೆ ಆಲ್ ಡೀಟೇಲ್ಸ್ ವಿಲ್ ಗೆಟ್ ಇನ್ ದಿ ಪ್ರಿಸನ್. ಹೌದಾ? ಫ್ರಂಟ್ ಆಫೀಸ್ ಇರುತ್ತೆ ಪ್ರಿಸನ್ ಅಲ್ಲಿ, ಅಲ್ಲಿ ಫುಲ್ ಡೀಟೇಲ್ಸ್ ಇರುತ್ತೆ. ಯಾವ ಕೇಸಲ್ಲಿ ಯಾರ್ಯಾರು ಅಕ್ಯೂಸ್ಡ್ ಅಂತ ಹೇಳಿ ಅವ್ರು ಹಾಕಿದಾರ ಇಲ್ಲ ಅಂತ ನಿಮ್ಗೆ ಡೀಟೇಲ್ಸ್ ತಗೊಂಡ್ರೆ ಸಿಗ್ತದೆ ಎಲ್ಲ. ಮತ್ ನೀವು ಈ ನಂಬರ್ ಕೊಟ್ಟರೆ ಕರೆಕ್ಟ್ ಇಲ್ಲ ಅಂತಾರಲ್ಲ ಅವರು. ನೋಡಿ ಮೇಡಮ್, 1395, 1393 of 25, 1902 of 25, whether it is arised out of
5029 account
5029 of 21 ಅಂತ ನೋಡಿ.
SC could be the same, my lord, but it appears that is from Madhugiri.
ಮಧುಗಿರಿನ
ಈಗ ಚೆಕ್ ಮಾಡಿದ್ದಾರೆ.
ಅವ್ರು ಹೇಳ್ತಾರದ
ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು ಮಧುಗಿರಿ SC.
ಇದು ಶಿವಮೊಗ್ಗ.
ಇದು ಶಿವಮೊಗ್ಗ.
228.
I am given to say there are only two appeals, that is the present appeal in which I am representing, ಇನ್ನೊಂದು 2554 which is listed today.
ಎಲ್ಲ ಅಕ್ಯೂಸ್ಡ್ ಇದ್ದಾರೆ, ಎಲ್ಲರಿಗೂ ಕನ್ವಿಕ್ಷನ್ ಆಗಿದೆ.
ಹೌದೌದು.
ಬೇರೆಯವ್ರು ಹಾಕಿರ್ತಾರೆ ನೋಡಿ.
ಹಾಕಿರ್ತಾರೆ ಒಂದೊಂದ್ಸಲ my lord, ಕೆಲವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ ಅಂದ್ರೆ ಧರ್ಮದ ಅಪೀಲ್ ಬರ್ಲಿ ಅಂತ ಕಾಯ್ತಾ ಇರ್ತಾರೆ. ಧರ್ಮದ ಅಪೀಲು ಅಂತ ಒಂದಿದೆ my lord ಅಲ್ಲಿ. ಧರ್ಮದ ಅಪೀಲು ಅಂತ.
ಅದಕ್ಕೆ ಹೇಳಿದ್ದು ಫ್ರಂಟ್ ಆಫೀಸ್ ಅಲ್ಲಿ ಇರುತ್ತೆಲ್ಲ.
ಹೌದು. ಯಾರು ಲಾಯರ್ಸ್ ಬರ್ಲಿಲ್ಲ.
ಧರ್ಮದ ಅಪೀಲ್ ಅಂದ್ರೆ ಜೈಲ್ ಅಪೀಲ್.
ಜೈಲ್ ಅಪೀಲ್. ಜೈಲ್ ಅಪೀಲ್.
13 ಆಫ್ 83 23 ಬರೋದ್ ಸಾಧ್ಯ ಇಲ್ಲ ಮೇಡಮ್. ಇದು ಜಡ್ಜ್ಮೆಂಟ್ ಬೇಡ, ಅದು ಜಡ್ಜ್ಮೆಂಟ್ ಆಗಿರೋದು 25ರಲ್ಲಿ ಸೆಪ್ಟೆಂಬರ್ ಅಷ್ಟೇನಾ? ಬೇರೆ ಅಪೀಲ್ ಯಾವ್ದು ಇಲ್ವಾ? ಮಧುಗಿರಿದ್ ಬರಲ್ಲ. ಈಗ ನಂಬರ್ ಕೊಟ್ರದ 22 ಅವ್ರು ಕೊಟ್ಟಿಲ್ಲ ಮೇಡಮ್, 25 ಕೊಟ್ಟವ್ರೆ ನಂಬರ್.
The judgment is dated by 27 September 2025.
ಆ ನಂಬರ್ ತೋರಿಸ್ತಾ ಇಲ್ಲ. ಮಧ್ಯಾಹ್ನ ಹೇಳಿ ಮೇಡಮ್. ಇವನ್ ನೀವು ಪ್ರಿಸನ್ ಅಲ್ಲೇ ಯು ಕ್ಯಾನ್ ಅಸರ್ಟೈನ್, ಅಲ್ಲಿ ಇರುತ್ತೆ. ಮಧ್ಯಾಹ್ನ ಕೊಡ್ತೀವಿ ಡೇಟ್. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲ, ಶಾರ್ಟ್ ಡೇಟ್ ಅಲ್ಲೇ ಕೊಡ್ತೀವಿ.
ಆಗ್ಬೋದು. ಸೋ ಗ್ರೇಟ್.
ಕರೆಕ್ಟ್ ನಂಬರ್ ಕೊಡಿ. ಒಂದು ಲಿಸ್ಟ್, ಒಂದು ಡೇಟ್ ಕೊಟ್ಬಿಡ್ತೀವಿ ಈಗ್ಲೇನೆ. ಅವ್ರು ನೋಡೋಣ. ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಕೊಡಿ. ನಂಬರ್ ಮಾತ್ರ ಚೇಂಜ್ ಮಾಡ್ಕೊಳ್ಳಿ ಯಾವ್ದು ಅಂತ ಏನಾರು ಇದ್ರೆ.
22
19 ನಂಬರ್ ಒಂದು ಹಾಕೋಕ್ಕಿಂತ ಮುಂಚೆ ಕ್ರಾಸ್ ಚೆಕ್ ಮಾಡ್ಕೊಳ್ಳಿ. ನೆಕ್ಸ್ಟ್
all these matters have become infructuous for the reason on 28/1/2026 not honorable apex court has directed the trial court not to go on with the trial not in these matters. May I just not pass on the latest orders not 28/1/26
ಓ ಟ್ರಯಲ್ ಗ
ಟ್ರಯಲ್ ಅಲ್ಲಿ
ಹಾಗಾದ್ರೆ ಬರೋದಿಲ್ಲ.
28/1 not this is the order.
ಇವ್ರು ಚಾಲೆಂಜ್ ಮಾಡಿರೋದೇನೆ
ಕಾಗ್ನಿಜೆನ್ಸ್, FIR, ಚಾರ್ಜ್ ಶೀಟ್,
FIR ಇವೆಲ್ಲ ಮಾಡಿ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ. ಎಲ್ಲ ಹೋಯ್ತಲ್ಲ,
ಎಲ್ಲ ಹೋಯ್ತು. ಅದಕ್ಕೆ ಇನ್ಫ್ರಕ್ಚರ್ಸ್ ಆಗಿದೆ. ಸುಮ್ಮನೆ ಪೆಂಡಿಂಗ್ ಇಟ್ಕೊಂಡು 2021 not one more thing, all this out of 7 not 4 petitions were already dismissed by the learned single judge. Not we then did not know that this matter should come before the division bench. On merits it was heard and dismissed. Not again my learned
single judge ಏನ್ ಮಾಡಿದಾರೆ,
ಇದನ್ನ ಡಿಸ್ಮಿಸ್ ಮಾಡೋದು. ಈ 4 petitions,
4 petitions
ಇದು ಇವತ್ತು ಬಂದಿರೋದ್ರೆ 4 ಡಿಸ್ಮಿಸ್ ಆಯ್ತು. Then my learned friend filed
4 ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ,
ಡಿಸ್ಮಿಸ್ ಆಗಿತ್ತು. Then they filed a review saying no it should have been heard by the division bench. ಮತ್ತೆ ಹಂಗಾಗಿ ರಿವ್ಯೂ ಆಲ್ ಆಗಿ ಮತ್ತೆ ತಿರ್ಗಾ ಇಲ್ಲಿ ಬಂದಿದೆ
ರಿವ್ಯೂ ಆಗಿ.
And next court last week I said let the trial go on.
ಏನ್ರಿ ಲಾಸ್ಟ್ ಟೈಮ್ ಅಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ನವರು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಡೈರೆಕ್ಷನ್ಸ್ ಕೊಟ್ಟವ್ರಂತಲ್ಲ, ನೀವು ಕಾಗ್ನಿಜೆನ್ಸ್ ಹೆಂಗ್ ಚಾರ್ಜ್ ಮಾಡ್ತೀರಿ?
ಇದ್ರ ಬೇಸಿಸ್ ಮೇಲೆ ಮೊನ್ನೆ ತಾವು ಒಬ್ರು ಯಾರಿಗೋ ಬೇಲ್ ಕೊಟ್ರಿ.
ಲರ್ನೆಡ್ ASC ಅದು ಇದರದ್ದು ಕೇಸ.
ಹೌದು, ಸೇಮ್ ಕೇಸ್.
ಬೇಲ್ ಆಯ್ತಲ್ಲ.
ಹೌದು ಸ್ವಾಮಿ, ಸೇಮ್ ಕೇಸ್.
Submit that there are 5 protected witnesses which are yet to be examined. Taking note of the above, we issue a direction to the trial court to
prioritize the
examination of 5 protected witnesses and
do the needful within a period of 4 weeks from date of receipt.
Within a period of 4 weeks from the date of receipt of a copy of this order antide.
That was for bail, your lordship. That was for bail.
ಏನು ಬೇಲ್ ಒಳಗೆ
ಆಯ್ತ್ರಿ, ಬೇಲ್ ಅಲ್ಲುವೆ ಏನ್ ಮಾಡಿದಾರೆ ಹೇಳಿ? ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ನೀವು ಟ್ರಯಲ್ ಮಾಡಿ ಆ ಪ್ರೊಟೆಕ್ಟೆಡ್ ವಿಟ್ನೆಸ್ ನ ರೆಕಾರ್ಡ್ ಮಾಡಿ ಅಂತ ಹೇಳವ್ರೆ. ನಿಮ್ಮ ಈ ಅಪೀಲ್ ಏನಕ್ಕೆ ಫೈಲ್ ಮಾಡಿರೋದು?
For quashing, your lordship.
ಮತ್ತೆ ಕ್ವಾಶಿಂಗ್ ಈಗ ಮಾಡಕ್ ಬರುತ್ತೆ ಸುಪ್ರೀಂ
ಅಲ್ಲ, ಬೇಲೇ ಆಗಿಲ್ಲ ಅವ್ರಿಗೆ ಅಪ್ ಟು ಸುಪ್ರೀಂ ಕೋರ್ಟ್
ಮೇಲೆ.
I seek instructions from senior lordship.
But I am sorry, 5 years now it is pending. I have been repeatedly moving.
ಇಟ್ಕೊಂಡಿದ್ದೀರಿ ನೀವು,
ಸುಮ್ಮನೆ ಪೆಂಡಿಂಗ್ ಇಡ್ತಾರೆ.
It was restored in the year 2023, your lordship. It was filed in the year 2021, your lordship. Again it was disposed and later it was reviewed by the single bench of this honorable court, your lordship.
ಅಲ್ಲ ರೀ, ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿರೋದು ಏನ್ರಿ? ಟೇಕಿಂಗ್ ಆಫ್ ಕಾಗ್ನಿಜೆನ್ಸ್ ಇವೆಲ್ಲ ಮಾಡಿದಿರಿ. ಈಗ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ನವರು ಟ್ರಯಲ್ ನಡೆಸಿ ಅಂತ ಬರ್ದವ್ರೆ.
I'll seek
Whether these
instructions.
petitions are survived.
It will not even survive.
Survives for consideration.
It will maybe taken up on Monday, Your Lordship. Senior is not here, Your Lordship.
ಈಗ
I won't seek any adjournment on Monday, Your Lordship.
ಇದು ಯಾವ ಇದ್ರ ಕೇಸ?
DJL
DJL, both matters, Your Lordship.
ಆಯ್ತ್ರಿ ಟ್ರಯಲ್ ನೀವೇ ಮೊನ್ನೆ ನಮ್ಮ
Please,
ನಮ್ಮ
Lordship.
ಹತ್ರ ಒಂದು ಬೇಲ್ ಆರ್ಡರ್
Please,
ತಗೊಂಡ್ರಿ.
Lordship.
No, they own,
Maybe taken up on Monday, Lordship. That day may be disposed of. Your
they only cite this order and take bail. ಈಗ ಬೇರೆ ನಾನು ಕೊಟ್ರೆ ಇದನ್ನ I don't understand.
ಅಲ್ಲಿ ಹೋಗಿ ಟ್ರಯಲ್ ನಡೆಸ್ಕೊಳ್ಳೋದು ಅಷ್ಟೇ.
ಅಷ್ಟೇ.
Please, Lordship. Monday.
ಆಮೇಲೆ not now the order framing charge is also called in question. ಅದೊಂದು 4 ರಿಟ್ ಪಿಟಿಷನ್ ಇದೆ.
ಅದು ಇದೆ ನೋಡ್ರಿ.
So these are order passed by the apex
Lordship
court.
may dispose out on Monday, Your Lordship. Just seek instruction.
Counsel appearing for the respondent.
ನಾಳೆ ನಾಡಿದ್ದು ಹಾಕೊಂಬ.
Appearing for the NIA.
On one hand, the Supreme Court directed the Telugu to examine priority. ಇಲ್ಲಿ ನಾವು
ಕಾಗ್ನಿಜೆನ್ಸ್ ಅದನ್ನೇ ನಾನು ಹೇಳ್ತಿರೋದು. ಅದನ್ನೇ ಕಾಗ್ನಿಜೆನ್ಸ್ ಬರ್ತದೆ ಈಗ. ಕೇಸ್ ಟ್ರಯಲ್ ಅಂದ್ಮೇಲೆ ಕಾಗ್ನಿಜೆನ್ಸ್ ಮೇಲೆ ಏನು
ಬರೋದೇ ಇಲ್ಲ. not unnecessarily not these things are not kept pending not by Melanie friend.
ಅದೇ ಹೇಳಿದ್ದು.
I will request on Monday, Lordship.
ಅಲ್ಲ ಇನ್ನೊಂದಿದೆ.
That
not
day,
one more submission.
Your senior only relied upon the orders passed by the apex court.
Please, Lordship.
And this court also on the ground of parity granted the bail in
Please,
favor
Lordship.
of accused number 16.
Please,
What I
Lordship.
can recollect my
Please,
memory.
On Monday, Lordship.
16, 15, 20, 21 bail ಕೊಟ್ಟಿದ್ರು.
Correct.
ಬೇರೆಯವ್ರಿಗೆಲ್ಲ ಇಲ್ಲ ಪ್ರಯಾರಿಟೈಸ್ ಮಾಡಿ ಅದನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರು. ಈಗ ಅದು ಈಗ ವಿಟ್ನೆಸ್ ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿ ಅಂತ ಡೈರೆಕ್ಷನ್ಸ್ ಕೊಟ್ಟಾರ ಟ್ರಯಲ್ ಕೋರ್ಟ್ಗೆ. ಹಂಗಿದ್ದಾಗ ನಿಮ್ ಕಾಗ್ನಿಜೆನ್ಸ್ ಇವೆಲ್ಲ ನಾವು
ನೋಡಕ್ಕೆ ಬರೋದಿಲ್ಲ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅರ್ಥ ಆಯ್ತು. ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇಲ್ಲ ಸ್ವಾಮಿ ಸೀನಿಯರ್ ಇಂದ.
ಅಲ್ಲ they know they are aware of this order. They have only cited but not this order for this order.
Order ಇದೆ ಇಲ್ಲ ಅಂತಿಲ್ಲ
But
ಸ್ವಾಮಿ.
they can't behave like this.
Criminal appeal 582 of 21 ಇದೇ ಕೇಸಿಗೆ ಸಂಬಂಧಪಟ್ಟಿದ್ದ.
585.
ಹೌದು
582 of 2021.
ಹೌದು.
Please, Lordship. That is it was for bail, Lordship.
ಇವರೇ ಅಕ್ಯೂಸ್ ಗಳಕ್ಕೆ
ಎಲ್ಲ ಇವ್ರೇನ್ ಮಾಡ್ತಾರೆ, ಅಲ್ಲೊಬ್ರು ಅಕ್ಯೂಸ್ಡ್ ಆಗ್ತಾರೆ, ಇಲ್ಲೊಬ್ರು ಆಗ್ತಾರೆ.
ಅಲ್ಲ ಇವ್ರು ಎಷ್ಟನೇ ಅಕ್ಯೂಸ್ ಇವರೆಲ್ಲ? ಫಸ್ಟ್ ಒನ್ ಅಲ್ಲಿ ಎಷ್ಟನೇ ಅಕ್ಯೂಸ್ ಇವನು?
ಮುಜಾಮಿಲ್ ಪಾಷಾ A1.
ಮೊಹಮ್ಮದ್ ತಾಹಿರ್
In one case he was
ಫಸ್ಟ್ ಒನ್ WP ನಲ್ಲಿ.
In one case he was A1 and in another case A2, Your Lordship.
A1 in one case, A2 in cases.
In case
A1
Not A1 in
152 of 21 special, Your Lordship.
DJL, A2 in KJL.
A2 is
He
in
filed single
KJL
writ petition seeking quashing of both a chart ಮಾಡಿದ್ದಾರೆ. But I prepared a chart not ಇದೆ ಎಲ್ಲ writ petition ದು ಒಂದು ಯಾರ್ಯಾರು ಏನೇನ್ ಪ್ರೇಯರ್ ಕೇಳಿದ್ರೆ ಏನ್ ರ್ಯಾಂಕ್ ಅಂತ ಒಂದು ಚಾರ್ಟ್.
ಆಮೇಲೆ ಕಂಪ್ಲೀಟ್ ಸೆಕೆಂಡ್ ಸೆಟ್ ನಾಟ್ ಫೈಲ್ಡ್ ಬೈ ದಿ ಕೌನ್ಸಿಲ್ ಫಾರ್ ಪಿಟಿಷನರ್ 21 ಮ್ಯಾಟರ್ ಅಲ್ಲಿ.
We have filed, Your Lordship, on
ರೆಕ್ಟಿಫಿಕೇಶನ್ ಆಫ್ ಆಫೀಸ್ ಸಬ್ಜೆಕ್ಟ್.
That may not arise maladi ಎಲ್ಲ ಇನ್ಫ್ರಕ್ಚರ್ಸ್ ಆಗಿದೆ ಅದು.
ನಾವು ಆರ್ಡರ್ ಮಾಡ್ತೀವಿ ಇನ್ಫ್ರಕ್ಚರ್ಸ್ ಅಂತ. ಇನ್ ಕೇಸ್ ಇಫ್ ನೆಸೆಸರಿ ಯು ಕ್ಯಾನ್ ರಿಕಾಲ್ ದಿ ಆರ್ಡರ್.
ಆಮೇಲೆ ಆರ್ಡರ್ ಆನ್ ಚಾರ್ಜ್ ಕೂಡ ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕಿದ್ದಾರೆ.
testing on Monday, Lordship. Monday may be disposed of, Lordship. Please, Your Lordship. Senior instruction ತಗೊಂಡಿಲ್ಲ ಸ್ವಾಮಿ.
ಇಂದ ಆರ್ಡರ್ ನೀವೇ
ಅವರೇ ಸೈಟ್ ಮಾಡ್ತಾರೆ. Not for obtaining bail they cite it for their benefit.
Lordship, that was aware, Your Lordship, but
my request is not Your Lordship kindly
Monday may
pass
be
orders if
disposed
they
of,
want.
Lordship.
Our
May be
review
disposed
ಪರ್ಯೂ
on
ಎಲ್ಲ
Monday,
ಹಾಕೊಂಡು ಬರ್ತಾನೆ
Lordship.
ಇದ್ದಾರೆ, ಬರ್ಲಿ ಅವ್ರು ಏನಾದ್ರು ಇದ್ರೆ.
Counsel appearing for the respondent would submit that the apex court already void order dated 28/1/26 in the same case directed to prioritize the examination of the 5 protected witnesses and do the needful within a period of 4 weeks from the date of receipt of copy of this order, and date is also listed on 18/3/26. And when this order was passed, the trial court only to record the evidence of witnesses, and at this stage the counsel appearing for the petitioner cannot seek for any order of quashing of taking of cognizance and framing of charge, and the writ petitions become infructuous. The counsel appearing for the petitioner seeks time on the ground that senior counsel is not in station, and hence this matter day after tomorrow.
Monday, Lordship.
ಬೇಡ Monday Tuesday trial ಇದೆ.
3 days.
Tomorrow day after. ಇನ್ನೊಂದು 4 ಇದೆ ಸ್ವಾಮಿ ಇದ್ರದ್ದು ಜೊತೆದೆ.
ಏನಿದೆ ಹೇಳಿ ಅದು.
ನಂಬರ್ ಐ ಹ್ಯಾಂಡ್ ಓವರ್ ರೈಟ್ ನೌ.
ಕೊಡಿ ಅದು ಯಾವ್ದಾರು ಇದ್ರೆ
ಪ್ಲೀಸ್
ಅದನ್ನ ಹಾಕ್ಸೋಣ.
ಪ್ಲೀಸ್
ಇದನ್ನ ಹಾಕ್ಸೋಣ ಅದ್ರ ಜೊತೆಗೆ
ಹಾಕ್ಸ್ಬೋದು. ಯಾಕಂದ್ರೆ ಸುಮ್ಮನೆ ಅವ್ರು ಅದೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾರೆ ಎಲ್ಲ.
Counsel appearing for the respondent would submit that other connected matters also to be listed along with this petition. ಲಿಸ್ಟ್ ಕೊಟ್ರೆ ಮೇಡಮ್ ಅದನ್ನ ಹಾಕಿ.
ಈಗಲೇ ಕೊಡ್ತೇನೆ. ಆಯ್ತು ಏನು ಎಲ್ಲಿದ್ರೆ ಹಾಕಿದ್ರೆ ಎಲ್ಲ ಬರಲಿ ಮಾಡ್ಕೊಡಿ.
Much obliged, Your Lordship.
ಅವ್ರಿಗೂ ಕೊಟ್ಬಿಡಿ, ಅದೇನ್ ಲಿಸ್ಟ್ ನೀವು ಕೊಡ್ತೀರದ್ನ ಹೇಳಿ.
Please, ಕೊಡೋ. ಕೊಡ್ತೀನಿ.
ನಾವು ನಾಳೆ ಬಂದಿಲ್ಲ ನಮ್ಗೆ ಇದು ಕೊಟ್ಟೇ ಇಲ್ಲ ಲಿಸ್ಟ್ ಅನ್ನೋದು ಬೇಡ.
ಅಲ್ಲ ಅವ್ರು ಮಾಡೋ ಕೆಲಸ ನಾವ್ ಮಾಡ್ತಾ ಇದೀವಿ, ಪಿಟಿಷನರ್ ಮಾಡ್ಬೇಕು, ನಾವೆಲ್ಲ ಮಾಡ್ತಾ ಇದೀವಿ.
ಆಯ್ತು, ನೆಕ್ಸ್ಟ್
Please.
Government Advocate. You Anil Kumar.
Such challenging the
respondent.
impugned order at annexure A, wherein the tribunal has directed the state to pay the.
ಲಾಸ್ಟ್ ಟೈಮ್ ಯಾರು AG ಬರ್ತಾರೆ ಅಂತ ಟೈಮ್ ತಗೊಂಡ್ರಲ್ರಿ?
ನನ್ಗೆ ಹೇಳಿದ್ದಾರೆ
ಮತ್ತೆ why you have taken time in the earlier occasion?
ಪ್ಲೀಸ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅವ್ರು ಹೇಳಿದ್ರು
ಟೈಮ್ ಬೇಕಿತ್ತು ಅಂತ ತಗೊಂಡ್ರ? ಸುಳ್ಳು ಹೇಳಿದ್ರ ಅಥವಾ ಏನು?
ಇಲ್ಲ ಮತ್ತೆ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅವ್ರು ಹೇಳಿದ್ರು.
ಹೇಳಿ.
Your Lordship, based on the inquiry, the respondents were the PDO, working as PDO in the Kodigelli Grama Panchayat in 2011, Your Lordship. Wherein they were assigned with the making the list of beneficiary list for Ashraya scheme.
Ashraya scheme.
Ashraya scheme. And during that period, without those people who were not eligible, and people who were not eligible, out the list they had
prepared anta.
Provisional list was prepared, including ineligible candidates out of the village also. And as per the direction, it was only for the ladies, a scheme. But in that part,
ಆ ಸ್ಕೀಮ್ ಅಲ್ಲಿ ಬರೀ ಲೇಡೀಸ್ ಗೆ ಮಾತ್ರ ಕೊಡಬೇಕು ಅಂತ ಇತ್ತಾ?
But that the defense of the respondent was that that list was not acted upon.
Which list?
The list which they had prepared,
they have prepared,
were not acted upon. Hakku patra enu kottirlilla anta. But the inquiry finding is that there was a dereliction of duty, and annual increment of 4 increments were.
But whether they dispute the preparation of preliminary list,
Your Lordship,
preliminary list na ಅವ್ರು ಪ್ರಿಪೇರ್ ಮಾಡಿದ್ದನ್ನ ಅವ್ರು ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡ್ತಾರಾ ಇಲ್ಲ?
ಇಲ್ಲ, they have agreed, Your Lordship. Page 231, Your Lordship.
ಆಯ್ತು. ಈ ಪ್ರಿಪೇರ್ ಮಾಡಕ್ಕಿಂತ ಮುಂಚೆನೆ ಈ ಡೈರೆಕ್ಷನ್ಸ್ ಎಲ್ಲ ಇತ್ತಾ? ಏನ್ ಕಂಪ್ಲೈ ಮಾಡ್ಬೇಕು ಅಂತ
ಇತ್ತು, Your Lordship.
ಇತ್ತು. ಅದ್ಯಾವ್ದು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಎಕ್ಸಿಬಿಟ್ಸ್ ತೋರ್ಸಿ, ಲಿಸ್ಟ್ ತೋರ್ಸಿ ಫಸ್ಟ್, ಪ್ರಾವಿಷನಲ್ ಲಿಸ್ಟ್. Whether it is acted upon or not, that is second.
It is not acted upon anta.
ಆಯ್ತು. But whether they have prepared that list?
Please, Your Lordship, they have prepared
provisional list prepared.
Prepared, Your Lordship.
On what
prepared
date?
As per
annexure ಯಾವ್ದು ಮೇಡಮ್?
annexure A13, Your Lordship. That is the
A13
inquiry report, wherein they have stated.
Inquiry report ಬೇಡ ಮೇಡಮ್, ಎನ್ಕ್ವೈರಿ ಆಮೇಲೆ. ಎನ್ಕ್ವೈರಿ ಎಲ್ಲ ಯಾವಾಗ ಬರೋದು ಮೇಡಮ್? ಫಸ್ಟ್ ದೇ ಹ್ಯಾವ್ ಪ್ರಿಪೇರ್ ದಿ ಪ್ರಾವಿಷನಲ್ ಲಿಸ್ಟ್ ಅಂತ ಇದೆಯಲ್ಲ, ಅದನ್ನ ಫಸ್ಟ್ ಪಾಯಿಂಟ್ ಔಟ್ ಮಾಡಿ ನೀವು. ನೀವ್ಯಾರು ಹೇಳ್ರಿ?
Page number 141.
141.
That is the charge memo which is issued to me. Charge memo ಅಲ್ಲಿ ಚಾರ್ಜ್ ಏನಿದೆ ಅಂತ ಹೇಳಿ ಓದ್ತೀನಿ. 142 ಅಲ್ಲಿ ಕಾಣ್ತದೆ. ಅನುಬಂಧ ಒಂದು ದೋಷಾರೋಪಣೆ 142 ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ 3ನೇ ಲೈನ್. ಆಶ್ರಯ ಯೋಜನೆ ಅಡಿಯಲ್ಲಿ ನಿವೇಶನಗಳನ್ನು ಮಂಜೂರು ಮಾಡುವ ಸಂದರ್ಭದಲ್ಲಿ ಆಶ್ರಯ ಯೋಜನೆ ಅಡಿಯಲ್ಲಿ ನಿವೇಶನಗಳನ್ನು ಮಂಜೂರು ಮಾಡುವ ಸಂದರ್ಭದಲ್ಲಿ ಗ್ರಾಮಕ್ಕೆ ಸೇರಿದಲ್ಲದ ವ್ಯಕ್ತಿಗಳನ್ನು ಸಹ ಫಲಾನುಭವಿಗಳ ಪಟ್ಟಿಯಲ್ಲಿ ಸೇರಿಸಿ ಸರ್ಕಾರದ ನಿಯಮಗಳನ್ನು ಉಲ್ಲಂಘಿಸಿ ಹಣ ತಗೊಂಡು ಗ್ರಾಮಸ್ಥರ ಇಲ್ಲೇ ಇರೋರು.
ಅರ್ಥ ಆಯ್ತ್ರಿ, ಐನೋ ಕನ್ನಡ ಆಯ್ತಾ? ಬಟ್ ನಾವ್ ಕೇಳ್ತಾ ಇರೋದು ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇದೆ ಫಸ್ಟ್ ತೋರ್ಸಿ ಅಂತ, ಅದೇ ಮೇನ್. ನೀವು ಲಿಸ್ಟ್ ಮಾಡಿದ್ರ ಇಲ್ಲ?
ಲಿಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ, ಬಟ್ ಆದ್ರೆ ಅದು ನಾವು ಮಾಡಿದ್ದಲ್ಲ. ಗ್ರಾಮ ಸಭೆನಲ್ಲಿ ಇಟ್ಟು ಅಲ್ಲಿ ಯಾರ್ಯಾರು ಇದ್ರೋ ಗ್ರಾಮ ಅಧ್ಯಕ್ಷರು ಎಲ್ಲಾರು ಯಾರ್ಯಾರ್ದು ಹೆಸರು ಹೇಳಿದಿರೋ ಅದನ್ನ ಲಿಸ್ಟ್ ಮಾಡಿದೀವಿ. ಅದನ್ನ ಮಾಡಿ ನಾವು ಫಾರ್ವರ್ಡ್ ಮಾಡಿದೀವಿ.
ಯು ಆರ್ ದಿ PDO, ಹೌದಿಲ್ಲ? ರೆಸ್ಪಾನ್ಸಿಬಿಲಿಟಿ ಯಾರ ಮೇಲೆ ಬರೋದು? PDO ಮೇಲಲ್ವಾ?
ಅದನ್ನ ನಾವು ಕಳ್ಸಿಲ್ಲ, ಅಂದ್ರೆ ಅದನ್ನ ನಾವು ಮಂಜೂರ್ ಮಾಡಿಲ್ಲ ಅಲ್ಲಿ.
ಮಂಜೂರ್ ಮಾಡೋದ್ ಬೇಡ್ರಿ, ನೀವು ಪ್ರಿಪೇರ್ ಮಾಡಿದಿರ ಲಿಸ್ಟ್ ನ?
Yes, my lords, that
ಮಾಡಿ
list was,
ಗವರ್ಮೆಂಟ್ ಕಳ್ಸಿದಿರಾ?
my lords, that was rejected, my lords.
ರಿಜೆಕ್ಟ್ ಆಗ್ಲಿ ರೀ,
Very well.
ರಿಜೆಕ್ಟ್ ಅದ ಆಮೇಲೆ, ಬಟ್ ಪ್ರಿಪೇರ್ ಮಾಡಿದ್ರ ಇಲ್ಲ? ನೀವು
Yes, my
ಪ್ರಿಪೇರ್
lords.
ಮಾಡಕ್ಕೆ ವಾಟ್ ಆರ್ ದಿ ಗೈಡ್ಲೈನ್ಸ್? ವೈ ಯು ಪ್ರಿಪೇರ್ ದಟ್ ಲಿಸ್ಟ್ ಆಫ್ ಇನ್ಎಲಿಜಿಬಲ್ ಕ್ಯಾಂಡಿಡೇಟ್ಸ್?
My lords, that was on ಗ್ರಾಮ ಸಭೆನಲ್ಲಿ ಮೀಟಿಂಗ್ ಆದಾಗ ಯಾರ್ಯಾರು ಇದ್ರು ಅವ್ರು
ಗ್ರಾಮ ಸಭೆಯಲ್ಲೂ ನೀವು
yes
ನೀವು PDO ಕೆಲಸ,
yes ma'am.
ಇಲ್ಲೂ ಬ್ಯೂರೋಕ್ರಾಟ್ಸ್ ಕೆಲಸ ಮಾಡ್ಬೇಕಾದ್ರೆ ಏನು ಅಂದ್ರೆ ಅವ್ರು ಹೇಳಿದ್ದೆಲ್ಲ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಕಾನೂನು ಏನಿರುತ್ತೋ ಅದ್ರ ಪ್ರಕಾರ ಮಾಡ್ಬೇಕು, ಹೌದಲ್ಲ? ಮಿನಿಸ್ಟರ್ಸ್ ಹೇಳ್ತಾರೆ, MLA ಹೇಳ್ತಾರೆ ಅಂತ ಹೇಳಿ ಬ್ಯೂರೋಕ್ರಾಟ್ಸ್ ಗಳು ಮಾಡಕ್ಕಾಗಲ್ಲ.
Very well.
ಯು ಆರ್ ದಿ PDO, ಹೌದಲ್ಲ?
Yes.
ರೆಸ್ಪಾನ್ಸಿಬಿಲಿಟಿ ಆನ್ ಯು.
Yes.
ನೀವು ಗ್ರಾಮ ಸಭೆಯಲ್ಲಿ ನಾವು ಲಿಸ್ಟ್ ತಯಾರು ಮಾಡಿದ್ವಿ ಅಂತಲ್ಲ, ಯಾರು ಮಾಡ್ಬೇಕಾದ್ ಲಿಸ್ಟ್ ನ? Who has to prepare the list?
PDO has to prepare the list.
ಹೌದಲ್ಲ?
Yes.
ಮತ್ತೆ ನಾ ಇಲ್ಲ ನಮ್ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಅಧ್ಯಕ್ಷ ಇದ್ದ, ಮೆಂಬರ್ ಇದ್ದ, ನಾನ್ ಮಾಡ್ದೆ ಅಂತ ಹೇಳಕ್ಕಾಗಲ್ಲ. ಅವ್ರು ರೆಕಮೆಂಡ್ ಮಾಡಿದ್ರು ನಾನ್ ಮಾಡ್ದೆ ಅಂತ ಹೇಳಕ್ಕಾಗಲ್ಲ. Why you sent the list of the candidates who are not eligible? That is the ನಿಮ್ಮೇಲ್ ಚಾರ್ಜ್, ಹೌದಾ?
ಅಲ್ಲ,
You are not disputing the provisional list prepared by you.
My lords, the charge is ಹಣ ತಕೊಂಡು ಇನ್ಎಲಿಜಿಬಲ್ ಲಿಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ.
ಸರಿ ರೀ, ಈಗ ಇನ್ಎಲಿಜಿಬಲ್ ಕ್ಯಾಂಡಿಡೇಟ್ ಬಂದ್ರು ಅಂದ್ರೆ ದಟ್ ಈಸ್ ಅನ್ ಇನ್ಫರೆನ್ಸ್.
My lords,
ಹೌದಿಲ್ಲ?
ಇಲ್ಲ, my lords may kindly take the judgment paragraph number 6 ಅಲ್ಲಿ. I'll come to that.
If you disputed that list was not prepared by you, then it is correct. ಈಗ ಅಕ್ಸೆಪ್ಟ್ ಆಗಿದ್ರೆ ಏನಾಗೋದು? ಒಂದ್ ನಿಮಿಷ ಇರ್ರಿ, ineligible candidates would have got the benefit under the scheme, ಹೌದಲ್ಲ? If it is accepted, reject ಆಗ್ಲಿ ಅದ್ secondary, but very preparation of the list who are ineligible.
Yes, ma'am.
To get the ಆಶ್ರಯಸ್ ಏನ್ ಸೈಟ್ ಇದು? ಸೈಟಾ? ಆಶ್ರಯ ಸೈಟ್.
Yes, ma'am.
That itself is a misconduct.
Yes.
My lords may kindly take page number 7, my lords. Page number 37, paragraph number 7.
ನಿಮ್ ಚಾರ್ಜ್ ಇರೋದೇ ಹಾಗಂತ, ನಿಮ್
ಇಲ್ಲ,
ಸ್ಪೆಸಿಫಿಕ್
ಚಾರ್ಜ್ ಇರೋದು ಹಣ ತಗೊಂಡು ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ. ಹಣ ತಗೊಂಡಿರೋದು ಪ್ರೂವ್ ಆಗಿಲ್ಲ. ಹಣ ತಗೊಂಡಿರೋದೇ ಪ್ರೂವ್ ಆಗಿಲ್ಲ ಅಂದ್ಮೇಲೆ ದಿ ಲಿಸ್ಟ್ ಪ್ರಿಪೇರ್.
ಆಯ್ತು, ನೀವು ಹಣ ತಗೊಂಡಿದ್ಮೇಲೆ ಮತ್ತೆ ಲಿಸ್ಟ್ ಆಗಿ ಪ್ರಿಪೇರ್ ಮಾಡಿದ್ರು ಇನ್ಎಲಿಜಿಬಲ್ ಕ್ಯಾಂಡಿಡೇಟ್ ಗೆ.
My lords, that was a list.
ಇನ್ಎಲಿಜಿಬಲ್ ಕ್ಯಾಂಡಿಡೇಟ್ ಗೆ ನೀವು ಲಿಸ್ಟ್ ಪ್ರಿಪೇರ್ ಮಾಡಿದಿರಿ ಅಂತ ಫೈಂಡಿಂಗ್ ಇದೆಯಾ?
ಅಲ್ಲ, ಅದು ಕರಡು ಲಿಸ್ಟ್ ಇನ್ ದ ಮೀಟಿಂಗ್ ಅದೇನಾಗಿರುತ್ತೋ ಅದನ್ನ ನಾವು ಬರ್ಕೊಂಡಿದ್ದ ಅಷ್ಟೇ.
ಕರಡುನು ಆದ್ರೂ ಅಲ್ಲಿಗೆ ಏನಕ್ ಮಾಡಿದ್ರಿ ಅದನ್ನ ಲಿಸ್ಟ್ ನ? ನೀವೇನ್ ಮಾಡ್ಬೇಕು ಲಿಸ್ಟ್ ನ?
ಅಲ್ಲ, ಗ್ರಾಮ ಸಭೆ
who are eligible to get the side under the scheme, if you would have prepared that, ನಿಮ್ದೇನು ಬರ್ತಾನೆ ಇರ್ಲಿಲ್ಲ. ಅದು ಆ ಊರಿಗೆ ಸೇರ್ದಿಲ್ಲವ್ರನ್ನೆಲ್ಲರಿಗೂ ಸ್ಕೀಮ್ ಅಲ್ಲಿ ಸೇರ್ಸಿದಿರಂತಲ್ಲ ನೀವು?
ಇಲ್ಲ, ಅದನ್ನು ಚಾರ್ಜ್ ಪ್ರೂವ್ ಆಗಿಲ್ಲ.
ಅದ್ ಪ್ರೂವ್ ಆಗಿಲ್ವಾ?
ಆಗಿಲ್ಲ. ಎಲ್ಲರೂ ಗ್ರಾಮಸ್ಥರೇ.
ಪ್ರೂವ್ ಆಗಿದ್ ಯಾವ್ದು ಮತ್ತೆ? ನಿಮ್ಮ
ಬರೀ ಆ ಲಿಸ್ಟ್ ಮಾತ್ರ ಮಾಡಿದೀವಿ ಅಂತ ಅಷ್ಟೇ ಹೇಳ್ತಾ ಇರೋದು.
ನಾವು ಕೇಳ್ತಾ ಇರೋದು.
That my lords may kindly.
ಭಾಗಶಃ ಅಂದ್ರೆ ಏನು? ಅಂದ್ರೆ ಲಿಸ್ಟ್ ಪ್ರಿಪೇರ್ ಮಾಡಿರೋದ್ ಬಗ್ಗೆ ನಿಮ್ಮ ಅಲಿಗೇಷನ್ ಅಲ್ಲಿ ಅವ್ರ ಊರ್ನವ್ರು ಅಲ್ಲ ಅನ್ನೋದ್ರಲ್ಲಿ ಯಾರು ಇದಾರ ಊರ್ನವ್ರು ಅಲ್ದಲ್ಲೇ ಇರೋದ್ರಲ್ಲಿ ಅದು ನೀವು ಪ್ರೂವ್ ಮಾಡಿಲ್ಲ, ಹೌದಾ? ಒಂದು. ಎರಡನೇದು, ದುಡ್ಡು ತಗೊಂಡಿದ್ಕೆ ಏನಿಲ್ಲ, ಬಟ್ ಓನ್ಲಿ ಲಿಸ್ಟ್ ಪ್ರಿಪೇರ್ ಮಾಡಿದಾರ ಅಷ್ಟೇ, ಎಫೆಕ್ಟಿವ್ ಕೊಟ್ಟಿಲ್ಲ ಅದು. ಮತ್ತಿನ್ನೇನು? ಚಾರ್ಜ್ ಓನ್ಲಿ ಪ್ರಿಪರೇಷನ್ ಆಫ್ ಲಿಸ್ಟ್ ಅಷ್ಟೇ, ಹೌದಾ? ಅದೇನ್ ರಿಜೆಕ್ಟ್ ಆಗಿದೆಯಾ ಅಲ್ಟಿಮೇಟ್ ಆಗಿ? ಮತ್ತೆ ಟ್ರಿಬ್ಯುನಲ್ನವರು ಅದನ್ನೇ ಅಬ್ಸರ್ವ್ ಮಾಡಿರೋದು, ಹೌದಾ?
Tribunal's observation, my lords, page 37, para 7 ಇಂದ ಶುರುವಾಗುತ್ತೆ. ಫಸ್ಟ್ ವೆದರ್ ಜುಡಿಷಿಯಲ್ ರಿವ್ಯೂ ಮಾಡಬಹುದಾ ಅಂತ ಹೇಳಿ ಅದನ್ನು ಕ್ವೆಶ್ಚನ್ ಫ್ರೇಮ್ ಮಾಡಿ. That has already been considered, my lords.
ಪ್ಯಾರಾ 8 ರಲ್ಲಿ ಎಲ್ಲ ಡಿಸ್ಕಸ್ ಮಾಡ್ಕೊಂಡು ಹೋಗೋರು ನೋಡಿ.
My lords may come to page number
PW1, PW2,
My lords, page 45 ಅಲ್ಲಿ ಮಧ್ಯದಲ್ಲಿಂದ
Witness voluntarily deposed that
yes,
in exhibit P1, he has put his signature and submitted that he cannot say how many houses and how many persons are residing within the jurisdiction of K. Gollahalli Grama Panchayat. To the suggestion that whether he knew Srimati Maharasama, this witness answered that if he went to the village, he will be knowing. When it was suggested that provisional list of the beneficiaries prepared by the so-and-so, he says that he does not know. But he denied the suggestion that applicants have not prepared the said provisional list. He also deposed that as the provisional list was not prepared in the Grama Sabha, it was not possible for him to participate in the said Grama Sabha. He cannot say that allotment of sites list prepared by whom at what time and where. He admitted the suggestion as that the said provisional list of allotment under exhibit P8 and exhibit P9 were returned back from the executive officer of the Taluka Panchayat to the Grama Panchayat. He doesn't know when the deputy commissioner allotted 2 acres of land in survey number 40 preparing of house list, not produce the sketch map for formation of 300 sites in the said 2 acres of land. Many of persons in the selection list of the beneficiaries have paid the money, but this witness deposed that those persons were hesitating to come before the inquiry officer to give evidence. He denied the suggestion that he is having personal enmity with the president of the Grama Panchayat and therefore he is giving false complaint and false evidence. He admitted that suggestion as true as per the list of understanding, the sites were not allotted to the persons mentioned in the list. He has also admitted the suggestion as true that before he gave the complaint, the selection list under so and so were not implemented. Admitted the suggestion that the sites were not allotted to the beneficiaries and Akkupatra was also not issued. PW3 evidence also discussed.
My lords, page number 45 ಅಲ್ಲಿ ಮಧ್ಯದಲ್ಲಿಂದ
Ink page 45.
ಅಲ್ಲ ಇಂಕ್ ಪೇಜ್ 25 my lords. 6ನೇ ಲೈನ್ ಅಥವಾ 7ನೇ, therefore these aspects ಅಂತ ಇದೆ. ಎಂಟೈರ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ಏನೇನ್ ಅಡ್ಮಿಷನ್ಸ್ ಇದೆ ಅದನ್ನೆಲ್ಲ ರೆಕಾರ್ಡ್ ಮಾಡಿ, therefore these aspects were not taken into consideration by the inquiry officer in his report and only on the basis of the evidence of the witness in the chief examination he has come to the conclusion that the charges against the appellants are partially or partly proved. The inquiry officer specifically held that report regarding the allegation made by receiving the amount from some of the beneficiaries has prepared the list names illegally as beneficiaries is not proved.
Therefore,
the aspects were not taken into.
The preparation of the provisional list is not denied by the, though it is not acted upon, your lordship. And the tribunal has taken appellant authority, that it has gone through the entire report. That was not the purview of the tribunal.
ಏನ್ ಮಾಡಿದ್ರೆ ಇನ್ಕ್ರಿಮೆಂಟ್ ಕಟ್ ಮಾಡಿದ್ರೆ ಒಂದು.
My lords, one more aspect, my lords, one more submission.
Annexures ಎಲ್ಲಿದೆ?
A19 my lords.
A19
A19
page
number 318 my lords, 2/3/2020 order.
324 324.
Yes. ಅಲ್ಲ ಅದು 324 typed copy.
ಅದು 324 typed copy.
Yes ma'am.
Government proceedings.
Yes ma'am. 330 and 331 is the
operative portion of the order.
Yes ma'am.
So the
yes ma'am.
instructed and not implemented, no Akkupatra was issued.
But there was a dereliction of duty to the extent that without verification list was prepared, your lordship.
My lords, one more submission, my lords. Page 44 for a moment, ink page 24 of the judgment. Page 44, second paragraph. Second paragraph.
Examination
Yes.
by the defense.
He admitted the suggestion that it is as true that the preparation of beneficiary list under the Ashraya will not be done by the Grama Sabha of the Gram Panchayat. He admitted that the two members of the Gram Panchayat make the Yes, my lords. Will be notified in the general body meeting in the same will be finalized. ಇನ್ನು finalized ಕೂಡ ಆಗಿರ್ಲಿಲ್ಲ.
ಫೈನಲ್ ಆಗಿಲ್ವಾ ಇದು?
ಆಗಿಲ್ಲ.
Our site is not on, DC has not built the land.
Even as on this day, the formation
It
of sites.
deposed that for preparation of the beneficiary list under the Ashraya scheme, there is no power for the panchayat secretary or by the PDO of the said panchayat ಅಂತ admission ಇದೆಯಲ್ಲ ಮೇಡಮ್? PW2 admission ಅಲ್ಲಿ ನೋಡಿ. PW3 B1 BO
Executive officer.
executive officer. Ultimate powers are not vested with him. That is the evidence.
But the very preparation of it is.
Preparation ಆಗಿದೆ ಮೇಡಮ್, ಅಲ್ಲೇ ಆ ಪ್ಯಾರಾದಲ್ಲಿ ಹೇಳಿದಾರೆ ನೋಡ್ರಿ, ಎಲ್ಲ ಅಡ್ಮಿಷನ್ ಇದೆ ಇವತ್ತು. Ashraya scheme will be done in the Grama Sabha of the Grama Panchayat ಅಂತಿದೆ.
Finally, it will be given.
ಇವನ್ ಒಬ್ಬನಿಗೆ ಹೆಂಗ್ ನೀವು ಮಾಡ್ತೀರಿ? He admitted his suggestion as true that members of the Grama Panchayat will make the selection list of the beneficiaries. He admitted the suggestion as true that thereafter the said will be notified in the general body meeting and the same will be finalized. This is the evidence. It takes away.
Professional list which was prepared, your lord.
That admission is also there.
It will be given after the discussion with the.
ನೀವು ಗ್ರಾಮ ಪಂಚಾಯತ್ ಚೇರ್ಮನ್, ಗ್ರಾಮ ಪಂಚಾಯತ್ ಮೆಂಬರ್ಸ್ ಗೆಲ್ಲ ಪ್ರಾಸಿಕ್ಯೂಟ್ ಮಾಡಿದ್ದೀರಾ?
Only.
ಇಲ್ಲ.
ಅವ್ರನ್ನ ಮಾಡ್ಬೇಕಲ್ಲ ನೀವು. ನಿಮ್ ಅಡ್ಮಿಷನ್ ನೋಡಿದ್ರೆ PW3 ಅಡ್ಮಿಷನ್ ನೋಡಿದ್ರೆ
ಲೋಕಾಯುಕ್ತ ಆಕ್ಟ್ ಸೆಕ್ಷನ್ 7 and 13D ನಲ್ಲಿ ಏನಾದ್ರು ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಇದೆಯಾ ಅವ್ರ ಮೇಲೆ? ಇಲ್ಲಲ್ಲ.
Heard the counsel appearing for the state, HCCP Srimati Rashmi Patel, and also the counsel appearing for the Lokayukta.
Respond, please.
And state had challenged the order passed by the tribunal in application number 1624 and 1625 of 2020. ಇರ್ಲೇನು ಎರಡು ಇದೆಯಾ? ಒಂದೇ ರಿಟ್ ಪಿಟಿಷನ್?
Two respondent.
Secretary is a PDO, secretary and PDO, two DQs. Joint and PDO.
ಬಟ್ ಅಲ್ಲ, ಈಗ ಟ್ರಿಬ್ಯುನಲ್ ಎರಡು ಅಪ್ಲಿಕೇಶನ್. ಈಗ ನೀವು ಯಾವ್ದ್ರ ಮೇಲೆ ಬಂದಿರೋದು? ಎರಡ್ರ ಮೇಲೂ ಬಂದಿದ್ದೀರಿ. ಇಲ್ಲಿ 2 ನಂಬರ್ ಆಗ್ಬೇಕಲ್ವಾ ರಿಟ್ ಪಿಟಿಷನ್? ಒಂದೇ ಹೆಂಗ್ ಹಾಕ್ತೀರಿ? ಕಾಮನ್ ಆರ್ಡರ್ ಆಗಿರ್ಬೋದು ಮೇಡಮ್. ಚಾಲೆಂಜ್ ವಾಸ್ ಮೇಡ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ 2 ಆರ್ಡರ್ಸ್ ಅಪ್ಲಿಕೇಶನ್ಸ್ ಅಲ್ವಾ? ಕಾಮನ್ ಆರ್ಡರ್ ಆದ್ರೂ 2 ಅಪ್ಲಿಕೇಶನ್ಸ್, independent applications by independent parties.
Like the court fee is paid, my lord, the single number is.
Normally, my lord, they will entertain even.
ಕೋರ್ಟ್ ಫೀ ಕೊಟ್ಟಿದಾರ ಹೋಗ್ಲಿ ಎರಡಕ್ಕೂ?
ನಾವು ಹಾಗೆ ಆಗ್ತೀವಿ ಕಾಮನ್ ಇವನ್ my lord, if there is common order.
ಇಂದೇ ಕಾನೂನುಗಳು. 1624 and 1625 of 2020. Wide order dated 14th day of October 2022. Wherein the tribunal comes to the conclusion that looking to the evidence led by PW 123 itself goes to show that there is no preparation of the final selection list in this case, and provisional list was prepared, and it was prepared by the members of Grama Panchayat in the Grama Sabha, and the same was forwarded to the executive officer of the Taluk Panchayat, but he has not finalized the same and returned it back. Witnesses admitted that the said land of 2 acres, which is earmarked for formation of sites under Ashraya scheme, is still in the name of the government, and no allotment of the site was made, and no Hakkupatra was issued to any of the beneficiaries. Therefore, these aspects were not taken into consideration by the inquiry officer in his report, and only on the basis of evidence of witness in the examination in chief, he has come to the conclusion that charges against the appellants are partly proved. The inquiry officer specifically held in his report regarding the allegation that the applicants, by receiving the amount from some of the beneficiaries, has prepared the list containing their names illegally, as many beneficiaries is not proved. Therefore, under these circumstances, allowed the applications and set aside the order. With annexure A19 and directed to pay all consequential benefits, including the monetary benefits to the applicant to which they are legally entitled to. And time found period of 3 months is also set in the order. The counsel appearing for the appellant HCP brought to notice of this court the government proceedings. Annexure 19, wherein increments of the respondent were withheld consequent upon the report of the inquiry officer. The counsel would vehemently contend that the tribunal committed an error in making the judicial review of the order of the inquiry officer and ought not to have done the same. And the scope of the tribunal is very limited, and appreciated the evidence of PW 123 and comes to such a conclusion, and hence it requires interference of this court. The counsel appearing for the respondent Lokayukta also reiterate the grounds which have been urged by the state and also contend that the tribunal committed an error. Per contra, the counsel appearing for the respondent would submit that the tribunal, while passing an order, taken note of the reasoning of taken note of that the charge leveled against the respondent is not proved with regard to the collecting the money and making the ineligible candidate as eligible for the eligible, and also counsel would submit that the charge is only partly proved only with regard to the preparation of provisional list, and the same is taken note of by the tribunal. There was no any acceptance of provisional list and also no final list, as well as the same is not accepted and no Hakkupatra was issued. Even the land remains and not led any consequences consequent upon preparation of the provisional list, and hence the same is taken note of. Having heard the counsel appearing for the appellant as well as the special counsel for Lokayukta and also the counsel appearing for the respondent, and considering the material on record, the charge number 1 against the respondent is that he had prepared the list for allotting the sites under the Ashraya scheme by collecting the money, and also made the ineligible candidate to get the benefit. The tribunal, while considering the material on record and particularly taking note of the inquiry report submitted by the inquiry officer, comes to the conclusion that only partly allowed, partly proved the charges leveled against the respondent, and nothing is placed on record with regard to the collecting of money and making the ineligible candidate who are not the residents of the particular village, and no such details are given. However, it is not in dispute that provisional list was prepared, but while conducting the inquiry, and the inquiry officer fails to take note of the cross-examination answers elicited from the mouth of PW3, who is a EO, and he categorically admits that the list was prepared by the panchayat members and not exclusively by the PDO, and the same is also a provisional list, and the said list is also not finalized, and the same is also sent it back, and also there was no any progress based on the said provisional list. And when such being the case, when the Grama Panchayat members were not prosecuted with regard to the preparation of the provisional list, and no doubt the PDO is also the officer finalizing the same, but the fact is that when the clear admission is given on the PW3 and in the cross examination, which has been discussed in paragraph number 8 by the tribunal, that list under the Ashraya scheme will be done in the Grama Sabha of the Grama Panchayat, and also admitted the suggestion as true that members of the Grama Panchayat will make the selection list of the beneficiaries, and also admitted the suggestion as true that thereafter, the said list will be notified in the general body meeting and the same will be finalized. And further admission that preparation of the beneficiary list under the Ashrayam scheme, there is no power for the Panchayat secretary or by the PDO of the said Panchayat. And when this admission was given, and now the council argument on behalf of the state that the tribunal ought not to have discussed in detail and ought to have exercised the judicial review cannot be accepted when the inquiry officer failed to take note of these admissions on the part of the EO who has been examined as PW3, and when the report was submitted before the government holding that the charges leveled is proved but fails to take note of this glaring admissions on the part of PW3, and hence the contention that the tribunal ought not to have made judicial review cannot be accepted when there is a clear admission on the part of PW3 that the preparation of the beneficiary list under the Ashrayam scheme, there is no power for the Panchayat secretary, and imposing the penalty, withholding his increment, that is 4 increment, when he was not eligible and competent to prepare the list, he ought not to have penalized by accepting the inquiry report, and hence we do not find any error on the part of the tribunal in considering particularly the admission on the part of PW3 in his cross examination. Instead of the inquiry officer only considered the evidence of PW3 which has been adduced in chief evidence, and the very examination and cross examination ought to have been taken note of by the inquiry officer by submitting the report in coming to the conclusion that charges has been proved, and the totality of the evidence is also chief evidence as well as cross examination, and the same is not considered, and hence no ground is made out by the state to set aside the order of the tribunal. Hence writ petition is dismissed. The PDO is warned not to indulge in such act in future while discharging his duty.
Guidelines, only women will have to be the beneficiary, and there are names of the male persons.
And as per the guidelines, only the woman will have to be the beneficiary, and as there are names of the male persons, the said list was sent back only on that ground. And when such being the case, when the beneficiaries are women only, prepare the list of male persons also. That is nothing but a dereliction of duty of the PDO and being a secretary of the Grama Panchayat. Even though the list will be prepared by the Grama Panchayat members as a duty bound to verify the same and prepare the list, and hence instead of imposing the penalty, he is censured.
My lords, there's a specific finding saying that I don't have the powers to prepare the list, my lords. Alla andre admission ide. Page 44 ಅಲ್ಲಿ.
Censure ಬೇಡ ಮೇಡಮ್, ಹಿಯರ್ ಬೈ ವಾಂಡ್ ಅಂದ್ಬಿಡಿ ಸಾಕು. Censure ಬೇಡ, ಹಿಯರ್ ಬೈ ವಾಂಡ್ ಅಂತ ಮಾಡಿ. The same is the and the CEO of ZP is directed to communicate this order to the secretary, PDO.
17.
ಅಲ್ರಿ ಅವ್ನ ಹೆಂಗ್ರಿ ಕಣ್ ಮುಚ್ಕೊಂಡು ರೆಡಿ ಮಾಡ್ತಾನೆ ಲಿಸ್ಟ್ ನ? ಬರೀ ಲೇಡೀಸ್ ಮಾತ್ರ ಎಲಿಜಿಬಲ್ ಅಂತ ಇದ್ದಾಗ ಸ್ಕೀಮ್ ಪ್ರಕಾರ ನಿಮಗೆ ಮತ್ತೆ ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡಿದ್ರೆ ನಿಮ್ಗೆ ಕೋಪ ಬಂದ್ಬಿಡ್ತದಲ್ಲ. ಮತ್ತೆ ಗೊತ್ತಾಗಲ್ವ ನನಗೆ ಜೆಂಡರ್ ಹೆಣ್ಮಕ್ಳ ಗಂಡ್ಮಕ್ಳ ಅಂತ. ಡೈರೆಕ್ಟ್ ಎವಿಡೆನ್ಸ್ ತರಕ್ಕಾಗಲ್ಲ, ದುಡ್ಡು ತಗೊಂಡು ಲಿಸ್ಟ್ ಪ್ರಿಪೇರ್ ಮಾಡಿದ್ಕೆ. ಹಾ ಅಟ್ಲೀಸ್ಟ್ ಅಷ್ಟೇ. ಇನ್ಫರೆನ್ಸ್ ಹ್ಮ್
17.
ಏನ್ ಮಾಡಿರ್ರಿ SPP? ಹೈಕೋರ್ಟ್ಗೆ ಯಾರು ಅಪಿಯರ್ ಆಗೋದು? ಸುವಮೋಟೋದಲ್ಲಿ ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಾರಲ್ರಿ? ಯಾರು ಹೈಕೋರ್ಟ್ ಅಡ್ವೊಕೇಟ್ ಯಾರು ಮೇಡಮ್? ಅಭಿಜಿತ್. ಸುವಮೋಟೋ ಹಾಕಿದಾಗ ಹೈಕೋರ್ಟ್ ಪರವಾಗಿ ಯಾರ್ರಿ ಅಡ್ವೊಕೇಟ್? ಆರ್ಡರ್ ನೋಡಿ, ಆರ್ಡರ್ ನಲ್ಲಿ ಏನಿದೆ? Learned government advocate accept notice for respond number 1 to 5 ಆಯ್ತು. Learned additional solicitor general of India accept notice for respond number 7. Krutika Raghavendra for R6. Registry is directed to serve the copy of the writ petition along with the annexures. Learned government advocate for respond number 1 to 5 6 time to file objections to the writ petition with regard to the appointment of a nodal officer at the senior so and so. ಗ್ರಿಡ್ ಬೈ ಸುವಮೋಟೋ ಅಲ್ಲ ಮೇಡಮ್ ಇದು? ಮತ್ತೆ ಯಾರು ಅಸಿಸ್ಟ್ ಮಾಡ್ಬೇಕಲ್ಲ ಹೈಕೋರ್ಟ್ಗೆ?
ಈಗ ಇವರು SPP ಅವರು ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್
SPP R1 to 5 ಗೆ ಇಲ್ಲಿ R1 ನಾವು ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಮಾಡಿದಾರೆ ನೋಡಿ.
SPP 6 2 weeks time to file statement of objections to the
ಮಾಡಿದಾರಲ್ಲ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿದಿರಲ್ಲ, ಹಾಕಿದಾರ ಅವರು. ಈಗ ಏನು ರಿಟಲ್ ಕೇಳಿದಾರ ಪ್ರೇಯರ್ ವೆದರ್ ದಿ ಸೇಮ್ ಹ್ಯಾಸ್ ಬಿನ್ ಕಂಪ್ಲೈಡ್ ಆರ್ ನಾಟ್ ಅನ್ನೋದಕ್ಕೆ ಎಜಿಗೆ ಡೈರೆಕ್ಟ್ ಮಾಡ್ಬಿಡಿ. ಗೌರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಯಾರು ಇದಾರೆ ಹೈಕೋರ್ಟ್ಗೆ? ಅದೇ ರಿಜಿಸ್ಟ್ರಿಗೆ ಪ್ಯಾನಲ್ ಅಡ್ವೊಕೇಟ್ಸ್ ಇದ್ದಾರೆ. We are only the umpires, sir. We are only the umpires. Huh? Huh? ಯಾರು ಅದು ಅಪಾಯಿಂಟ್ ಆಗ್ಬೇಕು ಇದ್ರಲ್ಲಿ?
ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಶ್ರೀರಂಗ ಅವರು ಇದ್ರಲ್ಲ.
ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ 4 ಜನ ಇದ್ದಾರೆ ನೋಡಿ, 4 ಜನ ಇದ್ದಾರೆ. ಮೊದ್ಲು ಅಶೋಕ್ ಕಾರ್ನಳ್ಳಿನು ಇವ್ರು ಇದ್ರು, ಯಾರು ಒಳ್ಳ ಇದ್ರು. ಈಗ ಯಾರಿದ್ದಾರೆ ಗೊತ್ತಿಲ್ಲ, ನಾಗಾನಂದ್ ಇದ್ರು. ಅದಲ್ಲ ಅವರಲ್ಲಿ ಯಾರನ್ನ ಫೈನಲೈಸ್ ಮಾಡ್ಕೋತಾರ ಈ ಸುವಮೋಟೋ ಕೇಳ್ಬಿಡಿ ಆಯ್ತು. ನಾವು ವಿಲ್ ಅಪಾಯಿಂಟ್ ಅನ್ ಅಡ್ವೊಕೇಟ್ ಅಂಡ್ ದೆನ್ ವಿಲ್ ಹಿಯರ್. ಅವರು ಕಂಪ್ಲೈನ್ಸ್ ಆಗಿದೆ ಇಲ್ಲ ನೋಡ್ ವಿಲ್ ಸಿ. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಡೈರೆಕ್ಷನ್ಸ್ ಕಂಪ್ಲೈ ಆಗಿದೆಯೋ ಇಲ್ವೋ ಅಷ್ಟೇ ನೋಡ್ಬೇಕು ನಾವು ಅಷ್ಟೇ. ಓನ್ಲಿ ರೆಮಿಷನ್ ಬಗ್ಗೆ. You are representing legal service authority. Totally. R6 council files memo along with letter dated 14/1/2026 5/4/25 and the same is taken on record. Copies serve madidra? Copy of the same is served on the other side. ಬಾಕಿದ್ ನೋಡಿ ಯಾರನ್ನ ಆಟೋ ಮಧ್ಯಾಹ್ನದೊಳಗೆ ಯಾರು ಅಂತ ಕೇಳ್ಬಿಟ್ಟು ಅಪಾಯಿಂಟ್ ಮಾಡ್ಕೊಡಿ. ನೋಡಿ ಡೇಟ್ ಕೊಟ್ಟು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಕೊಡ್ತೀವಿ. 18 ಬಟ್ ಅದು ಯಾರು ಅಂತ ಅವ್ರಿಗೆಲ್ಲ ಕೇಳಿ ಹಾಕ್ಬಿಡಿ. ಅಂಡ್ ಕೌನ್ಸಿಲ್ ಶ್ರೀ so and so is directed to take notice in respect of the suo motu petition filed by the High Court and assist the court ಅಂತ ಮಾಡ್ಬಿಡಿ. List to further hearing.
List to further hearing. Venkatesh R. Bhagat.
I am for the appellant number 1 and I may be permitted to appear online, my lords.
Final hearing.
How? I was
appear in online or in physically. It is left to you.
Yes, I was unwell, my lords. So for that purpose, I can.
Yes, you can make your submission.
Yes, ma'am. Yes, ma'am. my lord. The entire prosecution case.
Who appears on behalf of the state, madam, ಇದ್ರಲ್ಲಿ ನೀವಾ ಕೇಳಿಸ್ಕೊಳ್ಳಿ ಅವ್ರ ಆರ್ಗ್ಯುಮೆಂಟ್ ಏನ್ ಮಾಡ್ತಾರೆ ಅನ್ನೋದು. ಯು ಹ್ಯಾವ್ ಟು ಗಿವ್ ರಿಪ್ಲೈ ತಾನೆ, ಇಲ್ಲ ಅವ್ರದೇ ಅಪೀಲ್, ನೀವೇ ರಿಪ್ಲೈ ಕೊಡ್ಬೇಕು. ಎಸ್, A1 and A2.
Yes, my lord. Here, my lord, initially,
I am for A3.
A3 you have already argued.
Initially, my lord, entire case is based on voluntary statement of the accused number 1 to 3 recorded by the prosecution, my lord. The voluntary statements are at exhibit P61, 62, 63, my lord.
Voluntary statement, if any recovery?
My lord, there's a recovery is the pant and shirt, my lord, and one ATM card and one mobile phone.
Voluntary statement will be looked into only in case of recovery.
Yes,
and other materials which have been provided is
27.
inadmissible in evidence. That
Yes,
cannot be looked into.
No, my lord, why I am referring to 61, my lord?
What is the recovery? What are the recoveries?
Yes, my lord. Before that, one, my lord, my lord, initially prosecution starts with the eyewitness, my lord.
Eyewitness, yes.
It starts with saying that the eyewitness, PW15, that is referred in the voluntary statement, my lord. One Veeresh, my lord.
PW?
My lord, first I will take your lordship just to show that voluntary statement, my lord. Based on that, I am not relying upon any other thing. Your lordship is section. I will restrict.
Yes, we go through the voluntary statement. We will look into only the recovery portion in voluntary statement, not any other.
My lord, there it says Veeresh is an eyewitness to the incident in those 3 voluntary statements, my lord.
That is exhibit
PW50, exhibit 61, 62, 63, my lord.
Available at page number?
300. Yes, just
349.
349. Yes, my lord.
349.
Yes, my lord.
349 and 50. 50 yes, only last portion. ತೆಗೆದುಕೊಂಡು ಬಂದಿದ್ದು ಅಶೋಕನ ಮೊಬೈಲ್ ಹಾಗೂ ATM ಕಾರ್ಡ್ ಅನ್ನು ನಮ್ಮ ಮನೆಯಲ್ಲಿ ಇಟ್ಟಿದ್ದು ತೋರಿಸಿ ಹಾಜರುಪಡಿಸುತ್ತೇನೆ ಮತ್ತು ಕೊಲೆ ಮಾಡುವಾಗ ಧರಿಸಿದ ಬಟ್ಟೆಗಳನ್ನು ಹಾಜರುಪಡಿಸುತ್ತೇನೆ.
These 2 things are very important, my lord, here. Now, before that, my lord, the beginning of that paragraph, my lord, last paragraph, exhibit P61, my lord. ನಂತರ ನಾನು ಮಂಜಾ ಇಬ್ಬರು ನೂರುಲ್ಲಾ ಹಾಗೂ ವೀರೇಶನಿಗೆ ಈ ವಿಷಯವನ್ನು ಯಾರಿಗಾದರೂ ಹೇಳಿದರೆ ನಿಮಗೆ ಹೊಡೆದು ಇದೇ ಗತಿ ಕಾಣಿಸುತ್ತೇವೆ ಅಂತ ಹೆದರಿಸಿದ್ದು. ಮೀನ್ಸ್ ಪ್ರೆಸೆನ್ಸ್ ಆಫ್ ದ 4th person ವೀರೇಶ ಇಸ್ ದ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಕೇಸ್, ಮೈ ಲಾರ್ಡ್. ಸೇಮ್ ಥಿಂಗ್ ಇಸ್ ಬಿನ್ ಮೆನ್ಷನ್ಡ್ ಇನ್ 62, 63, my lord. So according to the prosecution, Veeresha is an eyewitness, direct witness to the incident. This being the case, my lord, now I will take your lordship to the evidence of PW15. He is an eyewitness, my lord. PW15. At page
15.
Yes. One. PW19, my lord. PW19, my lord. CW15, PW19, my lord.
15 speaks only about the auto driver was also there along with him.
Yes, my lord. That is, he turned totally hostile, my lord. He has been treated as hostile. He is the eyewitness.
19. He was along with the others also on the accused number 1 to 3.
Yes, well, he saw the incident. I will just read the evidence of page 193, PW19, my lord. PW19. ನಾನು SSLC ವರೆಗೆ ದಾವಣಗೆರೆ ವಿಶ್ವಭಾರತಿ ಮತ್ತು ಬಕ್ಕೇಶ್ವರ ಶಾಲೆಯಲ್ಲಿ ಓದಿದ್ದೇನೆ. ನನಗೆ ಏಕೆಂದರೆ ಆರೋಪಿಯ ಪರಿಚಯವಿಲ್ಲ. ಅವನು ಏನು ಓದಿದ್ದಾನೆ ಮತ್ತು ಯಾವ ಶಾಲೆ ಓದಿದ್ದಾನೆ ಗೊತ್ತಿಲ್ಲ. 2 ಮತ್ತು 3ನೇ ಆರೋಪಿ ಎಲ್ಲಿ ಓದಿದ್ದಾರೆ ಮತ್ತು ಯಾವ ಶಾಲೆ ಓದಿದ್ದಾರೆ ಗೊತ್ತಿಲ್ಲ. 3ನೇ ಆರೋಪಿ ಏನು ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದಾನೆ ಗೊತ್ತಿಲ್ಲ. ಈ ಕೇಸಿನ ಮೃತ ಅಶೋಕ್ ಇವರು ನಾನು ನೋಡಿಲ್ಲ. ದಿಸ್ ಇಸ್ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್ ಮೇಲರ್. ಈಗ ತೋರಿಸಿದ 2 ಫೋಟೋಗಳಲ್ಲಿರುವ ವ್ಯಕ್ತಿ ಯಾರು ಅಂತ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಸಾಕ್ಷಿ ಯಾವ ಫೋಟೋ ತೋರಿಸಿದೆ ಅಂತ ತಿಳಿದುಕೊಳ್ಳಲು ಆ ಫೋಟೋಗಳನ್ನು 29, 31 ಗುರುತಿಸಲಾಯಿತು. ನಾಟ್ ಅಡ್ಮಿಟೆಡ್, ಜಸ್ಟ್ ಫಾರ್ ದಿ ಐಡೆಂಟಿಫಿಕೇಶನ್ ಮೇಲೆ. ದಿನಾಂಕ 11/9/2017 ಸಂಜೆ 6:30 7 ಗಂಟೆ ಸುಮಾರಿಗೆ ನಾನು 1/2 ಜೊತೆಗೆ ಹೋಗಿಲ್ಲ. ಅವರು ನನ್ನನ್ನು ಕರೆದುಕೊಂಡು 3ನೇ ಆರೋಪಿಯ ಆಟೋದಲ್ಲಿ ರಸ್ತೆ ಬರಲಿಲ್ಲ. ಈ ದಿನ ರೈಲ್ವೆ ಸ್ಟೇಷನ್ ನಲ್ಲಿ ಆಸಾ 17 ಇರಲಿಲ್ಲ. ಆಸಾ 17 ತಮಿಳಿನಲ್ಲಿ ಮಾತಾಡುವ
ಟೋಟಲ್ ಹಾಸ್ಟೈಲ್ ಏನು ಗೊತ್ತಿಲ್ಲ ಅಂತ ಹೇಳವನೆ. ಕ್ರಾಸ್ ಮಾಡಿದಾರೆ ಪಿಪಿ ಅವರು ಅಲ್ಲೇನಾರು ಮಾಡಿಸಿದಾರ?
ಏನು ಎಲಿಸಿಟ್ ಮಾಡಿಸಿಲ್ಲ. ಕ್ರಾಸ್. Therefore, my lord, the prosecution's theory of eyewitness gone. Now they are relying upon the circumstantial witness now. According to prosecution, they want to prove the circumstances in the absence of the eyewitness when eyewitness turned hostile, my lord. To how far when eyewitness turned hostile, circumstantial witness may be taken into consideration, my lord.
Yes.
Yes, my lord. Now, my lord, the first circumstances that prosecution want to rely upon is presence of the deceased at the spot or in Bangalore on in Davangere on 11/9/2017. That's the first circumstance. Second circumstance is that A1 to A3 have accompanied the deceased. That is the second circumstance. Third, they have purchased a liquor from a liquor shop. Number fourth circumstances is that from ATM 1,000 rupees was withdrawn. And fifth circumstance is that blood, some AB positive blood was found on the MOs, my lord. These are the 5 circumstances based on which they want to bring home the guilt of the accused number 1 to 3 for the offense punishable under section 302, my lord. That is section 34, my lord. Now, my lord, in the absence of identity of the witness, eyewitness to the accused number 1 to 3, no test identification parade was conducted. Nobody have identified the accused. Now, entire prosecution story is, my lord, starts from PW 17, my lord. Mother of
what
the
mother? What mother of PW accused number 1 says?
Hostile.
17 Chandramma.
Chandramma, hostile.
PW 17 Chandramma.
Yes, sir. Totally hostile, my lord. Denied the relationship, everything denied, my lord. Now, according to prosecution, my lords, Chandramma is having an illicit relationship with deceased. That was the case of the prosecution. Yes, my lord. And she was working in some shop in Chennai. Then she came back to her native place in Davangere. Then to search her, to meet her, accused deceased has come to Davangere. At that point of time, accused 1 and 2, along with the accused number 3, killed the deceased. Now, regarding relationship is concerned, my lord, the very crucial evidence of the son may be kindly seen, my lord. Son of the deceased. Totally contrary to the prosecution case, my lord. My lord, PW 13, my lords. I will take your lordship PW 13. Lokeshwaram. My lords, in his, even though he speaks contrary to the case of the prosecution, he has not treated as hostile, he has not cross-examined, my lord. Just I will take your lordship to the, and he doesn't know where father was there, where he was residing. Very important. Just I will read very short portion of PW 13, my lord. Deceased Ashoka is my father. Riveshwaram is my younger brother. My father was a temple priest. I know CW 16 Chandramma. I do not know where CW was working earlier. On 13/9/2017, we get a phone call from the Davangere police stating that my father has been murdered for the reason that he had an illegal affair with CW16 Chandramma. Then I came to Bangalore with my mother, my younger brother, and our relatives. We saw the dead body of the father in the hospital Davangere. I cannot identify the photographer if shown into me and dead body therein. Now, see the Panchanama exhibit P19. I say that I signed the same in Bapuji Hospital. It marked as so and so. I can now identify the father if CC footage is shown to me. Now, CD MO20 is played on the laptop through by HC 49 of the so and so police station. I now see the visual recording in the MO20, identify my father and the person with him as a accused number one who is before the court now. I now see MO1A photograph of a lady and identify her as Chandramma. Chandrappamma it is. It's mostly Chandramma, my lord. She was doing a cleaning and sweeping work in the temple in which my father was a priest. That's very important, my lord. According to that, she is working in a mobile shop in a Chennai. Here, their case is that she is working in the temple where her father as a priest was working. I came to know from the police that my father has been murdered by son of Chandramma and his cousins. After my father, so he is a hearsay. After my father's death, the police from Davangere had come to Chennai along with Chandramma after 2-3 months. I now see that merger, identity, my signature, and merger is marked as Exhibit P25 and my signature 25A. That merger was drawn in the house where my father and Chandramma were living. This is very important, my lord. They together were living, children were not with them, mother was not with them, means wife of the deceased was not with them. They are living together. This is the against the prosecution story, my lord. My younger brother showed the said house to the police on that day. This is the evidence, my lord, which contrary to the evidence of the prosecution, contrary to the case of the prosecution, my lord. Now, what is the case of the prosecution in gist? I will take a lordship to the para number 230 of the trial court judgment, my lord.
Kara?
Yes, but just miss that the flag is gone off. Para 232, my lord.
232.
Yes. It starts with the finding on motive, my lord. Here, according to the prosecution, motive was that deceased was having an illicit relationship with the PW17. He came to Davangere. Then accused number 1 and 2 have planned to eliminate him. I will just read these three paragraphs, my lord. 32, 33, 37, 36 and 37, my lord.
Yes.
In this case, A1 and A2 had motive to murder the deceased as they were offended by illegal relationship of the deceased with PW17. So they have planned with A3 not only to take him but to go to in auto rickshaw all the way till the place of the incident and to execute their plan of murdering the deceased. The place where the body was deceased was found is beside a channel and not in the place where the deceased was residing or that he was sitting for some purpose. So taking deceased to such a remote place itself indicates that the intention was to put an end to the life of the deceased. So indicates that A1 to A3 had a common purpose to execute their object of murdering the deceased and such each of them becomes responsible for the act of the execution of their common purpose. A3 was physically present at the place of crime to facilitate the escape of A1 and A2 after they assault and murder the deceased. So the common intention between A1 to A3 is clearly established and A3 is liable to be conviction for the offense under section 302 and of the IPC. These three paragraphs is contrary to the entire story narrated by the IO in the voluntary beginning part of the voluntary statement, my lord. Just your lordship told is restricted, but according to the prosecution, their story is as per exhibit P61, my lord. Just I will tell the story, my lord, to show that this conduct or intention, there is no conduct or intention and absence of intention, my lord. Page 350, my lord. Exhibit P61. ನಂತರ ನಾನು ಮತ್ತು ಮಂಜುನಾಥ ಇಬ್ಬರು
page
350, my lord.
350.
Yes.
That's voluntary statement.
Yes, my lord. In that story is narrated by the IO, my lord. I'm not giving the what is the story of the prosecution, my lord.
Counsel, whether court can look into the voluntary statement.
No, my lord. But
I don't know why you are referring. Why you are referring inadmissible evidence before the court?
If just to show that what was there.
ತೋರಿಸಿದ್ರು court cannot look into that.
Yes, my lord.
Why you are showing inadmissible evidence before the court?
Yes, my lord. Contradiction in the prosecution case for that purpose, my lord. First,
even for contradictions also.
Yes, my lord.
Voluntary statement cannot be relied upon.
Yes, my lord. Because
if it is 161 statement, it can be relied upon. Contradictions.
Yes, my lord. No, just to show you what is the story of the that for that I am not relying upon.
Even if it is shown also.
Yes, my lord.
Court cannot take the voluntary statement remaining portion other than recovery.
Yes, my lord. Yes, my lord. Here, just I will narrate, my lord. That's
I don't know why you are repeatedly reading the voluntary statement.
Yes, my lord. I will leave it, my lord. Now, when Sun has not stated anything regarding the illicit relationship, when
you are arguing for acquittal of A1 and A2, A3 argued yesterday.
Yes, ma'am.
What are the material relied upon by the prosecution against you about A1 and A2? You point out. That's all.
Yes, ma'am. Now, my lord.
If trial court committed an error in relying upon the evidence, which is not trustworthy, and not reliable, then you point out.
Yes, ma'am. First of all, the recovery of the blood-stained clothes and blood-stained mud. That's a very important. It's one of the circumstances which heavily relied upon by the trial court, my lord. Now I will take your lordship to the FSL evidence, my lord. PW 26, page 205. My lords, 14 items were sent to him for FSL report, and he says except item number 6, all were blood stained, contained human blood of AB group. That was his finding recorded by him, my lord, except item number 6.
Yes.
Item number 6 appears to be a blood of the deceased.
Sample blood.
Regarding the recovery of the sample, as per MO6, there is no evidence has been adduced before the court, my lord. Even IO failed to state that, my lord. And no other witnesses have stated regarding the MO. And whose blood it is, nobody has stated, my lord. This AB positive group blood on this MO 1 to 5, 6 to 14 belong to whom? None have stated. The medical evidence FSL is PW 26 and doctor is PW 27, my lord. Both of them have not stated anything. Now, my lord, left out is IO, my lords. IO's evidence has been recorded. He stated nothing regarding the collection of blood by him, my lord. I will take a lordship to the page 233, PW 41. My lord, before this, my lord, where blood was collected, I will trace it back to the inquest Panchanama, my lord. At page 243, my lords, then there is a reference of the collection of the blood in the statement. Here, my lord, that shall be corroborated by the IO because FSL expert has not stated anything regarding collection of the blood and sending it to IO. Now, I will take a lordship to the evidence of PW 41, page 233. In the entire evidence, nowhere he states that I have collected the blood, packed it, nothing is. Just I will read that Panchanama, my lords. ನಾನು ದಾವಣಗೆರೆ ಗ್ರಾಮಾಂತರ ಸೇರಿದಲ್ಲಿ ಸೋಣಿಸೋರಲ್ಲಿ ಈ ಪ್ರಕರಣದ ಕಳೆದ ರೇವಣ ಸಿದ್ದಪ್ಪ SI ಅವರಿಂದ ಪಡೆದಿರುತ್ತೇನೆ. ದಾವಣಗೆರೆ ತಹಶೀಲ್ದಾರಿಗೆ 2 ಪಂಚರಸ ನೇಮಿಸಿ ಕಳಿಸುವಂತೆ ಮನವಿ ಸಲ್ಲಿಸಿ ನಂತರ ಕೃತ್ಯದ ನಡೆದ ಸ್ಥಳದ ಬಗ್ಗೆ ಭೇಟಿ ನೀಡಿರುತ್ತೇನೆ. ತಹಶೀಲ್ದಾರರು ಕಳಿಸಿದ ಪಂಚಸಾಕ್ಷಿ ಬಸವರಾಜ ಮಂಜುನಾಥ್ ಇವರು ಸಮಕ್ಷಮ ಕೃತ್ಯ ನಡೆದ ಸ್ಥಳ ಮಹಜರ್ ನಿಶಾನೆ P2 ರಂತೆ ಮಾಡಿರುತ್ತೇನೆ. ಅದರಲ್ಲಿ ನನ್ನ ಸಹಿಯನ್ನು ನಿಶಾನೆ P2 EC ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ಪಂಚನಾಮೆ ಕಾಲಕ್ಕೆ ಮುದ್ದೆ ಮಾಡಿದ 1 ರಿಂದ 8
Continue at 2:30.
My lord, tomorrow kindly, my lord. Tomorrow I will continue, my lord.
No counsel, no parted matter. That's why yesterday I asked and then only we will.
Yes, sir. Tomorrow I will continue. Tomorrow I will continue, my lord. Some inconvenience, personal inconvenience, for the personal inconvenience, for that purpose, my lord. Tomorrow I will argue the matter.
Third, heard the counsel appearing for the appellant, that is accused number 1 and 2 in part, and seeks time and hence list this matter tomorrow. Nale kaksiman.
Yes, ma'am.
You may make one submission respect to serial number 15, lordship.
Serial number
15, lordship, 15. Lordship has posted this matter on Friday. Lordship, I may not be available on Friday. Kindly have it on Monday, lordship.
Counsel, your colleague was there at the time of adjourning the matter.
He was not aware, lordship, because I have a listing here in Delhi on Friday, lordship. For that reason only I am requesting, lordship.
Avrena insist madidru, other side idara Prasanna Kumar.
I will
in Delhi and
he
will not come back to Bengaluru. He will come back only at Monday. ಆಯ್ತು ಮಂಡೆಗೆ ಹಾಕಿಂದ ಡೇಟ್ ನೋಡಿ ಮೇಡಮ್ ಅದು ನೋಡ್ಕೊಳ್ಳಿ. ತಗೊಂಡಿದ್ದಾರೆ ಡಿಕ್ಟೇಷನ್ ತಗೊಂಡವ್ರಿಗೆ ಹೇಳಿ ಮಂಡೆಗೆ ಹೇಳಿ.
Deeply obliged.
ಅದು ನನಗೆ ಓದುವುದೇ
ಕಂಟಿನ್ಯೂ ಮೇಡಮ್ ಕಂಟಿನ್ಯೂನಾ
ಇಲ್ಲ ಇಲ್ಲ ಇದು ಕಂಟಿನ್ಯೂ ಇಲ್ಲ.
ಲಿಸ್ಟ್ ಮುಗಿತಾ?
ಹೇಳಿ ಸರ್. ಹಾ ಪಾಸ್ವರ್ಡ್ 18 ಹೌದು ಹೀಗಿದೆ ಆಯ್ತಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಎಲ್ಲ 2 ಪಾಸ್ವರ್ಡ್ ಇದೆ. ಪಾಸ್ವರ್ಡ್ ಆದ್ಮೇಲೆ ಬೇಗ ಹಾಕ್ಬಿಡ್ಬೋದು. ಇಲ್ಲ ಇದಕ್ಕೆ ಏನಂದ್ರೆ ನಮ್ಮ ಮನೆಯವರು ಬೆಳಿಗ್ಗೆ ಆಫೀಸಲ್ಲಿ ಟೀ ಕುಡಿ ಅಂದ್ರೆ ನನಗೆ ಬೆಳಿಗ್ಗೆ ಅದಕ್ಕೆ ಒಂಥರ ಕಾಫಿನೇ ಕುಡಿ
to get the details from the PO, how many evidences are recorded in the month and how many cases are disposed of by the PO, particularly the oldest cases, and submit the list within 1 week from today. List this matter on 19/2. The registry is directed to communicate this letter to the PO forthwith. Allah hakpidi. The PO is directed to prepone the cases in the 3rd week of February and take up the matter day-to-day basis with intimation to the respective council and parties. Antamadi.
As in order to dispose this oldest appeal in the state.
The appeal which is pending before this court is the oldest appeal pending before the High Court for disposal in view of the earlier direction given by this court to take up the appeal in after the disposal of the sessions cases which are pending before the trial court.
11. Kanarawa.
Please.
ಏನ್ರಿ ಇದು ಮೆಮೊ?
ಮೆಮೊ ಐಎಗೆ ಕೊಡ್ತೀನಿ. ಐಎ ನಂಬರ್ 2 ಗೆ ಸರ್.
ಮತ್ ಪಿಟಿಷನ್ ಅಪೀಲ್ ನ ವಿಡ್ರಾ ಮಾಡಕ್ಕೆ ಅಂತ ಮೆಮೊ ಹಾಕಿದ್ರಿ? Third, counsel for the appellant files memo not pressing the IA number 2 and seeks permission of this court to withdraw the IA and hence permitted to withdraw in view of the memo. ಎಷ್ಟನೇದು serial number 11. ಅದರಲ್ಲಿ ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆ ಮೇಡಮ್? ಅಡ್ಮಿಷನ್ ಆಗಿಲ್ಲಲ್ಲ?
ಅಡ್ಮಿಷನ್ ಆಗ್ಬೇಕು.
ಲಿಸ್ಟ್ ಅಡ್ಮಿಷನ್ ಕೊಡಿ ಮಾಡಬಿಡೋಣ ಏನಿದೆ ಇದರಲ್ಲಿ. ಕನ್ವಿಕ್ಷನ್ ಅಪೀಲ್ ಅಲ್ಲ?
ಹೌದು ಸರ್. ಲೈಫ್ ಇಂಪ್ರಿಸ್ಮೆಂಟ್ ಇದೆ.
ಅಪೀಲ್
302
is arising out of the conviction and sentence for the offence punishable under section 302 of IPC section 498 of IPC. And in view of matter is a conviction appeal, matter requires reconsideration. Admit. The registry is directed to get the records of SAR forthwith and immediately after securing the records, prepare the paper book within 8 weeks. List this matter for final disposal as soon as paper book is ready. First ಆಗಿಲ್ವಾ ನಿಮ್ಗೆ ನೋಟಿಸ್ ಆಗಿಲ್ವಾ? ಫಸ್ಟ್ ಟೈಮ್ ಆಯ್ತು ತಗೊಳ್ಳಿ. ಅಡಿಷನಲ್ SPP takes notice for respondent. ಫಸ್ಟ್ ಆಕ್ಟ್ ಮಾಡಿ.
Finally, matter 18. NS Sampangi Ramaya, Karyappa in.
Three not seven ಗೆ acquittal.
498 conviction.
498 3 years 10,000.
ಈ ಮಾರ್ಟಿನ್ ಅಂಡ್ ಮಸ್ಕಿಟೋ ರೆಪೆಲೆಂಟ್ ಇರುತ್ತಲ್ಲ ಸರ್. ಮಾರ್ಟಿನ್ ಅಂಡ್ ಮಸ್ಕಿಟೋ ರೆಪೆಲೆಂಟ್ ಸ್ಪ್ರೇ ಸ್ಪ್ರೇ ಮಿನಿಸ್ಟರ್.
ಎಸ್ ಫಸ್ಟ್ ಅಪೀಲ್ ಯಾರು ನಿಮ್ದ? ಅಕ್ವಿಟಲ್ ಯಾರ್ದು? ಹಾ ಯಾರು ಮಾಡ್ತೀರಿ ಹೇಳಿ ಫಸ್ಟ್. ಮುಗ್ದೆ ಹೋಗುತ್ತೆ ನಿಮ್ದೇನಿಲ್ಲ. ಆಯ್ತು ಹೇಳಿ. Then why you have filed appeal? ಹೇಳ್ರಿ ನಿಮ್ದೇನ್ ಹೇಳಿ.
Please,
818 ನಾ?
my lord,
818 not.
that this A2 died, my lord, abated.
A2?
A2 is no
Abate
more
ಆಗಿದೆಯಾ?
abate ಆಗಿದೆ.
ಈಗ after filing of appeal?
After filing appeal, my lord, that
Bring
has been
appeal.
recorded. Only accused number 1 is the husband, your lordship.
A1.
A1 husband. My lord, A3, she is the mother-in-law. My lord, this PW1, my lord, Ruxana Khanam, she was married to accused number 1 in the year 2002.
Marriage 2002.
2002, my lord.
2000?
2002. They lived, my lord, together for 11 years.
11 years.
She is from Nanjangud. He is accused, my lord, from Kollegal town. My lord, they had 2 sons, my lord, from their wedlock. There used to be some differences, my lord, in between husband and wife. My lord, on 19/9/2013, there was some quarrel. My lord, on 20th morning at 9 a.m., when this husband was not there at home, my lord, she said to have consumed this good night mosquito coil, my lord. Immediately, this was informed to husband, who was a fabricator. He was in his workshop. On coming to know that, he rushed to the house, taken his wife to government hospital, Kollegal. There, my lord, she has given a history that she self-consumed good night coil and Martin mosquito, Allah, this cockroach insecticide. The doctor PW8, my lord, examined her and treated her, and she was discharged. My lord, thereafter, my lord, a complaint was lodged on the same evening. My lord, this fact of that she had consumed this insecticide was informed by accused number 1 husband to PW4, father of PW1, who was at Nanjangud. Then he and his wife, that is mother of victim, they rushed to Kollegal Government Hospital. My lord, thereafter, my lord, exit P1 complaint was lodged, alleging that this accused number 1 has administered and attempt to kill her by administering this. Upon this, my lord, FIR for 7 and 498A was registered. And this accused, my lord, accused number 1, who was in hospital, he was taken to custody. He remained in custody for about 20 days. Thereafter, he was granted bail. Charge sheet was filed against accused number 1, 2, 3. My lord, a charge was framed, my lord, by the trial court. The allegation only, my lord, that he was suspecting her if
fidelity.
Not fidelity, my lord, that he was suspecting that if she looks to somebody like that, my lord, there is no specific allegation that she had developed any intimacy with anyone. There is no such. This accused her to be always a suspicious character. He was not allowing her to be openly in the family. He has 2 brothers, and he used to see that his wife should remain in room. Should not be exposed to the family members like that. This is the allegation she has narrated. That was not the fact, my lord, but to lodge a complaint, these kind of things is developed. My lord, I take your lordship to the charge, your lordship. Charge is at page 6, my lord. ದಿನಾಂಕ 20/9/2013 ಬೆಳಿಗ್ಗೆ 9:30 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಕೊಳ್ಳೇಗಾಲ ಟೌನಿನ ಹೊಸ ಕುರುಬರಪೇಟೆಯಲ್ಲಿ ಇರುವ ಮನೆ ನಂಬರ್ 7941ರಲ್ಲಿ ಸಾಕ್ಷಿ 1 ರುಕ್ಸಾನಾ ಬೇಗಂರವರು ಇರುವಾಗ ನೀವು ಒಂದೇ ಆರೋಪಿ ಹಿಂದಿನ ದಿನಗಳಂತೆ ಜಗಳ ತೆಗೆದು ನೀನೇನಾದರೂ ಕುಡಿದು ಸಾಯದೆ ಇನ್ನೂ ಬದುಕಿದೆಯಾ ಅಲ್ಲ ಎಂದು ಪ್ರೇರೇಪಿಸಿದಾಗ ಸಾಕ್ಷಿ 1ರವರು ಗುಡ್ ನೈಟ್ ಮತ್ತು ಮಾರ್ಟಿನ್ ಕ್ರಿಮಿನಾಶಗಳನ್ನು ಎತ್ತಿಕೊಂಡಾಗ ನೀವು 1ನೇ ಆರೋಪಿ ಬಲವಂತವಾಗಿ ಕುಡಿಸಿ ಕೊಲೆ ಮಾಡಲು ಪ್ರಯತ್ನಿಸಿದ್ದು ಹಾಗೂ 2 ಮತ್ತು 3ನೇ ಆರೋಪಿಗಳಾದ ನೀವು ಸಮಾನ ಉದ್ದೇಶದಿಂದ ಈ ಹಿಂದಿನಿಂದಲೂ 1ನೇ ಆರೋಪಿಯವರ ಜೊತೆ ಸೇರಿಕೊಂಡು ಸಾಕ್ಷಿ 1ರವರಿಗೆ ಮಾನಸಿಕ ಮತ್ತು ದೈಹಿಕ ಹಿಂಸೆ ನೀಡುತ್ತಿರುವುದರಿಂದ ಭಾರತದ ಕಲಂ 498A 307 ಸಹೋಚ್ಚಕ 34ರಡಿ ಅಪರಾಧವನ್ನು ಎಸಗಿರುತ್ತೀರಿ. ಸದರಿಯ ಆರೋಪದ ಮೇಲೆ ನೀವು ಆರೋಪಣೆಗಳ ವಿಚಾರಣೆ ಗುರಿಯಾಗತಕ್ಕದ್ದೆಂದು ಮೂಲಕ ಆದೇಶಿಸುತ್ತೇನೆ. Pleaded not guilty. Now, my lord, I take your lordship to the complaint, your lordship. Exhibit P1 complaint at page 119, my lord. रुखसाना खानम कम अब्दुल बासिद 30 ವರ್ಷ ಗೃಹಿಣಿ ಮುಸ್ಲಿಂ ಜನಾಂಗ 7/23 ಹೊಸ ಕುರುಬರ್ ಬೀದಿ ಕೊಳ್ಳೇಗಾಲ ಪಟ್ಟಣ ದಿನಾಂಕ 20/9/2013.
ಫಸ್ಟ್ 10 ಲೈನ್ಸ್ ಬೇಡ, ಮುಂದಿನ ಹೇಳಿ ಸಾಕು.
ನನಗೆ 10 ವರ್ಷದ ಮೊಹಮ್ಮದ್ ಲುಕ್ಮಾನ್ 7 ವರ್ಷದ ಮೊಹಮ್ಮದ್ ರಯಾನ್ ಎಂಬ 2 ಗಂಡು ಮಕ್ಕಳಿರುತ್ತಾರೆ. ನಾನು ನನ್ನ ಸಂಸಾರದ ಜೊತೆ ಹೊಸ ಕುರುಬರ್ ಬೀದಿಯ ಮನೆ ನಂಬರ್ 7/23 ವಾಸವಾಗಿದ್ದೆವು. ನನಗೂ ನನ್ನ ಗಂಡ ಅಬ್ದುಲ್ ಬಾಸನಿಗೆ ಮದುವೆ ಆದಾಗಿನಿಂದ ಸಂಸಾರದಲ್ಲಿ ಅನ್ಯೂನ್ಯತೆ ಇಲ್ಲದೆ ಯಾವಾಗಲೂ ನನ್ನ ಮೇಲೆ ನನ್ನ ಗಂಡ ಸಂಶಯ ಪಡುತ್ತಿದ್ದು ನನ್ನ ಮೇಲೆ ಹೊಡೆದು ಬಡಿದು ದೌರ್ಜನ್ಯ ಎಸಗುತ್ತಿದ್ದರು. ನಾನು ಕ್ರಮೇಣ ಸರಿ ಹೋಗಬಹುದೆಂದು ಅನುಸರಿಸಿಕೊಂಡು ಜೀವನ ಮಾಡಿಕೊಂಡು ಬಂದೆ. ಈಗ ಹಾಲಿ 2 ಮಕ್ಕಳಿದ್ದರೂ ಸಹ ನನ್ನ ಗಂಡ ನನ್ನ ಮೇಲೆ ಆಗಾಗ ಹೊಡೆದು ನಿನಗೆ ಯಾರ ಜೊತೆಯಾದರೂ ಹೋಗ್ಬೇಕೆನ್ನುವ ಹಾಗಿದ್ದರೆ ಅವನ ಜೊತೆ ಓಡಿ ಹೋಗು, ನನ್ನ ಮನೆಯಲ್ಲಿ ನಿನಗೆ ಜಾಗವಿಲ್ಲ ಇತ್ಯಾದಿಯಾಗಿ ಕಿರುಕುಳ ನೀಡುತ್ತಾ, ಜೊತೆಗೆ ನನ್ನ ಮಾವ ಅಬ್ದುಲ್ ಗಫಾರ್ ಮತ್ತು ಅತ್ತೆ ರಾಫಿಯಾ ಬೇಗಂರವರು ಸಹ ಮಗನ ಜೊತೆ ಸೇರಿಕೊಂಡು ಆಗಾಗ ನನಗೆ ಕಿರುಕುಳ ನೀಡುತ್ತಾ ತಮ್ಮ ಮಗನಿಗೆ ಕುಮುಕು ನೀಡಿ ಸದರಿಯವರುಗಳ ಎದುರಿಗೆ ನನ್ನ ಗಂಡ ಹೊಡೆಯುತ್ತಿದ್ದರೂ ಸಹ ಬಿಡಿಸದೆ ಮೂಕ ಪ್ರೇಕ್ಷರಾಗಿ ವರ್ತಿಸುತ್ತಿದ್ದರು. ಈ ವಿಚಾರವನ್ನು ನನ್ನ ಮದುವೆಯಾದ 3 ವರ್ಷದ ನಂತರ ನಮ್ಮ ತಂದೆ ತಾಯಿಯವರಿಗೆ ತಿಳಿಸಿದ್ದೆ. ಸದರಿಯವರುಗಳು ಈ ಸಂಬಂಧ ನನ್ನ ಗಂಡನ್ನು ಕರೆಯಿಸಿ ಬುದ್ಧಿವಾದ ಹೇಳುತ್ತಿದ್ದರು. ಅಲ್ಲದೆ ನಮ್ಮ ಅತ್ತೆ ಮಾವರ ಜೊತೆ ಸಹ ಅನೇಕ ಬಾರಿ ನ್ಯಾಯ ಪಂಚಾಯತ್ ನಡೆಸಿದ್ದರೂ ಸಹ ನನ್ನ ಮೇಲಿನ ದೌರ್ಜನ್ಯ ನಿರಂತರವಾಗಿ ಸಾಗುತ್ತಲೇ ಇತ್ತು. ಹೋದ ವರ್ಷ ಇದೇ ರೀತಿ ನನಗೂ ನನ್ನ ಯಜಮಾನರಿಗೂ ಗಲಾಟೆಯಾಗಿ ನನ್ನನ್ನು ಮತ್ತು ನನ್ನ ಮಕ್ಕಳನ್ನು ಕಾರಿನಲ್ಲಿ ಕರೆದುಕೊಂಡು ಹೋಗಿ ನನ್ನ ತಂದೆ ಮನೆಗೆ ಬಿಟ್ಟು ಹೊರಟು ಬಂದಿದ್ದರು. ಆ ನಂತರ ನಮ್ಮ ತಂದೆ ಮತ್ತಿತರು ನನ್ನನ್ನು ಕೊಳ್ಳೇಗಾಲಕ್ಕೆ ಕರೆದುಕೊಂಡು ಬಂದು ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ನಲ್ಲಿ ನ್ಯಾಯ ಪಂಚಾಯತಿ ಮಾಡಿ ಸ್ವಲ್ಪ ದಿನ ನನ್ನನ್ನು ನಮ್ಮ ತಂದೆ ಮನೆಯಲ್ಲೇ ಇರುವಂತೆ ತೀರ್ಮಾನ ಮಾಡಿದ್ದರು. ಆಗ ನನ್ನ ಯಜಮಾನರು ನಮ್ಮ ತಂದೆ ಮನೆಗೆ ಬಂದು ಹೋಗುತ್ತಿದ್ದರು. ಅಲ್ಲದೆ ನಮ್ಮ ತಂದೆ ಮನೆಯಲ್ಲೇ ವ್ಯಾಸಂಗ ಮಾಡುತ್ತಿದ್ದ ನನ್ನ ಮಕ್ಕಳಿಗೂ ಕೂಡ ಮನಸ್ಸು ಕೆಡಿಸುತ್ತಿದ್ದರು. ಹೋದ ಜುಲೈ ತಿಂಗಳಿನಲ್ಲಿ ನನ್ನ ಯಜಮಾನರೇ ನನ್ನನ್ನು ನನ್ನ ಮಕ್ಕಳನ್ನು ಕೊಳ್ಳೇಗಾಲಕ್ಕೆ ಕರೆದುಕೊಂಡು ಬಂದು ಮಕ್ಕಳನ್ನು ನಿಸರ್ಗ ವಿದ್ಯಾನಿಕೇತನಕ್ಕೆ ಸೇರಿಸಿದವು. ಕೊಳ್ಳೇಗಾಲಕ್ಕೆ ಬಂದ ಸ್ವಲ್ಪ ದಿನಕ್ಕೆ ನಾನು ಊರಿನಲ್ಲಿ ಬಿಟ್ಟು ಬಂದಿದ್ದ ಎಲ್ಲಾ ಒಡವೆಗಳನ್ನು ತೆಗೆದುಕೊಂಡು ಬಾ, ಅವುಗಳನ್ನು ಮಾರಿ ನನ್ನ ಮಗ ಬೇರೆ ಯಾವುದಾದರೂ ವ್ಯಾಪಾರ ಮಾಡಲಿ ಎಂದು ನಮ್ಮ ಅತ್ತೆ ಮಾವ ಪೀಡಿಸುತ್ತಿದ್ದರು. ಜೊತೆಗೆ ನನ್ನ ಗಂಡನೂ ಸಹ ಹೋಗಿ ತರುವಂತೆ ಪ್ರತಿನಿತ್ಯ ಜಗಳ ಮಾಡುತ್ತಿದ್ದರು. ನಿನ್ನೆ ದಿನ 19/9/2013 ರಾತ್ರಿ ಮಾಮೂಲಿನಂತೆ ನಮ್ಮ ಅತ್ತೆ ಮಾವರವರಿಗೆ ಊಟ ಬಡಿಸಿ ನಂತರ ಡೈನಿಂಗ್ ಹಾಲ್ನಲ್ಲಿ ಕ್ಲೀನ್ ಮಾಡುತ್ತಿರುವಾಗ ನನ್ನ ಯಜಮಾನರು ಬಂದು ಇಲ್ಲಿ ಯಾಕೆ ನಿಂತಿದ್ಯಾ, ಯಾರನ್ನು ನೋಡುತ್ತಿದ್ಯಾ ಎಂದು ಜಗಳ ಮಾಡಿದರು. ನಾನು ಮನಸ್ಸಿಗೆ ತುಂಬಾ ಬೇಸರವಾಗಿ ಬೇರೆಯಾಗಿ ಮಲಗಿಕೊಂಡಾಗ ನನ್ನ ಮಕ್ಕಳನ್ನು ಏಳಿಸಿಕೊಂಡು ಇವಳಿಗೆ ನಮ್ಮ ಜೊತೆ ಇರಲು ಇಷ್ಟವಿಲ್ಲ, ಬೇರೆ ಕಡೆ ಹೋಗೋಣ, ಒಟ್ಟು ಇವಳಿಗಲ್ಲದೆ ಇವಳ ಅಪ್ಪ ಅಮ್ಮನಿಗೂ ಸರಿಯಾದ ಪಾಠ ಕಲಿಸುತ್ತೇನೆ ಎಂದು ಹೊರಟು ಹೋದರು. ನಾನು ರಾತ್ರಿಯೆಲ್ಲ ತುಂಬಾ ಯೋಚನೆ ಮಾಡಿ ಈ ದಿನ 20/9/2013 ಬೆಳಿಗ್ಗೆ 9:15 ಗಂಟೆಯಲ್ಲಿ ನನ್ನ ಗಂಡ ಮತ್ತೆ ಜಗಳ ತೆಗೆದು ನೀನು ಏನಾದರೂ ಕುಡಿದು ಸಾಯದೆ ಇನ್ನೂ ಬದುಕಿದೆಯಲ್ಲ ಎಂದು ಪ್ರಯತ್ನಿಸಿದಾಗ ನಾನು ಅಲ್ಲೇ ಇದ್ದ ಗುಡ್ ನೈಟ್ ಮತ್ತು ಮಾರ್ಟಿನ್ ಅನ್ನು ಎತ್ತಿಕೊಂಡಾಗ ನನ್ನ ಗಂಡ ನನ್ನ ಕೈಲಿದ್ದ ಗುಡ್ ನೈಟ್ ಮತ್ತು ಮಾರ್ಟಿನ್ ಅನ್ನು ಕಿತ್ತುಕೊಂಡು ನನ್ನ ಮೂಗನ್ನು ಹಿಡಿದುಕೊಂಡು ಕುಡಿದು ಸಾಯಿ ಎಂದು ಕೀಟನಾಶಕವನ್ನು ಬಾಯಿಗೆ ಬಲವಂತವಾಗಿ ಹಾಕಿ ಕುಡಿಸಿದರು. ಆಗ ನಾನು ಎಷ್ಟೇ ಕೂಗಿಕೊಂಡರೂ ಯಾರೂ ಬರಲಿಲ್ಲ. ಆಗ ನನಗೆ ತುಂಬಾ ಸುಸ್ತಾಗಿ ಬೆವರುತ್ತಾ ಕುಸಿದು ಬಿದ್ದೆ. ಆಗ ನನ್ನ ಗಂಡ ಹೆದರಿ ನನ್ನನ್ನು ಕೊಳ್ಳೇಗಾಲದ ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಗೆ ಕರೆದುಕೊಂಡು ಬಂದು ಸೇರಿಸಿದರು. ಅವರೇ ಕರ್ಕೊಂಡು ಹೋಗಿ ಸೇರಿಸ್ತಾರ. ಇಲ್ಲಿ ಡಾಕ್ಟರ್ ನನ್ನನ್ನು ವಿಚಾರಿಸಿದಾಗ ನನ್ನ ಗಂಡ ನನಗೆ ಮಾತನಾಡಲು ಬಿಡಲಿಲ್ಲ. ನನ್ನ ಮೇಲೆ ಮದುವೆ ಆದಾಗನಿಂದಲೂ ಕಿರುಕುಳ ನೀಡುತ್ತಾ, ಜೊತೆಗೆ ನನ್ನ ಅತ್ತೆ ಮಾವರು ಸಹ ನನ್ನ ಗಂಡನ ಜೊತೆ ಸೇರಿಕೊಂಡು ದೈಹಿಕವಾಗಿ ಮತ್ತು ಮಾನಸಿಕ ಕಿರುಕುಳ ನೀಡುತ್ತಾ, ಈ ದಿನ ನನ್ನ ಗಂಡ ಬಲವಂತವಾಗಿ ಕೀಟನಾಶಕ ಮಾರ್ಟಿನ್ ಮತ್ತು ಗುಡ್ ನೈಟ್ ಕುಡಿಸಿ ಕೊಲೆ ಮಾಡಲು ಪ್ರಯತ್ನಿಸಿದ್ದು.
ಈ ಹಿಂದೆ ಪಂಚಾಯತ್ ಮಾಡಿದ್ದು, ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಹೋಗಿದ್ದು, ಅದಕ್ಕೆ ಏನಾದ್ರು ರೆಕಾರ್ಡ್ಸ್ ಹಾಕಿದಾರ?
ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಹೋಗಿದ್ದು a fact it was. At that time, police, this PW9 PSI Mahadevanta, he has ascertained there was no act of cruelty on the part of this accused. He did not register 498A. He has advised her remain with the husband, but she went back to Nanjangud, started residing with her parents. This fact is there in the record. But Panchayati ಬಗ್ಗೆ PW7 ಮತ್ತು 9 ಅನ್ನು ವಿಚಾರಣೆ ಮಾಡಿದ್ದಾರೆ. They have not supported, there is no such panchayat at all. They have turned hostile. PW2 and 3 are the spot Mahazar witnesses. No neighbor is examined. PW4, 5 are the parents. PW1 is this lady. And PW7 is the maternal uncle. They were all at Nanjangud.
PW6, not 7.
4, 5, 6.
6.
4, 5, 6.
Chikkappa.
Yes, Chikkappa. Andre, this is her mother's brother, please.
Maternal uncle.
Maternal uncle. And this PW7 and 9, my lord, is said to be the panchayat member. They have not supported. And neighbors are there. It is in thickly populated area. Their house was located. None of the neighbors have been examined. 11 years they led marital life. Well, there used to be some differences. This accused, my lord, he was following religious, my lord, very seriously. The PW1, my lord, she has studied BCom and computer course. She was not inclined to remain in home always. Regarding this, there used to be incompatibility, always some discussion and talks, my lord. Verbal talk was there. Barring this, my lord, there was nothing. Her father was very affluent, therefore she wants to remain in their house. And this accused number 1, my lord, he was only a fabricator. He had a small workshop, he used to do some welding work. My lord, their life was only for sustenance of the day to day. Nothing more, my lord, he had.
What is the history was given before the court?
Self-consumption, self-consumption, self-consumption.
History.
Yes.
Who gave?
Herself. Dr. PW8 says.
Doctor says.
Yeah, doctor says.
She only gave the statement.
Yes.
Self-consumption.
Yes, and recorded in the MLC register also. Now, after the arrival of father at 5 p.m., he has incited.
What time she was taken to the hospital?
At 9:30 or 10:30, my lord.
10:30. In the early morning.
Morning it had happened. Morning it had happened at 9:30, and she was taken to hospital at 10:15 p.m. 10:15 a.m.
10:15.
ಅದೇ ದಿನ ಬೆಳಗ್ಗೆ 9ರ ಸಮಯದಲ್ಲಿ ಸದರಿ ರುಕ್ಸಾನ ಖಾನಂರವರ ಮೇಲೆ ಹೇಳಿದ ಮಾರ್ಟಿನ್ ಮತ್ತು ಗುಡ್ ನೈಟ್ ಎಂಬ ದ್ರವ ರೂಪದ ವಿಷವಸ್ತುವನ್ನು ಕುಡಿದಿದ್ದರು.
ತಂದೆ ಬಂದ್ಮೇಲೆ ಯಾಕಂದ್ರೆ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದು ಸಂಜೆ.
But whether police have informed the hospital authority, have informed the police or not?
Doctor required to inform, but there is no such evidence. After arrival of father, accused number 1 only informed.
What time father arrived?
5 p.m.
Evening.
Yes. After his arrival, discussed with daughter, and exhibit P1 complaint was lodged.
Yes.
At his instigation. It is he who was cross-examination suggestion illa. It is he who is responsible for creating all these disturbance. He was always expecting that repeatedly the daughter should be in his house. And 2 children were there, they were very active. He was liking these children. Therefore, daughter and children should be every week and should be in my house. Regarding this, this accused was not able to subscribe so much. He was not liking this.
Go to cross-examination of PW1. What is the answer elicited from the mouth of PW1? Cross.
Yes, 63.
Page 63 में लौट लो.
Page 63.
ಪಾರ್ಟಿ ಸವಾಲು ಆರೋಪಿಗಳ ವಕೀಲರಾದ MD ರವರಿಂದ ನನಗೆ ವಿಷ ಕುಡಿಸಲಾಗಿತ್ತು ಮತ್ತು ಆ ಕಾರಣದಿಂದ ನನ್ನನ್ನು ಆಸ್ಪತ್ರೆಗೆ ಸೇರಿಸಲಾಗಿತ್ತು. ಗುಡ್ ನೈಟ್ ಲಿಕ್ವಿಡೇಟರ್ ಕಂಟೈನರ್ ನಲ್ಲಿ ಇದ್ದ ವಿಷವನ್ನು ನನಗೆ ಕುಡಿಸಿದ್ದರು. ವಿಷವನ್ನು ನನ್ನ ಗಂಡನು ನನಗೆ ಕುಡಿಸಿದ್ದರು. ನನ್ನ ಗಂಡನು ಆ ರೀತಿ ನನಗೆ ವಿಷ ಕುಡಿಸಿದಾಗ ಬೆಳಿಗ್ಗೆ 9 ಗಂಟೆ ಸಮಯ ಆಗಿತ್ತು. ಮಸ್ಕಿಟೋ ರೆಪಲೆಂಟ್ ನಮ್ಮ ಮನೆಯಲ್ಲಿ ಇದ್ದೆ. ನನ್ನ ಗಂಡನು ನನಗೆ ಆ ವಿಷ ವಸ್ತುವನ್ನು ಕುಡಿಸಿದಾಗ ಆ ಕಂಟೈನರ್ನಲ್ಲಿ ಅರ್ಧ ಭಾಗಕ್ಕಿಂತ ಹೆಚ್ಚು ವಿಷ ವಸ್ತು ಇತ್ತು. ಮಸ್ಕಿಟೋ ರೆಪಲೆಂಟ್ ಪಕ್ಕದಲ್ಲಿಯೇ ಮಾರ್ಟಿನ್ ಕಂಟೈನರ್ ಸಹ ಇತ್ತು. ಸದರಿ ಮಾರ್ಟಿನ್ ಕಂಟೈನರ್ ನಲ್ಲಿ ಇದ್ದ ವಸ್ತುವನ್ನು ಸಹ ನನ್ನ ಮುಖದ ಮೇಲೆ ನನ್ನ ಗಂಡನು ಸ್ಪ್ರೇ ಮಾಡಿದರು. ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ಇರುವ ಮುದ್ದೆಮಾಲು 1 ಅಂದರೆ ಮಾರ್ಟಿನ್ ಕಂಟೈನರ್ ಈಗ ಇರುವ ರೀತಿಯಲ್ಲೇ ಘಟನೆ ಆಯಿತು ಎಂದು ಹೇಳುವ ಸಮಯದಲ್ಲೂ ಹಾಗೆಯೇ ಇತ್ತು. ಹೇಗೆ ಎಂದರೆ ಘಟನೆ ಸಮಯದಲ್ಲಿ ಆ ವಸ್ತುವಿನ ಮೇಲೆ ಒಂದು ಕ್ಯಾಪ್ ಇತ್ತು. ನನ್ನ ಗಂಡನು ನನ್ನ ಮುಖದ ಮೇಲೆ ಮಾರ್ಟಿನ್ ಕಂಟೈನರ್ ಸ್ಪ್ರೇ ಮಾಡಿದಾಗ ನಾನು ಬಿಡಿಸಿಕೊಳ್ಳಲು ಪ್ರಯತ್ನ ಪಟ್ಟನು ಮತ್ತು ಆ ಸಮಯದಲ್ಲಿ ಮುದ್ದೆಮಾಲು 1 ವಸ್ತುವಿನ ಮೇಲೆ ಇದ್ದ ಮುಚ್ಚಳ ಅಥವಾ ಕ್ಯಾಪ್ ಬಿದ್ದು ಹೋಗಿದೆ. ಘಟನೆ ಆದ ದಿನದ ಹಿಂದಿನ ದಿನವೂ ಸಹ ಮುದ್ದೆಮಾಲು 1 ವಸ್ತು ನಮ್ಮ ಮನೆ ಶೋಕೇಸ್ನಲ್ಲಿಯೇ ಇತ್ತು. ಮುದ್ದೆಮಾಲು 2 ಸಹ ಶೋಕೇಸ್ನಲ್ಲಿಯೇ ಇತ್ತು. ಶೋಕೇಸ್ ನಮ್ಮ ಮನೆ ಹಾಲ್ನಲ್ಲಿ ಇದೆ. ನನ್ನ ಗಂಡನು ನಮ್ಮ ಮನೆಯ ಹಾಲ್ನಲ್ಲಿಯೇ ನನಗೆ ವಿಷ ಕುಡಿಸಿದ್ದಾರೆ. ನನ್ನನ್ನು ಆಸ್ಪತ್ರೆಗೆ ನನ್ನ ಗಂಡನೇ ಕರೆದುಕೊಂಡು ಹೋಗಿದ್ದಾರೆ. ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ವೈದ್ಯರು ನನ್ನ ಪರೀಕ್ಷೆ ಮಾಡುವಾಗ ನನ್ನ ಗಂಡನು ಸಹ ಅಲ್ಲೇ ಇದ್ದರು ಮತ್ತು ಇತರೆ ಕೆಲವು ಜನರು ಇದ್ದರು. ಏನಾಯಿತು ಎಂಬುದಾಗಿ ವೈದ್ಯರು ನನ್ನನ್ನು ಕೇಳಿದ್ದಾರೆ. ವೈದ್ಯರ ಬಳಿ ನಾನು ಏನು ಹೇಳಿದೆನು ಎಂದರೆ ಏನನ್ನೂ ಹೇಳಲಿಲ್ಲ. ದಿಸ್ ಈಸ್ ಮಿಲಾಂಡ್. ಸಾಕ್ಷಿಯು ಮುಂದುವರೆದು ಹೇಳುತ್ತಾರೆ, ವೈದ್ಯರ ಬಳಿ ಏನನ್ನೂ ಹೇಳಬಾರದು ಎಂಬುದಾಗಿ ನನ್ನ ಗಂಡನು ನನಗೆ ಹೆದರಿಸಿದನು. ನನಗೆ ಪ್ರಜ್ಞೆ ಹೋಗಿರಲಿಲ್ಲ, ಆದರೆ ಬಹಳ ಸುಸ್ತಾಗಿತ್ತು. ನನಗೆ ವೈದ್ಯರು ವಾಮಿಟ್ ಮಾಡಿಸಿದ್ದಾರೆ. ಆ ರೀತಿ ನಾನು ವಾಮಿಟ್ ಮಾಡಿದಾಗ ಬಂದಂತ ವಸ್ತುಗಳು ವೈದ್ಯರು ಆಗಲಿ ಅಥವಾ ನಾನಾಗಲಿ ಯಾವುದೇ ಬಾಟಲ್ನಲ್ಲಿ ಶೇಖರಣೆ ಮಾಡಲಿಲ್ಲ. ಘಟನೆ ಆದ ತಕ್ಷಣವೇ ನನ್ನ ಗಂಡನೇ ನನ್ನನ್ನು ಆಸ್ಪತ್ರೆಗೆ ಕರೆದುಕೊಂಡು ಹೋಗಿದ್ದಾರೆ. ಘಟನೆ ಆದ ದಿನ ಸಂಜೆ 7 ಗಂಟೆ ಸುಮಾರಿಗೆ ನಿಶಾನೆ P1 ದಾಖಲೆಗೆ ಪೊಲೀಸರು ನನ್ನ ಸಹಿಯನ್ನು ಪಡೆದುಕೊಂಡಿದ್ದಾರೆ. ನಿಶಾನೆ P1 ದಾಖಲೆಯಲ್ಲಿ ಇರುವ ಸಂಗತಿಗಳನ್ನು ಓರ್ವ ಪೊಲೀಸ್ ಪೇದೆಯು ಬರೆದಿದ್ದಾರೆ. ನಿಶಾನೆ P1 ಇರುವ ಸಂಗತಿಗಳನ್ನು ನಾನೇ ಹೇಳಿ ಬರೆಸಿದ್ದೇನೆ. ನಿಶಾನೆ P1 ಬರೆಸುವಾಗ ನಾನು ನನ್ನ ಗಂಡನು ನನಗೆ ವಿಷಯ ಕುಡಿಸಿದರು ಎಂಬುದಾಗಿ ಹೇಳಿದ್ದೇನೆ. ಮದುವೆಯಾದ 1 ತಿಂಗಳ ನಂತರ ನನ್ನ ಮತ್ತು ನನ್ನ ಗಂಡ ಮಧ್ಯೆ ವೈಮನಸ್ಸು ಪ್ರಾರಂಭವಾಯಿತು. ನನ್ನ ಗಂಡನು ನನ್ನ ಮೇಲೆ ವಿನಾಕಾರಣ ಸಂಶಯ ಪಡುತ್ತಾ ಇದ್ದರು ಮತ್ತು ಆ ಕಾರಣದಿಂದ ನಮ್ಮಿಬ್ಬರ ಮಧ್ಯೆ ವಿರಸ ಪ್ರಾರಂಭ ಆಯಿತು. ನನ್ನ ಗಂಡ ಮತ್ತು ಆತನ ತಂದೆ ತಾಯಿ ಮತ್ತು ಸಹೋದರರು ಪರಸ್ಪರ ಸೌಹಾರ್ದತೆಯಾಗಿ ಇದ್ದಾರೆ. ನನ್ನ ವಿಷಯಕ್ಕೆ ಆರೋಪಿಗಳು ತಮ್ಮಲ್ಲಿಯೇ ಜಗಳ ಆಡಿದ್ದಾರೆ. ನನ್ನ ಗಂಡನು ನನ್ನ ಮೇಲೆ ಸಂಶಯ ಪಡುತ್ತಾ ಇದ್ದ ವಿಷಯದಲ್ಲಿ ಪಂಚಾಯತಿಗಳು ನಡೆದಿವೆ ಮತ್ತು ಆ ಪಂಚಾಯತಿಗೆ ನನ್ನ ಕಡೆಯಿಂದ ನನ್ನ ತಂದೆ ಮತ್ತು ತಾಯಿ ಮಾತ್ರ ಬಂದಿದ್ದಾರೆ, ಬೇರೆ ಯಾರೂ ಬಂದಿರಲಿಲ್ಲ. ನನಗೆ 2 ಮಕ್ಕಳು ಜನಿಸಿದ ಸಂಬಂಧ ಮನೆಯಲ್ಲಿ ಹುಟ್ಟುಹಬ್ಬ ಇತ್ಯಾದಿಗಳನ್ನು ಆಚರಣೆ ಮಾಡಿರುವುದಿಲ್ಲ. ಈ ಘಟನೆ ಆಗುವುದಕ್ಕಿಂತ ಮೊದಲು ನನ್ನ ಮಕ್ಕಳು ಕೊಳ್ಳೇಗಾಲದಲ್ಲಿಯೇ ಶಾಲೆಗೆ ಹೋಗುತ್ತಾ ಇದ್ದರು. ನಂತರ ನಂಜನಗೂಡಿನಲ್ಲಿ ಅವರುಗಳನ್ನು ಶಾಲೆಗೆ ಸೇರಿಸಲಾಗಿದೆ. ನನ್ನ ಗಂಡನು ಫ್ಯಾಬ್ರಿಕೇಶನ್ ಕೆಲಸ ಮಾಡುತ್ತಾರೆ. ನನ್ನ ಗಂಡನು ಬೆಳಿಗ್ಗೆ ಕೆಲಸಕ್ಕೆ ಹೋದರೆ ಸಂಜೆ ಎಷ್ಟು ಹೊತ್ತಿಗೆ ಮನೆಗೆ ಬರುತ್ತಿದ್ದರು ಎಂದರೆ ಪದೇ ಪದೇ ಮನೆಗೆ ಬರುತ್ತಾ ಇದ್ದರು. ನಾನು ನನ್ನ ಅತ್ತೆ ಮತ್ತು ಮಾವನಿಗೆ ಸೇವೆ ಮಾಡಿದ್ದೇನೆ. ಏನು ಸೇವೆ ಎಂದರೆ ಅವರಿಗೆ ಊಟ ತಿಂಡಿ ಮಾಡುವ ವ್ಯವಸ್ಥೆಯನ್ನು ನನ್ನ ಮದುವೆ ಆದಾಗಿನಿಂದಲೂ ಮಾಡುತ್ತಾ ಇದ್ದೆನು. ನನ್ನ ಗಂಡನು ನನ್ನನ್ನು ಕೋಣೆಯಲ್ಲಿ ಕೂಡಿ ಹಾಕಿ ಎಷ್ಟು ಹೊತ್ತಿಗೆ ಬೀಗ ಹಾಕುತ್ತಾ ಇದ್ದರು ಮತ್ತು ಎಷ್ಟು ಹೊತ್ತಿಗೆ ಬೀಗ ತೆಗೆಯುತ್ತಾ ಇದ್ದರು ಎಂದರೆ, ಬೆಳಿಗ್ಗೆ 9 ಗಂಟೆಗೆ ವೇಳೆಗೆ ಬೀಗ ಹಾಕುತ್ತಾ ಇದ್ದರು ಮತ್ತು ಮನೆಗೆ ಬಂದಾಗ ಬೀಗ ತೆಗೆಯುತ್ತಾ ಇದ್ದರು. ಎಷ್ಟು ಹೊತ್ತಿಗೆ ನನ್ನ ಗಂಡನು ಮನೆಗೆ ಬರುತ್ತಾ ಇದ್ದರು ಎಂದರೆ, ಪ್ರತಿ ಅರ್ಧ ಗಂಟೆಗೊಮ್ಮೆ ಮನೆಗೆ ಬಂದು ಹೋಗುತ್ತಾ ಇದ್ದರು. ನನ್ನ ಗಂಡನು ಆ ರೀತಿ ಮನೆಗೆ ಬಂದಾಗ ಸಹ ನಾನು ನನ್ನ ರೂಮಿನಿಂದ ಹೊರಗೆ ಬರುವುದಕ್ಕೆ ನನಗೆ ನನ್ನ ಗಂಡನು ಅನುಮತಿಯನ್ನು ಕೊಡುತ್ತಾ ಇರಲಿಲ್ಲ. ನನ್ನನ್ನು ರೂಮಿನಲ್ಲಿ ಕೂಡಿ ಹಾಕಿ ಬೀಗ ಹಾಕಿಕೊಂಡು ಹೋಗುವುದನ್ನು ನನ್ನ ಮದುವೆ ಆದ ಸುಮಾರು 1 ತಿಂಗಳಿಗೆ ನನ್ನ ಗಂಡನು ಪ್ರಾರಂಭ ಮಾಡಿದನು ಮತ್ತು ಅದೇ ಪದ್ಧತಿಯನ್ನು ಕಡೆಯವರೆಗೂ, ಅಂದರೆ ಈ ಕೇಸ್ ಆಗುವವರೆಗೂ ಮುಂದುವರಿಸಿಕೊಂಡು ಬಂದನು. ನನ್ನನ್ನು ಕೂಡು ಹಾಕುತ್ತಾ ಇದ್ದ ಕೊಠಡಿಯಲ್ಲಿ ಅಡಿಗೆ ಮನೆ ಇತ್ತು. ಹೇಗೆ ಎಂದರೆ, ನಾನು ಮತ್ತು ನನ್ನ ಗಂಡ ಮತ್ತು ನನ್ನ ಅತ್ತೆ ಮಾವ ಎಲ್ಲರೂ ಒಟ್ಟಿಗೆ ಇದ್ದಾಗ ಕೊಠಡಿಯಲ್ಲಿ ಕೂಡಿ ಹಾಕುತ್ತಾ ಇದ್ದರು ಮತ್ತು ನಾನು ಮತ್ತು ನನ್ನ ಗಂಡ ಪ್ರತ್ಯೇಕವಾಗಿ ವಾಸ ಮಾಡಲು ಪ್ರಾರಂಭ ಮಾಡಿದ ನಂತರ ಮನೆಯಲ್ಲಿ ಕೂಡಿ ಹಾಕುತ್ತಾ ಇದ್ದರು. ನನ್ನ ಮದುವೆಯಾದ 3 ವರ್ಷಗಳ ನಂತರ ನಾನು ಮತ್ತು ನನ್ನ ಗಂಡನು ಪ್ರತ್ಯೇಕವಾಗಿ ವಾಸ ಮಾಡಲು ಪ್ರಾರಂಭ ಮಾಡಿದೆವು. ಮದುವೆಯಾದ 3 ವರ್ಷದ ನಂತರ ನನಗೆ ಮಕ್ಕಳು ಜನಿಸಿದ ಸಮಯದಲ್ಲೂ ಸಹ ನಾನು ಮತ್ತು ನನ್ನ ಗಂಡನು ಜಗಳ ಆಡಿಕೊಂಡೇ ಇದ್ದವು. ನನ್ನ ಮತ್ತು ನನ್ನ ಗಂಡನ ಮಧ್ಯೆ ಗಲಾಟೆಗಳು ಆಗುತ್ತಾ ಇದ್ದ ವಿಷಯ ನನ್ನ ತಂದೆ ಮತ್ತು ತಾಯಿಗೆ ಬಿಟ್ರೆ ಕೊಳ್ಳೇಗಾಲದಲ್ಲಿ ಬೇರೆ ಯಾರಿಗೂ ಗೊತ್ತಿರಲಿಲ್ಲ. ನನ್ನ ಗಂಡನ ಮನೆಯ ಅಕ್ಕಪಕ್ಕದಲ್ಲಿ ಬೇರೆಯವರ ಮನೆಗಳು ಇವೆ. ನನ್ನ ಗಂಡನು ನನಗೆ ವಿಷ ಕುಡಿಸಿದರು ಎಂದು ಹೇಳುವ ದಿನದಂದು ಯಾರಾದರೂ ಅಕ್ಕಪಕ್ಕದವರು ಬಂದಿದ್ದರೋ? ಹೇಗೆ ಎಂದರೆ ಬಂದಿರಲಿಲ್ಲ. ನಮ್ಮ ಮನೆಯಲ್ಲಿ ಕಿರ್ಚಿಕೊಂಡರೆ ಅಥವಾ ಗಲಾಟೆ ಆದರೆ ಅಕ್ಕಪಕ್ಕದ ಮನೆಯವರಿಗೆ ಕೇಳಿಸುತ್ತದೆಯೋ? ಹೇಗೆ ಎಂದರೆ ನನ್ನ ಗಂಡನ ಮನೆಯಲ್ಲಿ ಕಿಟಕಿಗಳನ್ನು ಯಾವಾಗಲೂ ಮುಚ್ಚಲಾಗುತ್ತದೆ. ಆದ್ದರಿಂದ ಆ ಶಬ್ದಗಳು ಹೊರಗಡೆಯವರಿಗೆ ಕೇಳಿಸುವುದಿಲ್ಲ. ನನ್ನ ಗಂಡನ ಮನೆಯಲ್ಲಿ ಹವಾ ನಿಯಂತ್ರಣ ವ್ಯವಸ್ಥೆ ಇರುವುದಿಲ್ಲ. ನಾನು ಈ ಫಿರ್ಯಾದನ್ನು ಕೊಡುವುದಕ್ಕಿಂತ ಮೊದಲು 1 ಬಾರಿ ಕೊಳ್ಳೇಗಾಲದ ಪಟ್ನಾ ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ಒಂದು ಪಂಚಾಯಿತಿ ಆಗಿತ್ತು. ಆ ರೀತಿ ಪಟ್ನಾ ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ಪಂಚಾಯಿತಿ ಆಗಿರುವ ಬಗ್ಗೆ ನನ್ನ ಬಳಿ ದಾಖಲೆಗಳು ಇರುವುದಿಲ್ಲ. ನಾನು ಪಟ್ನಾ ಪೊಲೀಸ್ ಠಾಣೆಗೆ ಲಿಖಿತವಾಗಿ ದೂರು ಕೊಟ್ಟಿದ್ದೆನು ಮತ್ತು ಆ ಕಾರಣದಿಂದ ಪಂಚಾಯಿತಿಯನ್ನು ಮಾಡಿದರು. ಆ ರೀತಿ ನಾನು ಪಟ್ನಾ ಪೊಲೀಸ್ ಠಾಣೆಗೆ ದೂರು ಕೊಟ್ಟಿರುವ ಬಗ್ಗೆ ಯಾವುದೇ ದಾಖಲೆಗಳನ್ನು ನನ್ನ ಬಳಿ ಇರುವುದಿಲ್ಲ. ನನ್ನ ಗಂಡನು ನನಗೆ ವಿಷ ಕುಡಿಸಿದ ಘಟನೆ ಆಗುವುದಕ್ಕಿಂತ ಮೊದಲೇ ನಮ್ಮ ಮಕ್ಕಳನ್ನು ನಂಜನಗೂಡಿನ ಶಾಲೆಗೆ ಸೇರಿಸಲಾಗಿತ್ತು. ನನ್ನ ಮಕ್ಕಳನ್ನು ನಂಜನಗೂಡಿನ ಶಾಲೆಗೆ ಸೇರಿಸುವ ಸಮಯದಲ್ಲಿ ನನ್ನ ಮೊದಲನೇ ಮಗನು 4ನೇ ತರಗತಿಯಲ್ಲಿ ಮತ್ತು 2ನೇ ಮಗನು UKGಯಲ್ಲಿ ಕಲಿಯುತ್ತಾ ಇದ್ದರು. ನಂಜನಗೂಡಿನಲ್ಲಿ ನನ್ನ ಮತ್ತು ನನ್ನ ಗಂಡನ ಮಧ್ಯೆ ಗಲಾಟೆ ಆಗಿರುವುದಿಲ್ಲ. ನಾನು ಮತ್ತು ನನ್ನ ಮಕ್ಕಳು ನಂಜನಗೂಡಿನಲ್ಲಿ ನನ್ನ ತಂದೆ ಮನೆಯಲ್ಲಿ ವಾಸ ಇದ್ದಾಗ ನನ್ನ ಗಂಡನು ನಮ್ಮ ತಂದೆ ಮನೆಗೆ ಬಂದು ಹೋಗುತ್ತಾ ಇದ್ದರು. ನಂಜನಗೂಡಿನ ಶಾಲೆಯಿಂದ ನನ್ನ ಮಕ್ಕಳನ್ನು ಬಲವಂತವಾಗಿ ಕರೆತಂದು ಕೊಳ್ಳೇಗಾಲದಲ್ಲಿ ಶಾಲೆಗೆ ಸೇರಿಸಿರುವುದಿಲ್ಲ. ಆದರೆ ನನ್ನ ಗಂಡನೇ ಪಂಚಾಯಿತಿ ಮಾಡಿ ನಮ್ಮನ್ನು ಕರೆದುಕೊಂಡು ಕೊಳ್ಳೇಗಾಲಕ್ಕೆ ಬಂದರು. ಆವಾಗಲೂ ಸಹ ನನಗೆ ಜೀವ ಭಯ ಇತ್ತು. ನನ್ನ ಬಳಿ ಒಡವೆಗಳು ಇದ್ದವು ಎಂದು ತೋರಿಸಲು ದಾಖಲೆ ಇಲ್ಲ ಮತ್ತು ಅದನ್ನು ನಾನು ಪೊಲೀಸರಿಗೆ ಕೊಟ್ಟಿಲ್ಲ. ನನಗೆ ಸೇರಿದ ಒಡವೆಗಳು ಈಗ ಸ್ವಲ್ಪ ನನ್ನ ಬಳಿ ಇದೆ, ಉಳಿದವು ಇರುವುದಿಲ್ಲ. ಆರೋಪಿಗಳು ಒಡವೆ ತರಬೇಕು ಎಂದು ನನಗೆ ಒತ್ತಾಯ ಮಾಡಿದ್ದಾರೆ, ಆದರೆ ನಾನು ಒಡವೆಗಳನ್ನು ತರಲಿಲ್ಲ. ಯಾವ್ಯಾವ ಒಡವೆಗಳನ್ನು ನಾನು ಗಂಡನ ಮನೆಯಲ್ಲಿ ಬಿಟ್ಟು ಹೋಗಿದ್ದೇನೆ ಮತ್ತು ಯಾವ ಒಡವೆಗಳನ್ನು ನನ್ನೊಂದಿಗೆ ತೆಗೆದುಕೊಂಡು ಹೋಗಿದ್ದೇನೆ ಎಂದು ನನಗೆ ನೆನಪಿದೆ. ನನಗೆ ಸೇರಿದ ಯಾವುದೇ ಒಡವೆಗಳು ನನ್ನ ಗಂಡನ ಮನೆಯಲ್ಲಿ ಇರುವುದಿಲ್ಲ ಮತ್ತು ಎಲ್ಲವೂ ನನ್ನ ಬಳಿಯೇ ಇವೆ ಎಂದರೆ ಸುಳ್ಳು. ನನ್ನ ಗಂಡನು ನನಗೆ ವಿಷ ಕುಡಿಸಿದ ದಿನದ ಹಿಂದಿನ ದಿನದಂದು ನಮ್ಮ ಮನೆಯಲ್ಲಿ ಗಲಾಟೆ ಆಗಿತ್ತು. ಏನು ಗಲಾಟೆ ಎಂದರೆ, ಆ ದಿನ 2 ಮತ್ತು 3ನೇ ಆರೋಪಿಗಳು ನಾನು ರಾತ್ರಿ ಊಟ ಬಡಿಸಿ ನಂತರ ಡೈನಿಂಗ್ ಹಾಲ್ನಲ್ಲಿ ಕ್ಲೀನ್ ಮಾಡುತ್ತಾ ಇದ್ದೆನು. ಆಗ ನನ್ನ ಗಂಡನು ಬಂದು, ಇಲ್ಲಿ ಯಾಕೆ ನಿಂತಿದ್ಯಾ, ಯಾರನ್ನು ನೋಡುತ್ತಿದ್ಯಾ ಎಂದು ಹೇಳಿ ಗಲಾಟೆ ತೆಗೆದರು ಮತ್ತು ಗಲಾಟೆ ಮಾಡಿದರು. ನಾನು 2 ಮತ್ತು 3ನೇ ಆರೋಪಿಗಳಿಗೆ ಪ್ರೀತಿಯಿಂದ ಊಟ ಬಡಿಸುತ್ತಾ ಇದ್ದೆನು. ನನ್ನ ಗಂಡನು ನನ್ನನ್ನು ಉದ್ದೇಶಿಸಿ ಯಾರನ್ನು ನೋಡುತ್ತಾ ಇದೆಯಾ ಎಂದು ಹೇಳಿದಾಗ ಅಲ್ಲಿ 2 ಮತ್ತು 3ನೇ ಆರೋಪಿಗಳು ಬಿಟ್ಟರೆ ಬೇರೆ ಯಾರೂ ಇರಲಿಲ್ಲ. ನನ್ನ ಗಂಡನ ಮನೆಯಲ್ಲಿ ಯಾವಾಗಲೂ ಕಿಟಕಿ ಮುಚ್ಚಿರುವ ಕಾರಣದಿಂದ ನಮ್ಮ ಮನೆಯಿಂದ ಹೊರಗಡೆ ನಿಂತಿರುವ ವ್ಯಕ್ತಿಗಳು ನನಗೆ ಕಾಣಿಸಲು ಸಾಧ್ಯ ಇಲ್ಲ. ನನ್ನ ಗಂಡನು ಆ ರೀತಿ ಯಾರನ್ನು ನೋಡುತ್ತಾ ನಿಂತಿದ್ಯಾ ಎಂದು ಕೇಳಿದಾಗ ನಾನು ಯಾರನ್ನೂ ನೋಡಲಿಲ್ಲ ಎಂದು ಪ್ರಶ್ನಿಸಿದೆನು. ಪ್ರಶ್ನೆ, ನಿಮ್ಮ ಗಂಡನು ನಿರ್ದಿಷ್ಟವಾಗಿ ಇಂಥ ವ್ಯಕ್ತಿ ಎಂದು ಹೆಸರನ್ನು ಸೂಚಿಸಿ ಆತನನ್ನು ನೋಡುತ್ತಾ ಇದೆಯಾ ಎಂದು ಹೇಳಿದರೋ ಹೇಗೆ? ಉತ್ತರ, ನಿರ್ದಿಷ್ಟವಾಗಿ ಯಾವುದೇ ವ್ಯಕ್ತಿಯ ಹೆಸರನ್ನು ನನ್ನ ಗಂಡನು ನನಗೆ ನಮೂದು ಮಾಡಿರುವುದಿಲ್ಲ. ನಾನು ಮತ್ತು ನನ್ನ ಗಂಡನು ಸ್ವತಂತ್ರವಾಗಿ ಬೇರೆ ಮನೆ ಮಾಡಿಕೊಂಡು ವಾಸ ಮಾಡಲು ಪ್ರಾರಂಭ ಮಾಡಿದ ನಂತರ ನನ್ನ ಗಂಡನ ಮನೆಯಲ್ಲೇ ನಾನೇ ಅಡಿಗೆಯನ್ನು ಮಾಡುತ್ತಾ ಇದ್ದೆನು. ಅದೇ ರೀತಿ ನನ್ನ ವಾರ್ಗಿತ್ತಿಯ ಅಡಿಗೆ ಮಾಡಿ ನನ್ನ ಅತ್ತೆ ಮಾವ ಅಂದರೆ 2 ಮತ್ತು 3ನೇ ಆರೋಪಿಗಳಿಗೆ ಮತ್ತು ಇತರರಿಗೆ ಬಡಿಸುತ್ತಾ ಇದ್ದರು. ನನ್ನ ಗಂಡನು ನನಗೆ ವಿಷ ಕುಡಿಸಿದರು ಎಂದು ಹೇಳುವ ದಿನದ ಹಿಂದಿನ ರಾತ್ರಿ ನಾನು ಪ್ರತ್ಯೇಕವಾಗಿ ಮಲಿಕೊಂಡನು ಮತ್ತು ನನ್ನ ಗಂಡನು ಮಕ್ಕಳನ್ನು ಕರೆದುಕೊಂಡು ನಮ್ಮ ಮನೆಯಲ್ಲೇ ಹಾಲ್ನಲ್ಲಿ ಪ್ರತ್ಯೇಕವಾಗಿ ಮಲಿಕೊಂಡರು. ಆ ಸಮಯದಲ್ಲಿ 2 ಮತ್ತು 3ನೇ ಆರೋಪಿಗಳು ಸಹ ನಮ್ಮ ಜೊತೆಯಲ್ಲೇ ವಾಸ ಇದ್ದರು. ಘಟನೆ ಆದ ದಿನವರೆಗೂ ನನ್ನ ಮತ್ತು 2ನೇ ಮತ್ತು 3ನೇ ಆರೋಪಿಗಳ ಮಧ್ಯೆ ಯಾವುದೇ ದ್ವೇಷ ಇರಲಿಲ್ಲ. ಪ್ರಶ್ನೆ, ಪ್ರೇರೇಪಿಸುವುದು ಎಂಬ ಪದ ಅರ್ಥ ಏನು? ಉತ್ತರ, ಫೋರ್ಸ್ ಮಾಡುವುದು. ನನ್ನ ಗಂಡನು ನನಗೆ ವಿಷ ಕುಡಿಸಿದರು ಎಂದು ಹೇಳುವ ದಿನದಂದು ಸಹ ಬೆಳಿಗ್ಗೆ ನನ್ನ ಮತ್ತು ನನ್ನ ಗಂಡನ ಮಧ್ಯೆ ಜಗಳ ಆಗಿತ್ತು. ಶೋಕೇಸ್ನಲ್ಲಿ ಇದ್ದ ಮಾರ್ಟಿನ್ ಮತ್ತು ಗುಡ್ ನೈಟ್ ಕಂಟೈನರ್ಗಳನ್ನು ನಾನೇ ಮೊದಲು ನನ್ನ ಕೈಗೆ ಎತ್ತಿಕೊಂಡೆನು. ಆ ವಸ್ತುಗಳನ್ನು ನಾನು ಎತ್ತಿಕೊಂಡಾಗ ಅವುಗಳಿಗೆ ಮುಚ್ಚಳ ಇತ್ತು. ಆ ವಸ್ತುಗಳ ಮುಚ್ಚಳಗಳನ್ನು ನಾನೇ ತೆಗೆದೆನು. ನನ್ನ ಯಾವ ಕೈನಲ್ಲಿ ಗುಡ್ ನೈಟ್ ಕಂಟೈನರ್ ಇತ್ತು ಮತ್ತು ಯಾವ ಕೈನಲ್ಲಿ ಮಾರ್ಟಿನ್ ಕಂಟೈನರ್ ಇತ್ತು ಎಂದು ಹೇಳಲು ಆಗುವುದಿಲ್ಲ. ಆ ಸಮಯದಲ್ಲಿ ನನ್ನ ಮಕ್ಕಳು ಶಾಲೆಗೆ ಹೋಗಿದ್ದರು. ನನ್ನ ಮಕ್ಕಳಿಗೆ ನಾನು ತಿಂಡಿ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದೆನು ಮತ್ತು ಆರೋಪಿಗಳಿಗೂ ಸಹ ತಿಂಡಿ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದನು ಮತ್ತು ಅವರು ತಿಂಡಿ ತಿಂದು ಆಗಿತ್ತು. ನನ್ನ ಕೈನಿಂದ ನನ್ನ ಗಂಡನು ಮುದ್ದೆಮಾಲು 1 ಮತ್ತು 2ಗಳನ್ನು ಕಿತ್ತುಕೊಂಡಾಗ ನನ್ನ ಗಂಡನ ಯಾವ ಕೈನಲ್ಲಿ ಮಾರ್ಟಿನ್ ಇತ್ತು ಮತ್ತು ಯಾವ ಕೈನಲ್ಲಿ ಗುಡ್ ನೈಟ್ ಇತ್ತು ಎಂದು ಹೇಳಲು ಆಗುವುದಿಲ್ಲ. ನಾನು ಓಡಿ ಹೋಗಲು ಪ್ರಯತ್ನ ಮಾಡಿದನೋ ಹೇಗೆ ಎಂದರೆ ನನ್ನ ಗಂಡನು ನನ್ನನ್ನು ಬಿಗಿಯಾಗಿ ಹಿಡಿದುಕೊಂಡನು. ನನ್ನ ಗಂಡನು ನನ್ನನ್ನು ತಬ್ಬಿ ಹಿಡಿದುಕೊಂಡಿದ್ದನು. ನನ್ನ ಮೂಗನ್ನು ನನ್ನ ಗಂಡನು ಮುಚ್ಚಿದಾಗ ನಾನು ಓಡಿ ಹೋಗಲು ಪ್ರಯತ್ನ ಪಟ್ಟನೋ ಹೇಗೆ ಎಂದರೆ ಆದರೆ ನನ್ನ ಕೈಯಲ್ಲಿ ಆಗಲಿಲ್ಲ. ನನಗೆ ಮೊದಲು ಗುಡ್ ನೈಟ್ನಲ್ಲಿ ಇದ್ದ ದ್ರವವನ್ನು ನನ್ನ ಗಂಡನು ಕುಡಿಸಿದರು. ಮಾರ್ಟಿನ್ ದ್ರವವನ್ನು ಯಾವಾಗ ಕುಡಿಸಿದರು ಎಂದರೆ ಅದನ್ನು ಕುಡಿಸಲಿಲ್ಲ, ಆದರೆ ನನಗೆ ಸ್ಪ್ರೇ ಮಾಡಿದರು ಅಂತ. ನನಗೆ ಗುಡ್ ನೈಟ್ ಮತ್ತು ಮಾರ್ಟಿನ್ 2ನ್ನು ನನ್ನ ಗಂಡನು ಕುಡಿಸಿದರು ಎಂದು ನಾನು ಪೊಲೀಸರಿಗೆ ಹೇಳಿಕೆಯನ್ನು ಕೊಟ್ಟಿದ್ದೇನೆ. ವೈದ್ಯರು ನನ್ನನ್ನು ವಿಚಾರಿಸಿದ ಸಮಯದಲ್ಲಿ ನನ್ನ ಗಂಡನು ಸಹ ಅಲ್ಲೇ ಇದ್ದರು. ವೈದ್ಯರ ಬಳಿ ನಾನೇ ಗುಡ್ ನೈಟ್ ಅನ್ನು ಕುಡಿದಿದ್ದೇನೆ ಎಂಬುದಾಗಿ ನಾನು ಹೇಳಿದ್ದೇನೆ ಎಂಬುದಾಗಿ ಎಲ್ಲಿಯಾದರೂ ಬರೆದಿದ್ದರೆ ಅದು ಸುಳ್ಳು ಸಂಗತಿಯಾಗಿದೆ. ನನ್ನ ಗಂಡನು ನನಗೆ ವಿಷ ಕುಡಿಸಿದ ಘಟನೆ ಆದ ವೈದ್ಯರ ಬಳಿ ನಾನೇ ಗುಡ್ ನೈಟ್ ಕುಡಿದಿದ್ದೇನೆ ಎಂಬುದಾಗಿ ನಾನು ಹೇಳಿದ್ದೇನೆ ಎಂಬುದಾಗಿ ಎಲ್ಲಿಯಾದರೂ ಬರೆದಿದ್ದರೆ ಅದು ಸುಳ್ಳು ಸಂಗತಿ.
Instead of reading entire evidence, you point out where you have got the admissions.
Lord, evidence, the cross examination done to demonstrate all the evidence deposed by her is all invented and falsity, improbability.
That's what you have elicited from the mouth of PW1.
Continuously it is shown that one person, she was alone and this accused alone, holding her made to administer 2 bottles in 2 hands, and she was caught hold. These are all improbable things. What was the earliest version, my lord, given before the doctor?
Was there any other injuries?
No injuries, your lordship, not even she. Even she had not consumed. She also not consumed. It was not known. She made like that, made to appear. No stomach wash, nothing, my lord. It was removed or tested
Yes,
for
only ಮಾರ್ಟಿನ್ ದ್ರವವನ್ನು ಯಾವಾಗ ಕುಡಿಸರು ಎಂದರೆ ಅದನ್ನು ಕುಡಿಸಲಿಲ್ಲ, ಆದರೆ ನನಗೆ ಸ್ಪ್ರೇ ಮಾಡಿದರು ಅಂತ
ಅದು ಕೂಡ ನಾಟ್ ನೋಟಿಸ್ ಬೈ ಡಾಕ್ಟರ್.
ಅಡ್ಮಿಷನ್
ಸ್ಪ್ರೇ ಮಾಡಿದ್ದು ಇಲ್ಲ. ಅದರಿಂದ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಕಮ್ ಟು ಎ ಡೆಫಿನೆಟ್ ಕನ್ಕ್ಲೂಷನ್.
ಯಾವುದೇ ವೈಜ್ಞಾನಿಕ ಕುಡಿಸಿ ವಾಂತಿ ಮಾಡಿದ್ದಾರೆ. ರಕ್ಷಣಾ ಕಾನೂನು ವಾಂತಿ ಮಾಡಿದಾಗ ಅದರ ಸ್ವಲ್ಪ ತೆಗೆದು ರಾಸಾಯನಿಕ ಗೊತ್ತಾಗ್ತದೆ ಅಂದ್ರೆ ಸರಿ. ಇದರಲ್ಲಿ ಕಳಿಸಿಲ್ಲ ಸೆಕ್ಷನ್
Then, my lord,
Evidence of PW1.
I read out the entire evidence, my lord, how falsity it is. She has only created for the purpose of the case. She wants to get separate from this man. That's how it is. Taken 2 children, got admitted in school in Nanjangud, and she was expecting that this man should reside in their house. And he has this aged parents. His avocation is in Kollegal. He cannot go as per her demand. Fighting was there regarding this, but he did not cause any cruelty. Jagala agta ittu. Jagala is not cruelty. Cruelty should be one-sided with a deliberate, willful intention to see that she is harassed. She is trying to commit suicide. The degree of cruelty, what defined in explanation 1 to 498A, that the woman should have been driven to commit suicide of such a degree. ಇಲ್ಲಿ ಇವ್ರು ಜಗಳ ಆಡ್ತಾ ಇರೋದು ಬಾಯಿ ಮಾತಲ್ಲಿ ಜಗಳ, ಯಾವತ್ತೂ ಹೊಡೆದ್ರು ಅಂತ ಹೇಳಿಲ್ಲ ನೋಡಿ. He has not raised his hand against her. There is no such allegation. ಇದು ಮನೇಲಿ ಇದ್ರೆ ಯಾರು ನೋಡ್ತಾ ಇದೀಯ ಅಂತ. This kind of all it is she has invented to file a complaint. There is no other reason. Even 498A, my lord, they do not constitute any facts and circumstances of the case. Previous day she has come. Page 69 also, my lord, that yes, in page 69 last paragraph also, ನಾನು ಗುಡ್ ನೈಟ್ ಮತ್ತು ಮಾರ್ಟಿನ್ಗಳನ್ನು ಕೈಗೆ ಎತ್ತಿಕೊಳ್ಳುತ್ತೇನೆ ಮತ್ತು ನಂತರ ನನ್ನ ಗಂಡನ್ನು ಆ ದ್ರವಗಳನ್ನು ನನಗೆ ಕುಡಿಸುತ್ತಾನೆ ಎಂಬ ಯಾವುದೇ ವಿಷಯಗಳು ಆರೋಪಿ 2 ಮತ್ತು 3 ಅವರಿಗೆ ಗೊತ್ತಿರಲಿಲ್ಲ. ಸಾಕ್ಷಿ ಮುಂದುವರೆದು ಹೇಳುತ್ತಾರೆ, ಪ್ರತಿದಿನ ಇದೇ ಆಯ್ತು, ಇವಳನ್ನು ಸಾಯಿಸಬೇಕು ಎಂದು ಎಲ್ಲ ಆರೋಪಿಗಳು ಮಾತನಾಡುತ್ತಾ ಇದ್ದರು. ಇಂಥ ಮಾತುಗಳನ್ನು ಬಹಳ ಸಾರಿ ಆರೋಪಿಗಳು ಮಾತನಾಡಿಕೊಂಡಿದ್ದಾರೆ. ಆ ರೀತಿ ಆರೋಪಿಗಳು ಮಾತನಾಡಿಕೊಂಡರು ಎಂಬ ವಿಷಯಗಳನ್ನು ಪೊಲೀಸರಿಗೆ ಹೇಳಲು ನನಗೆ ತೊಂದರೆ ಇರಲಿಲ್ಲ. ನನ್ನ ಅತ್ತೆ ಮತ್ತು ಮಾವನವರು ನನಗೆ ಹಲವು ಬಾರಿ ಸಮಾಧಾನ ಹೇಳಿದ್ದಾರೆ. ಯಾವ ರೀತಿ ಸಮಾಧಾನ ಹೇಳಿದ್ದಾರೆ ಅಂದ್ರೆ, ಜೀವನ ಎಂದ ಮೇಲೆ ಇದೆಲ್ಲ ಬರುತ್ತದೆ ಮತ್ತು ಹೆಣ್ಣಾದ ಮೇಲೆ ಇದೆಲ್ಲ ಸಹಿಸಿಕೊಳ್ಬೇಕು ಎಂಬುದಾಗಿ 2 ಮತ್ತು 3ನೇ ಆರೋಪಿಗಳು ನನಗೆ ಸಮಾಧಾನ ಹೇಳಿದ್ದಾರೆ. 2 ಮತ್ತು 3ನೇ ಆರೋಪಿಗಳು ನನಗೆ ಆ ರೀತಿ ಶಾಂತಮಾನ ಹೇಳುತ್ತಾರೆ ಮತ್ತು ಒಳ್ಳೆಯವರು ಇದ್ದಾರೆ ಎಂಬ ಕಾರಣದಿಂದಲೇ ನಾನು ಆರೋಪಿ 2 ಮತ್ತು 3ರವರಿಗೆ ಊಟ ಉಪಚಾರಗಳನ್ನು ಮಾಡುತ್ತಾ ಇದ್ದೆನು ಮತ್ತು ಘಟನೆ ಆದ ದಿನ ಬೆಳಿಗ್ಗೆ ಉಪಹಾರ ಕೊಟ್ಟಿದ್ದು ಮತ್ತೆ ಘಟನೆ ಆದ ಹಿಂದಿನ ದಿನ ರಾತ್ರಿ ಊಟ ಕೊಟ್ಟಿದ್ದು ಅದೇ ಪ್ರೀತಿಯಿಂದಲೇ ಎಂದರೆ ಸರಿ. ಸಂಶಯ ಪಡುವುದು ಮತ್ತು ಒಡವೆ ಬೇಕು ಎಂದು ಹೇಳುವುದು ಎಂಬ 2 ಕಾರಣಗಳಿಂದ ಮಾತ್ರ ನನ್ನ ಮತ್ತು ನನ್ನ ಗಂಡನ ಮಧ್ಯೆ ಗಲಾಟೆಗಳು ಆಗುತ್ತಾ ಇದ್ದವು. ನಾನು ಈ ಪ್ರಕರಣವನ್ನು ಮಾಡಿದ ನಂತರವೂ ಸಹ ರಾಜಿ ಸಂಧಾನಗಳು ನಡೆದಿವೆ ಮತ್ತು ಆ ರಾಜಿ ಸಂಧಾನಗಳಲ್ಲಿ ಆಸ್ತಿಯ ವಿಷಯವೂ ಸಹ ಬಂದಿದೆ. ನನ್ನ ಗಂಡನ ಮತ್ತು ನನ್ನ ಗಂಡನ ಮನೆಯವರ ಆಸ್ತಿಗಳ ಮೇಲೆ ನನಗೆ ಯಾವುದೇ ಸಂಬಂಧ ಇಲ್ಲ. ಹೇಗಾದರೂ ಮಾಡಿ ನನ್ನ ಗಂಡನನ್ನು ಆತನ ತಂದೆ ತಾಯಿ ಮನೆಯಿಂದ ಬೇರೆ ಮಾಡಿ ಆತನಿಗೆ ಬರುವ ಆಸ್ತಿಗಳನ್ನು ಲಪ್ತಾಯಿಸಿಕೊಂಡು ನಾನು ಮತ್ತು ನನ್ನ ತಂದೆ ನನ್ನ ಗಂಡನನ್ನು ನಂಜನಗೂಡಿನಲ್ಲಿ ಇರಿಸಿಕೊಂಡು ನಮ್ಮ ಜೀತದ ಆಳಿನಂತೆ ನಡೆಸಿಕೊಳ್ಳಬೇಕೆಂಬ ದುರುದ್ದೇಶದಿಂದ ನಾನು ಈ ಸುಳ್ಳು ಪ್ರಕರಣವನ್ನು ಮಾಡಿದ್ದೇನೆ ಎಂದರೆ ಸುಳ್ಳು. ನನ್ನ ಗಂಡನ ಮನೆಯಲ್ಲಿ ನನ್ನ ದೈನಂದಿನ ಅಗತ್ಯಗಳಿಗೆ ಕೊರತೆ ಮಾಡಿದ್ದಾರೆ ಎಂಬ ವಿಷಯವನ್ನು ನಾನು ನನ್ನ ತಂದೆ ಮತ್ತು ತಾಯಿಗೆ ಹೇಳಿದ್ದೇನೆ, ಬೇರೆ ಯಾರಿಗೂ ಹೇಳಿಲ್ಲ. ನನಗೆ ಇವತ್ತಿಗೂ ಸಹ ನನ್ನ ಗಂಡನ ಜೊತೆ ಬಾಳ್ವೆ ಮಾಡಬೇಕು ಎಂದು ಆಸೆ ಇದೆ. ಆದರೆ ನನ್ನ ಕಟುಕ ತಂದೆ ಅದಕ್ಕೆ ಅವಕಾಶ ಕೊಡುತ್ತಾ ಇಲ್ಲ ಎಂಬುದಾಗಿ 1ನೇ ಆರೋಪಿಯ ಆರೋಪ ಮಾಡುತ್ತಾರೆ ಎಂದರೆ ಅದೆಲ್ಲ ಸುಳ್ಳು. ದಿಸ್ ಇಸ್ ಹೌ. ನಾನು ನನ್ನ ವಿದ್ಯೆಯನ್ನು ಮತ್ತು ಬುದ್ಧಿಯನ್ನು ಸಾಕ್ಷಿಯನ್ನು ತಿರುಚಿ ಹೇಳಲು ಉಪಯೋಗಿಸುತ್ತಾ ಇದ್ದೇನೆ ಎಂದರೆ ಸುಳ್ಳು. ದಿನಾಂಕ 19/9/2013 ಆಗಲಿ ಅಥವಾ 20/9/2013 ಆಗಲಿ ಅಥವಾ ಆ ದಿನಗಿಂತ ಹಿಂದಿನ ಸಮಯದಲ್ಲಿ ಆಗಲಿ ನಾನು ಆರೋಪ ಮಾಡುತ್ತಾ ಇರುವಂತ ಯಾವುದೇ ಘಟನೆಗಳು ಆಗಿರುವುದಿಲ್ಲ ಅಂದರೆ ಸಾಮಾನ್ಯವಾಗಿ ಗಂಡ ಹೆಂಡತಿ ಮಧ್ಯೆ ಬರುವ ಸಣ್ಣ ಪುಟ್ಟ ವಿರಸ ಮನಸ್ತಾಪಗಳು ನಮ್ಮ ಮನೆಯಲ್ಲಿ ಬಂದಿವೆ ಮತ್ತು ಅದನ್ನು ನಾನು ದೊಡ್ಡದು ಮಾಡುತ್ತಾ ಇದ್ದೇನೆ ಎಂದರೆ ಸುಳ್ಳು. ನಾನು ಕುಡಿದು ಬಿಡಬೇಕು ಎಂಬ ಗುಡ್ ನೈಟ್ ಮತ್ತು ಮಾರ್ಟಿನ್ ಅನ್ನು ತೆಗೆದುಕೊಂಡಿದ್ದೆನೋ ಹೇಗೆ ಎಂದರೆ ನಾನು ಕುಡಿಯುವ ಉದ್ದೇಶದಿಂದ ತೆಗೆದುಕೊಂಡಿರಲಿಲ್ಲ. ಸಾಕ್ಷಿ ಸ್ವತಃ ಹೇಳುತ್ತಾರೆ, ನಾನು ಯಾವುದೇ ಕಾರಣಕ್ಕೂ ಅದನ್ನು ಕುಡಿಯುತ್ತಾ ಇರಲಿಲ್ಲ. ನನ್ನನ್ನು ಪರೀಕ್ಷೆ ಮಾಡಿದ ವೈದ್ಯರಿಗೂ ಮತ್ತು ನನಗೂ ಯಾವುದೇ ಮನಸ್ತಾಪ ಇರುವುದಿಲ್ಲ. ನಾವು ವೈದ್ಯರ ಎವಿಡೆನ್ಸು ಪ್ರಾಸ 8. This all, my lord, the probability is to be appreciated by your lordship.
We read PW 8 evidence also.
Yes, your lordship. PW 8 at page.
PW 8 also says that no such consumption of the Martin good night anta heltaro.
ಹೌದೌದು, ಕುಡಿದಿಲ್ಲ, ಸುಮ್ಮನೆ ಮನೆಯಲ್ಲಿ
same was not sent to the even to the lab.
After stomach wash he did not.
Also there is an improvement in the evidence of PW 1. She makes the statement before the doctor that Sadri Rukshana Kanam Ravranu ನಾನು ವಿಚಾರಿಸಿದಾಗ ಆ ವಿಷವಸ್ತುಗಳನ್ನು ಆಕೆ ಗಂಡ ಆದ ಅಬ್ದುಲ್ ಬಸೀದ್ ರವರು ಮತ್ತು ಅತ್ತೆ ಮತ್ತು ಮಾವ ಬಲವಂತವಾಗಿ ಕುಡಿಸಿದರು ಎಂಬುದಾಗಿ ನನ್ನ ಬಳಿ ಹೇಳಿದ್ದಾರೆ ಮತ್ತು ಆ ವಿಷಯವನ್ನು ನಿಶಾನೆ 5ರಲ್ಲಿ ನಮೂದು ಮಾಡಿದ್ದೇನೆ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ. That is not the case of the prosecution. Prosecution case is only that accused only administered the same ಅಂತ.
After the arrival of father, my lord, all this improvement is done. He wants to give a color of something.
What is your submission with regard to the 498A?
498A, my lord, it is settled law now. My lord, in order to constitute offence of 498A, the act of cruelty must be of such a nature, such a high degree, willfully festering, harassing, either in connection with demand of dowry or for other reasons also, which must be of a serious nature. One-sided it is. Jagala aadta iddo ನಾವು ಇಬ್ರು ಅಂತ ಹೇಳ್ತಾರೆ. It is an incompatibility. Marital maladjustment is not cruelty. This honorable court, my lord, in Ramswamy's case, it is held that cruelty should be willful and deliberate act of one-sided. A fight between husband and wife, a marital differences, marital discord, this cannot be considered as cruelty within the meaning of section 498. ಇದು the circumstances are demonstrated for 11 years. ಮದುವೆ ಆದಾಗ್ಲಿಂದ ಈ ತರ ನಡೀತಾನೆ ಇತ್ತು. ಇವ್ರವ್ರ ಜಗಳ, ಮಾತಿಗೆ ಜಗಳ ಅದು ಇತ್ತು. ಇದು she tolerated. She got shifted slowly, got admitted the children to the school of Nanjangud. This man, he was very good while coming to their house. It has come in the evidence. ನಮ್ಮ ಮನೆಗೆ ವಾರಕ್ಕೆ ಒಂದ್ಸರಿ ಬಂದಾಗ ಚೆನ್ನಾಗಿರ್ತಾ ಇದ್ರು ಅಂತ. ಅಲ್ಲಿ ಕ್ರೂಯಲ್ಟಿ ಆಗಿಲ್ಲ. ಇಲ್ಲಿ ಬಂದ್ರೆ ಅವಳಿಗೆ ಕ್ರೂಯಲ್ಟಿ. ಇವ್ರ ಜೊತೆಲೆಲ್ಲ ಇರ್ಬೇಕಲ್ಲ, ಅನುಸರಿಸ್ಕೊಂಡು ಇರ್ಬೇಕು ಆಗಲ್ಲ ಅಂತ. ಅತ್ತೆ ಮಾವ ಹೇಳ್ತಾರೆ, ಹೆಣ್ಣಾದ್ಮೇಲೆ ನೀನು ಅನುಸರಿಸ್ಕೊಂಡು ಹೋಗ್ಬೇಕು ಅಂತ ಹೇಳಿದ್ರು ಅಂತ. She don't want to remain. It is her attitude is the contribution for all this.
Yes.
No other reason, my lord, in the circumstance of the case. This has been demonstrated. Not even a single witness, neighbor has said that at any time they have heard a fight between husband and wife. At no occasion it is. This man has sacrificed all his life only for the sake of children. Now those children were taken slowly and got admitted there, got separated from father. The father lost the affection of children. And to have the affection of children, he adjusted with her, lived for about 1 or 2 years. These circumstances, my lord, it discloses clearly.
7 and 9.
And it is her father, my lord, who intervened. Till her father arrived to government hospital, she did not implicate husband at all, nor the parents-in-law.
Go to the evidence of PW 4. What are the answers illustrated?
Yes. This has been PW 4. Page 81, cross-examination, your lordship. ಮದುವೆ ಆದ ನಂತರ ನನ್ನ ಮಗಳು ಮತ್ತು ಆಕೆಯ ಗಂಡ ಸುಮಾರು 2 ವರ್ಷಗಳ ಕಾಲ ಚೆನ್ನಾಗಿದ್ದರು. ನನ್ನ ಮಗಳು ಏನು ಮಾಡದೇ ಇದ್ದರೂ ಸಹ ಆರೋಪಿಗಳು ನನ್ನ ಮಗಳನ್ನು ಸಂಶಯದಿಂದ ನೋಡುತ್ತಾ ಇದ್ದರು. ಆರೋಪಿಗಳೆಲ್ಲರೂ ನನ್ನ ಮಗಳನ್ನು ಸಂಶಯದಿಂದ ನೋಡುತ್ತಾ ಇದ್ದರು ಎಂಬ ವಿಷಯವನ್ನು ನಾನು ಪೊಲೀಸರ ಮುಂದೆ ಹೇಳಿದ್ದೇನೆ. ನನ್ನ ಮಗಳು ಮನೆಯಲ್ಲೇ ಇರುತ್ತಾ ಇದ್ದಳು ಮತ್ತು ಗಂಡನ ಜೊತೆಗೆ ಹೊರಗಡೆ ಹೋಗುವ ಬುರ್ಕಾ ಹಾಕಿಕೊಳ್ಳುತ್ತಿದ್ದಳು. ನನ್ನ ಅಳಿಯ ಅಂದರೆ ಒಂದೇ ಆರೋಪಿ ನಮ್ಮ ಮನೆಗೆ ಬಂದಾಗ ನಾನು ಆತನಿಗೆ ಮಾಮೂಲಿನಂತೆ ಪ್ರೀತಿಯಿಂದಲೇ ಮಾತನಾಡಿ ಹೆಂಡತಿ ಮೇಲೆ ಯಾಕೆ ಸಂಶಯ ಪಡುತ್ತೀರಿ ಮತ್ತು ಚೆನ್ನಾಗಿ ಸಂಸಾರ ಮಾಡಿಕೊಂಡು ಹೋಗ್ರಿ ಎಂದು ಹೇಳುತ್ತಾ ಇದ್ದನು. ನಾನು ಆ ರೀತಿ ಹೇಳಿದ ನಂತರ ಎಷ್ಟು ಸಮಯ ಆರೋಪಿ ಚೆನ್ನಾಗಿ ಇರುತ್ತಾ ಇದ್ದನು ಎಂದರೆ ಆತನು ಚೆನ್ನಾಗಿ ಇರುತ್ತಾ ಇರಲಿಲ್ಲ, ಬದಲಿಗೆ ನಿಮ್ಮ ಅಪ್ಪನಿಗೆ ಹೇಳಿದ್ಯಾ ಎಂದು ಕಿರುಕುಳವನ್ನು ಇನ್ನೂ ಹೆಚ್ಚಿಗೆ ಮಾತನಾಡುತ್ತಾ ಇದ್ದನು. ನಾನು ಒಂದೇ ಆರೋಪಿ ಜೊತೆ ಮಾತನಾಡಿ ಆತನಿಗೆ ತಿಳುವಳಿಕೆ ಹೇಳಿದ ವಿಷಯಗಳು ನನ್ನ ಮಗಳಿಗೆ ಗೊತ್ತು. ಈಗ ನಾನು ಹೇಳಿದ ವಿಷಯಗಳನ್ನು ಪೊಲೀಸರ ಮುಂದೆ ಹೇಳಿದ್ದೇನೆ. ನನ್ನ ಮಗಳು ವಿಷ ಕುಡಿದಿದ್ದಾಳೆ ಎಂಬ ಸಂಗತಿಯು ಬೆಳಿಗ್ಗೆ 11:30 ವೇಳೆಗೆ ನನಗೆ ತಿಳಿದು ಬಂತು. ನಾನು ಮಧ್ಯಾಹ್ನ 2ರಿಂದ 3 ಗಂಟೆ ವೇಳೆಗೆ ಮಧ್ಯದಲ್ಲಿ ಕೊಳ್ಳೆಗಾಲಕ್ಕೆ ಆ ದಿನ ಬಂದೆನು. ನಾನು ಕೊಳ್ಳೆಗಾಲಕ್ಕೆ ಬಂದ ತಕ್ಷಣ ನಾನು ನನ್ನ ಮಗಳನ್ನು ಮಾತನಾಡಿಸಿದೆನು ಮತ್ತು ವಿಷಯಗಳನ್ನು ಕೇಳಿ ತಿಳಿದುಕೊಂಡೆನು. ನನ್ನ ಮಗಳನ್ನು ಆಸ್ಪತ್ರೆಗೆ ಆಕೆ ಗಂಡನೇ ಅಂದರೆ ಒಂದೇ ಆರೋಪಿಯೇ ಸೇರಿಸಿದನು. ನಾನು ಕೊಳ್ಳೆಗಾಲಕ್ಕೆ ಬಂದಾಗ ಆರೋಪಿಗಳು ಎಲ್ಲಿ ಇದ್ದರು ಎಂದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ರಾತ್ರಿ 7:30 ವೇಳೆಗೆ ಪೊಲೀಸರು ಕೊಳ್ಳೆಗಾಲ ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಗೆ ಬಂದರು. ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ನನ್ನ ಮಗಳು ನನಗೆ ವಿಷಯಗಳನ್ನು ಹೇಳಿದ ತಕ್ಷಣ ಪೊಲೀಸರಿಗೆ ಆ ವಿಷಯವನ್ನು ತಿಳಿಸಲು ನನಗೆ ತೊಂದರೆ ಇತ್ತು ಎಂದರೆ ತೊಂದರೆ ಇರಲಿಲ್ಲ. ನನ್ನ ಮಗಳು ಆ ರೀತಿ ನನಗೆ ವಿಷಯಗಳನ್ನು ಹೇಳಿದ ನಂತರ ಮುಂದೆ ಏನು ಮಾಡಬೇಕು ಎಂಬುದಾಗಿ ನಾನು ಮತ್ತು ನಮ್ಮ ಮನೆಯ ಸದಸ್ಯರು ಕುಳಿತು ಚರ್ಚೆ ಮಾಡಲಿಲ್ಲ. ನಾವು ನಮ್ಮ ಜನಾಂಗದ ಕಮಿಟಿಯ ಪಂಚಾಯತಿ ನಡೆಸಿದಾಗ ಆ ಪಂಚಾಯತಿಗೆ ಆರೋಪಿಗಳು ಎಲ್ಲರೂ ಬಂದಿದ್ದರು. ಮುಸ್ಲಿಂ ಕಮಿಟಿಯಲ್ಲಿ ರಾಜಿ ಪಂಚಾಯತಿ ಮಾಡಿದಾಗ ಆ ಪಂಚಾಯತಿಯವರು ನಾವು ಎಲ್ಲಾ ಜವಾಬ್ದಾರಿ ತೆಗೆದುಕೊಳ್ಳುತ್ತೇವೆ ಎಂದು ಹೇಳಿದರೂ ಸಹ ನಾನು ನನ್ನ ಮಗಳನ್ನು ಕೊಳ್ಳೆಗಾಲದಲ್ಲಿ ಗಂಡನ ಮನೆಯಲ್ಲಿ ಬಿಡದೆ ಆಕೆಯನ್ನು ನಂಜನಗೂಡಿಗೆ ಕರೆದುಕೊಂಡು ಹೋಗಿದ್ದೇನೆ ಮತ್ತು ಇದುವರೆಗೂ ಕಳಿಸಿರುವುದಿಲ್ಲ ಎಂದರೆ ಆರೋಪಿಯೇ ಬಂದು ತನ್ನ ಹೆಂಡತಿಯನ್ನು ಅಂದರೆ ನನ್ನ ಮಗಳನ್ನು ಕರೆದುಕೊಂಡು ಕೊಳ್ಳೆಗಾಲಕ್ಕೆ ಬಂದಿದ್ದಾನೆ. ದಿಸ್ ಈಸ್ ಮೆಲಾಟ್ ದಿಸ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಇಟ್ ಸೆಲ್ಫ್ ಸಜೆಸ್ಟ್ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್ ಇಟ್ ಈಸ್. The committee members they have taken, we will take responsibility of wellness of your daughter. Live in Kollegal, let them live anta. He has taken them to his house. This is the only reason, my lord, that there is no other. ನಾನು ನಮ್ಮ ಮನೆಯಲ್ಲಿ ಚಿನ್ನದ ಒಡವೆಗಳನ್ನು ಯಾವಾಗಲೂ ಸ್ಟಾಕ್ ಇಟ್ಟುಕೊಂಡಿರುತ್ತವೋ ಹೇಗೆ ಎಂದರೆ ಇಲ್ಲ. ಈ ಘಟನೆ ಆದ ಸಮಯದಿಂದ ಇಲ್ಲಿವರೆಗೂ ಒಂದೇ ಆರೋಪಿಯು ಏನೇ ಕೆಲಸ ಮಾಡುತ್ತಾ ಇದ್ದಾನೆ ಎಂದರೆ ಫ್ಯಾಬ್ರಿಕೇಶನ್ ಬಿಸ್ನೆಸ್ ಮಾಡಿಕೊಂಡಿದ್ದಾರೆ ಮತ್ತು ಆ ಮೂಲಕ ಜೀವನ ನಡೆಸುತ್ತಾ ಇದ್ದಾರೆ. ಖರ್ಚಿಗೆ ಹೆಚ್ಚು ಹಣ ಬೇಕು ಎಂದು ನನ್ನ ಮಗಳು ಕೇಳುವುದು ಮತ್ತು ಅದಕ್ಕೆ ಆರೋಪಿ ಇಲ್ಲ ಎಂದು ಹೇಳುವುದು ಎಂಬ ರೀತಿಯ ಘಟನೆಗಳು ಆಗಿರುವುದಿಲ್ಲ. ದಿಸ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ದಟ್. ಈಗ ಹೇಳುತ್ತೇನೆ, ಮಧ್ಯದಲ್ಲಿ ಸ್ವಲ್ಪ ದಿನಗಳ ಕಾಲ ಮನೆ ಪದಾರ್ಥಗಳನ್ನು ಒಂದೇ ಆರೋಪಿ ಕೊಡಿಸುತ್ತಾ ಇರಲಿಲ್ಲ ಮತ್ತು ಆ ಬಗ್ಗೆ ಸ್ವಲ್ಪ ಮಟ್ಟದ ಭಿನ್ನಾಭಿಪ್ರಾಯ ಬಂದಿತ್ತು. ನಂತರ ಅದು ನಿವಾರಣೆ ಆಯಿತು. ನನಗೆ ಕೇವಲ ಹೆಣ್ಮಕ್ಳು ಮಾತ್ರ ಇದ್ದಾರೆ ಎಂದರೆ ಸರಿ. ನನ್ನ ಮಗಳು ಮತ್ತು ಅಳಿಯ ಅಂದರೆ ಒಂದೇ ಆರೋಪಿಯನ್ನು ನಂಜನಗೂಡಿನ ಮನೆಯಲ್ಲಿ ಇರಿಸಿಕೊಳ್ಳುತ್ತೇನೆ ಎಂಬುದಾಗಿ ನಾನು ಹಲವಾರು ಬಾರಿ ಹೇಳಿದ್ದೇನೆ ಎಂದರೆ ಸುಳ್ಳು. ನನಗೆ ಮತ್ತು ನನ್ನ ಹೆಂಡತಿಗೆ ವಯಸ್ಸು ಆಗುತ್ತಾ ಇದೆ ಮತ್ತು ಆ ಕಾರಣದಿಂದ ನಮಗೆ ಒಂದು ಆಸರೆ ಬೇಕಾಗುತ್ತದೆ ಎಂಬ ಕಾರಣದಿಂದ ನಾನು ಒಂದೇ ಆರೋಪಿಯನ್ನು ನನ್ನ ಮನೆಗೆ ಅಳಿಯನ್ನಾಗಿ ಮಾಡಿಕೊಳ್ಳಲು ಉದ್ದೇಶ ಹೊಂದಿದ್ದೇನೆ ಎಂದರೆ ಸುಳ್ಳು. ನಿಮ್ಮ ತಂದೆಯಿಂದ ಬರಬೇಕಾದ ಆಸ್ತಿಯನ್ನು ಭಾಗ ತೆಗೆದುಕೊಂಡು ಆ ಆಸ್ತಿಯನ್ನು ಮಾರಿ ಆ ಹಣವನ್ನು ತೆಗೆದುಕೊಂಡು ನೀನು ಬಂದು ನಂಜನಗೂಡಿನಲ್ಲಿ ನಮ್ಮ ಜೊತೆಯಲ್ಲಿ ವಾಸ ಮಾಡು ಎಂದು ನಾನು ಒಂದೇ ಆರೋಪಿಗೆ ಹೇಳುತ್ತಾ ಇದ್ದೇನೆ ಎಂದರೆ ಸುಳ್ಳು. ಒಂದೇ ಆರೋಪಿಯ ಹಣದ ಮೇಲೆ ಮತ್ತು ಆಸ್ತಿಯ ಮೇಲೆ ನಾನು ಒಂದು ಕಣ್ಣಿಟ್ಟಿದ್ದೇನೆ ಮತ್ತು ಆ ಕಾರಣದಿಂದ ನಾನೇ ನನ್ನ ಕೈಯಾರೆ ನನ್ನ ಮಗಳ ಜೀವನವನ್ನು ಹಾಳು ಮಾಡುತ್ತಾ ಇದ್ದೇನೆ ಎಂದರೆ ಸುಳ್ಳು. ನನ್ನ ಮಗಳು ನನಗೆ ಹೇಳಿದ ವಿಷಯಗಳು ನಾನು ಪೊಲೀಸರಿಗೆ ಹೇಳಿಕೆ ನೀಡಿದ್ದೇನೆ. ಈ ಘಟನೆಯಾದ ಮಾರನೇ ದಿನ ಪೊಲೀಸರು ಪ್ರಾಯಶಃ ನನ್ನ ಹೇಳಿಕೆಯನ್ನು ಪಡೆದುಕೊಂಡಿದ್ದಾರೆ, ಆದರೆ ನಿರ್ದಿಷ್ಟವಾಗಿ ಹೇಳಲು ಆಗುವುದಿಲ್ಲ. ಕಾರಣ ಇದು 3 ವರ್ಷಗಳ ಹಿಂದಿನ ಘಟನೆಯಾಗಿತ್ತು. ನಾನು ನನ್ನ ದುರಭಿಮಾನ ಮತ್ತು ನನ್ನ ಹಠದ ಪ್ರವೃತ್ತಿಯಿಂದ ನನ್ನ ಮಾತೇ ನಡೆಯಬೇಕು ಎಂದು ನಾನು ಸುಳ್ಳು ಸಾಕಿ ಹೇಳುತ್ತಾ ಇದ್ದೇನೆ ಎಂದು ಸುಳ್ಳು. There is no other differences, my lord, in this case. No kind of cruelty, nothing in all this. The trial court heard, my lord. Differences, my lord, is not cruelty. Lordship, kindly that the decision of this court, marital maladjustment or fight between couples is not cruelty. May place an authority, my lord, in similar cases where definition of 498A has been interpreted. The investigation also was not fair, your lordship. That PSI, my lord, he succumbed to the pressure of this PW4. My lord, he developed a color of 307, filed charge sheet, subjected them for trial of sessions trial. My lord, ultimately, my lord, they are found, my lord, not guilty. The elders, my lord, parents-in-law also implicated. My lord, subject for ordeal of trial. And in the circumstance of the case, this kind of fight, my lord, between husband and wife cannot be cruelty at all. This PW10, my lord, Mahadev Nayak, it is a complaint which was prepared, not a written complaint was lodged. It is the police, my lord, who developed this. Previously also that it is the same PSI, my lord, who had advised and sent them. On that evening after this PW4 came and talked to him, my lord, thereafter, my lord, at 7:30 he developed this complaint. A case of self-consumption made into administration, highly improbable it is. That was not the version before the doctor at all. Earliest version given before the doctor improbabilizes such theory. And that shows that this witness PW1 victim, she stick to the version given in the complaint, try to justify it in spite of so many questions being put, which shows that a self-interest on the part of PW1. Such kind of interested witness testimony cannot be given any credence. PW4, 5, 6, my lord, they are away. They have no direct knowledge about it. Being a daughter, my lord, she used to give a colorable version to the father and mother, and that was believed by them, and they try to repeat and all that. Ultimately, my lord, that it is her decision should have been taking the interest of children. She should have lived with the husband. She got parted away, and only previous day she has come only to create this case. 1909 it was. And after registration of the complaint, my lord, that this PW4, he has taken his own persons. My lord, the entire house was looted of this accused. This has come, my lord, at page 109 it is. PSI, he has not taken any action. He incited them. Lord, in the facts and circumstances of the case, my lord, no offense can be made out, my lord, against the husband.
Yes.
And my lord, parents-in-law that till previous night also she has fed them, respected, treated. My lord, there cannot be any quarrel at all in between them. And my lord, since after 3 years of marriage, she was residing, my lord, separately. There was no occasion. She herself said that. And morning, my lord, she has prepared breakfast, and this accused husband has consumed breakfast. Children also, they were taken to school. And when he had gone for his work, my lord, when she was alone, she pretended as if she has consumed. But doctor found that she has not consumed. This is a created story, my lord. They developed a case of.
Then how he came to the house?
Mother informed.
According to you, the husband only taken the victim to
Yes,
the
yes,
hospital.
Yes. Mother sent a word to him.
Your submission is that he is a fabricator and
Yes,
he
yes.
went for job.
Yes, yes.
How you come to know about this incident?
Mother informed me, Lord. Mother sent word to him. Immediately he came. Mother told that she is pretending something. You see that ಯಾದಕ್ಕೂ ಏನು ಇರ್ಲಪ್ಪ ನೀನು ಹಾಸ್ಪಿಟಲ್ ಕರ್ಕೊಂಡು ಹೋಗಿ ತೋರಿಸ್ಬಿಡು ನಮ್ಮ ತಲೆ ಮೇಲೆ ಬರ್ತದೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಕರ್ಕೊಂಡೋಗಿ ಅಲ್ಲಿ ತೋರಿಸಿದ್ರೆ ಅಲ್ಲಿ ಏನು ಇಲ್ಲ. ಅಲ್ಲಿ ಅವರು ಸ್ಟಮಕ್ ವಾಶ್ ಕೊಟ್ರೆ ಏನು ವಾಂತಿ ಬರಲೇ ಇಲ್ಲ. ಅಮ್ಮ ನಾಟಕ ಆಡ್ತಾ ಇದ್ದಾನೆ ಅಂತ
What time mother has noticed that?
9:30 itself, my lord.
9:30.
9:30.
Incident at what time?
ಅದೇ 9:30ಗೆ ಆಗಿರೋದು.
Immediately, according to you, mother,
husband has come.
witnessed this
Yes.
incident.
Immediately, mother secured this husband. Husband has taken to government hospital, which is at a distance in town, my lord. And 10:15 correct.
Yes, having perused the material, we also do not find any material with regard to the 307. How you overcome for the offence under section 498A? You are not disputing the previous day incident, that is on 19th.
This, my lord, it is all developed. It is previous day incident agide anta.
Is it your case that 19th no such galata
No
was
such
taken place between-
galata, my lord. No galata at all. She has created this, my lord, only to get separate from the husband.
Is it any suggestion to the PW1?
Yes, yes. Many suggestions.
Where is that suggestion?
Yes,
With regard to the previous day incident is concerned?
Yes, yes. Previous day incident also not.
Where is that suggestion? Disputing the previous incident dated 19th.
Incident, previous day incident cross examination ಮಾಡಿದರೆ ಏನು ಅಂತ ಹೇಳಿದ್ರು ಅಂತ. ಯಾರಿಗೆ ನೋಡ್ತಾ ಇದೆ ಅಂದ್ರೆ ಯಾರಿಗೆ ನೋಡ್ತೇನೆ ಅಮ್ಮ ಅಪ್ಪನಿಗೆ ನೋಡ್ತಿದ್ಯಾ.
Is it your
ಇದು is it believable?
Is it your suggestion to the witness PW1 that no such incident was taken place on the previous day?
The entire suggestion is there, your lordship. Kindly.
Where is that suggestion?
Yes, yes. I will that's what I was about to read. Your lordship stopped me. That at that stage. Continuation, my lord. It see that previous days there was no such incident. There is a suggestion, your lordship, that ಇಲ್ಲಿ last page, your lordship, that 70 page number ಅಲ್ಲಿ ದಿನಾಂಕ 19/9/2013 ರಂದಾಗಲಿ ಅಥವಾ 29/2013 ರಂದಾಗಲಿ ಅಥವಾ ಅದಕ್ಕೆ ಆ ದಿನಗಳಿಗಿಂತ ಹಿಂದಿನ ಸಮಯದಲ್ಲಾಗ್ಲಿ ನಾನು ಆರೋಪ ಮಾಡುತ್ತಾ ಇರುವಂತ ಯಾವುದೇ ಘಟನೆಗಳು ಆಗಿರುವುದಿಲ್ಲ ಎಂದರೆ ಸುಳ್ಳು. ಸ್ಪೆಸಿಫಿಕ್ ಸಜೆಷನ್ ಇದೆಲ್ಲ ಹುಟ್ಟಿಸ್ಕೊಂಡು ನಿಂಗೆ ಮಾಡಿದ್ಯಾ ಅಂತ.
ಸಾಮಾನ್ಯವಾಗಿ ಗಂಡ ಹೆಂಡತಿಯ ಮಧ್ಯೆ ಬರುವ ಸಣ್ಣ ಪುಟ್ಟ ವಿರಸ ಮನಸ್ತಾಪಗಳು ನಮ್ಮ ಮನೆಯಲ್ಲಿಯೂ ಬಂದಿವೆ ಮತ್ತು ಅದನ್ನು ನಾನು ದೊಡ್ಡದು ಮಾಡುತ್ತಾ ಇದ್ದೇನೆ ಎಂದರೆ ಸುಳ್ಳು.
ಕರೆಕ್ಟ್. ಇದೆಲ್ಲ ಗಂಡ ಹೆಂಡತಿ ಜಗಳ ಇದ್ದೇ ಇರುತ್ತೆ.
That you admit that.
Yes, yes.
There was a
difference
between the husband and wife.
Yes. That is not cruelty, your lordship. The differences in between, that is how Supreme Court, my lord, many occasions, your lordship also held, my lord, that marital discord, marital differences, incompatibility of temperament, maladjustment,
yes,
these kinds of different words.
Let them say with regard to the 498A is concerned. With regard to the invoking of section 307, what is the material placed before the court? But doctor categorically says that no such consumption of the same.
PW8 evidence ಒಂದ್ಸತಿ ಹೇಳ್ಬೇಕು.
PW8 ಅಲ್ಲಿ ಏನಿಲ್ಲ ಏನಿಲ್ಲ ನೋಡಿ.
ವಾಂತಿ ಮಾಡಿಸಿದ್ರ ಬಗ್ಗೆ
ಏನಿಲ್ಲ ಅಂತ.
ವಾಮಿಟಿಂಗ್ ಪಾರ್ಟಿಕಲ್ಸ್ ನ ಯಾವುದೇ ಕೆಮಿಕಲ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಕಳಿಸಿಲ್ಲ. ಯಾವ ಎಕ್ಸಾಮಿನೇಷನ್ ಕಳಿಸಿಲ್ಲ.
97 only.
ತದನಂತರ ರುಕ್ಸಾನಾ ಖಾನ್ ಅವರ ಹೊಟ್ಟೆಯನ್ನು ಉಪ್ಪು ನೀರಿನಲ್ಲಿ ತೊಳಿಸಲಾಯಿತು. ಸೂಕ್ತವಾದ ಔಷಧೋಪಚಾರವನ್ನು ಮಾಡಲಾಯಿತು.
ಆಯ್ತು.
ಅಲ್ಲಿಂದ ಕೆಳಗಡೆ 10 ಲೈನ್ಸ್. ನಾವು ಎರಡು ಸದರಿ ರುಕ್ಸಾನಾ ಖಾನಂ ಅವರು ನಾನು ವಿಚಾರಿಸಿದಾಗ ಆ ವಿಷವಸ್ತುಗಳನ್ನು ಆಕೆಯ ಗಂಡ ಆದ ಅಬ್ದುಲ್ ಬಶೀರ್ ಮತ್ತು ಆಕೆಯ ಅತ್ತೆ ಮತ್ತು ಮಾವ ಬಲವಂತವಾಗಿ ಕುಡಿಸಿದ್ರು ಎಂಬುದಾಗಿ ನನ್ನ ಬಳಿ ಹೇಳಿದ್ದಾರೆ ಮತ್ತು ಆ ವಿಷಯವನ್ನು ನಿಶಾನೆ P5 ನಮೂದು ಮಾಡಿದ್ದೇನೆ.
That is only she says ಅಂತ ಅಷ್ಟೇ. She says ಅಂತ. What PW 8 has found. ಚೀಫ್ ಎವಿಡೆನ್ಸ್ ಇದೆ ರೀ, ಚೀಫ್ ಓದ್ಬೇಕು, ಕ್ರಾಸ್ ಓದ್ಬೇಕು. ಮತ್ತೆ ಚೀಫ್ ಅಲ್ಲಿ ಇರ್ಬೋದು. We cannot take only the chief evidence. We should.
ಕ್ರಾಸ್ ಅಲ್ಲಿ ಸ್ವಾಮಿ.
ಮಿಸ್ಟರ್ ಕೌನ್ಸಲ್, ಈಗ ನಿಂಬು ಜ್ಯೂಸ್ ಕುಡಿದು ನಾನು ವಿಷ ಕುಡಿದೀನಿ ಅಂತ ಹೇಳಿದ್ರೆ ಡಾಕ್ಟರ್ ಆಗಿ ಒಪ್ಕೊಂಡ್ಬಿಡ್ತೀರಾ?
ಡಾಕ್ಟರ್ ಇರೋದೇ ಅದಕ್ಕೆ ಸ್ವಾಮಿ, ಅವ್ರು ನೋಡಿ ವಿಶ್ವ
ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಹೋಗ್ರಿ.
ಅದೇ ಸ್ವಾಮಿ ಅಲ್ಲಿ
ಆ ಗಾಯಾಳುವನ್ನು ಆಸ್ಪತ್ರೆಗೆ ಕರೆದುಕೊಂಡು ಬಂದಾಗ ಆಕೆ ಸಂಪೂರ್ಣವಾಗಿ ಕಾನ್ಸಿಯಸ್ ಆಗಿದ್ದಳು. ಹೌದಾ? ಮುಂದೆ ಟೆಂಡರ್ನೆಸ್ ಇದೆ. ನಿಶಾನೆ 5 ದಾಖಲೆಯಲ್ಲಿ ಕೆಳಗಡೆಯಿಂದ 3ನೇ ಸಾಲಿನಲ್ಲಿ ಓಲ್ಡ್ ಕೇಸ್ ಆಫ್ ಲ್ಯಾಕುನರ್ ಇನ್ಫಾರ್ಕ್ಟ್ ಎಂಬುದಾಗಿ ಬರೆದಿದೆ ಮತ್ತು ಅದು ಗಾಯಾಳುವಿಗೆ ಮೊದಲೇ ಇದ್ದ ತೊಂದರೆ ಎಂದರೆ ಸರಿ, ಅವತ್ತಿಂದಲ್ಲ. ಆ ದಿನ ಆಗಿದೆ ಎಂದು ಹೇಳುವ ಘಟನೆಗೂ ಮತ್ತು ಓಲ್ಡ್ ಕೇಸ್ ಆಫ್ ಲ್ಯಾಕುನರ್ ಇನ್ಫಾರ್ಕ್ಟ್ ಎಂಬುದಕ್ಕೂ ಯಾವುದೇ ಸಂಬಂಧ ಇಲ್ಲ ಎಂದರೆ ಸರಿ. ಸದರಿ ರುಕ್ಷಾನ ಕಾನಂರವರು ಪೆಸ್ಟಿಸೈಡ್ ಕುಡಿದಿದ್ದಾಳೆ ಎಂಬುದು ಯಾವುದೇ ವೈಜ್ಞಾನಿಕ ಪರೀಕ್ಷೆಯಲ್ಲಿ ಕಂಡು ಬರುವುದಿಲ್ಲ. ಮುಂದಕ್ಕೆ ಇರ್ಲಿ, ಅದಕ್ಕಿಂತ ಮುಂಚೆ PW1 ಎವಿಡೆನ್ಸ್ ಹೋಗಿ. ಆಕೆನೆ ಸಿ ಅಡ್ಮಿಟ್ಸ್ ಇನ್ ದಿ PW1 ನೋಡಿ. ಇನ್ನರ್ ಕ್ಲಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾರ್ಟಿನ್ ದ್ರವವನ್ನು ಯಾವಾಗ ಕುಡಿಸಿದರು ಎಂದರೆ ಅದನ್ನು ಕುಡಿಸಲಿಲ್ಲ, ಆದರೆ ನನಗೆ ಮಾಡಿದರು. ದಿಸ್ ಇಸ್ ದಿ ಎವಿಡೆನ್ಸ್ ಆಫ್ PW1.
ಗುಡ್ ನೈಟ್ ಕುಡಿಸಿದ್ದಾರೆ.
ಎಲ್ಲಿದೆ ಅದಂಗಂತ ಅವಳ ಹೆಸರು? ಗುಡ್ ನೈಟ್ ನಲ್ಲಿ ಇದ್ದ ದ್ರವವನ್ನು ನನ್ನ ಗಂಡನ್ನು ಕುಡಿಸಿದರು. ಹಾ ಆಯ್ತು, ಅದಕ್ಕಿಂತ ಮುಂಚಿನ ಲೈನ್ ಅಲ್ಲಿ
ಮಾರ್ಟಿನ್ ದ್ರವವನ್ನು ಯಾವಾಗ ಕುಡಿಸಿದ್ದಾರೆ ಅಂದ್ರೆ ಕುಡಿಸಲಿಲ್ಲ, ನನಗೆ ಸ್ಪ್ರೇ ಮಾಡಿದೆ.
ಬಟ್ ಅದಕ್ಕಾರು ಡಾಕ್ಟರ್ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಇದೆಯಾ ಗುಡ್ ನೈಟ್ ಕುಡಿಸಿದ್ರ ಬಗ್ಗೆ?
ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಅಷ್ಟೇ ಹೊಟ್ಟೆ.
ಅದಕ್ಕಿಂತ ಹಿಂದಿನ ಲೈನ್ ಓದಿ ನೀವು. 1 ಮತ್ತು 2ಗಳನ್ನು ಕಿತ್ತುಕೊಂಡಾಗ ತಿಂಡಿ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದನು ಮತ್ತು ಅವರು ತಿಂಡಿ ತಿಂದು ಆಗಿತ್ತು. ನನ್ನ ಕೈನಿಂದ ನನ್ನ ಗಂಡನನ್ನು ಮುದ್ದೆ ಮಾಡಲು 1 ಮತ್ತು 2ಗಳನ್ನು ಕಿತ್ತುಕೊಂಡಾಗ ನನ್ನ ಗಂಡನ ಯಾವ ಕೈಯಲ್ಲಿ ಮಾರ್ಟಿನ್ ಇತ್ತು, ಯಾವ ಕೈನಲ್ಲಿ ಗುಡ್ ನೈಟ್ ಇತ್ತು ಎಂದು ಹೇಳಲು ಆಗುವುದಿಲ್ಲ. ದಟ್ ಈಸ್ ಅವರ್ ಎವಿಡೆನ್ಸ್. ನಾನು ಓಡಿ ಹೋಗಲು ಪ್ರಯತ್ನ ಮಾಡಿದನು ಹೇಗೆ ಎಂದರೆ ನನ್ನ ಗಂಡನು ನನ್ನನ್ನು ಬಿಗಿಯಾಗಿ ಹಿಡಿದುಕೊಂಡನು, ನನ್ನ ಗಂಡನ ನನ್ನನ್ನು ತಪ್ಪಿ ಹಿಡಿದುಕೊಂಡಿದ್ದನು. ನನ್ನ ಮೂಗನ್ನು ನನ್ನ ಗಂಡನನ್ನು ಮುಚ್ಚಿದಾಗ ನಾನು ಓಡಿ ಹೋಗಲು ಪ್ರಯತ್ನ ಪಟ್ಟೆನೋ ಹೇಗೆ ಎಂದರೆ ಪ್ರಯತ್ನ ಪಟ್ಟೆನೋ, ಆದರೆ ನನ್ನ ಕೈಯಲ್ಲಿ ಆಗಲಿಲ್ಲ. ದಿಸ್ ಇಸ್ ದಿ ಎವಿಡೆನ್ಸ್. Next, go to the even evidence of PW8 also. ವೈಜ್ಞಾನ ಪರೀಕ್ಷೆಗೆ ಒಳಪಡಿಸಿದ ಪಕ್ಕದಲ್ಲಿ ರುಕ್ಷಾನ ಕಾನೂನು ಯಾವುದಾದ್ರು ಕ್ರಿಮಿನಾಶಕವನ್ನು ಕುಡಿದಿರೋ ಅಥವಾ ಇಲ್ಲ ಎಂಬುದು ಗೊತ್ತಾಗುತ್ತಾ ಇತ್ತು ಎಂದರೆ ಸರಿ.
ಸಾಕ್ಷಿ ಮುಂದುವರೆದು ಹೇಳುತ್ತಾರೆ, ಸಾಮಾನ್ಯವಾಗಿ ನಾವು ವಾಂತಿ ಪಾರ್ಟಿಕಲ್ಸ್ ಅನ್ನು ರಾಸಾಯನಿಕ ಪರೀಕ್ಷೆ ಕಳಿಸುವುದಿಲ್ಲ. ಕೇವಲ ಒಬ್ಬ ವ್ಯಕ್ತಿಯು ಮರಣ ಹೊಂದಿದರೆ ಆ ಶವವನ್ನು ಪೋಸ್ಟ್ ಮಾರ್ಟಮ್ಗೆ ಕಳಿಸುವಾಗ ಮಾತ್ರ ಆ ಶವದ ಹೊಟ್ಟೆ ಮತ್ತು ಇತರ ಅಂಗಗಳಲ್ಲಿ ಸಿಕ್ಕಿದ ಪಾರ್ಟಿಕಲ್ಸ್ ಅನ್ನು ರಾಸಾಯನಿಕ ಪರೀಕ್ಷೆಗೆ ಒಳಪಡಿಸುತ್ತೇವೆ. ನಿಶಾನೆ P5 ದಾಖಲೆಯನ್ನು ಓದಿ ನೋಡಿದರೆ ಸದರಿ
ಒಪಿನಿಯನ್ ಗುಣ ನೋಡಿ. ಐ ಆಮ್ ಆಫ್ ದಿ ಒಪಿನಿಯನ್ ದಟ್ ಎಂಬ ಕಾಲಂ ನಲ್ಲಿ ಪೇಷಂಟ್ ಫೆಲ್ ಅನ್ಕಾನ್ಸಿಯಸ್ ಫಾರ್ 15 minutes, ಕಂಪ್ಲೇಂಟ್ ಆಫ್ ವಾಮಿಟಿಂಗ್ ಅಂಡ್ ಗಿಡಿನೆಸ್ ಎಂದು ನಾನು ಬರೆದಿದ್ದೇನೆ ಎಂದರೆ ಸರಿ. ಆ ರೀತಿ ಅಭಿಪ್ರಾಯವನ್ನು ಯಾವ ಆಧಾರದ ಮೇಲೆ ಬರೆದಿದ್ದೇನೆ ಎಂದರೆ ಐ ಆಮ್ ಆಫ್ ದಿ ಒಪಿನಿಯನ್ ಎಂಬುದನ್ನು ಹೊಡೆದು ಹಾಕಬೇಕಾಗಿತ್ತು, ಆದ್ರೆ ಅದು ಹಾಗೆ ಬಿಟ್ಟಿದ್ದು ನನ್ನ ಕಡೆಯಿಂದ ತಪ್ಪು ಆಗಿದೆ. ಪೇಷಂಟ್ ಫೆಲ್ ಅನ್ಕಾನ್ಸಿಯಸ್ ಫಾರ್ 15 minutes, ಕಂಪ್ಲೇಂಟ್ ಆಫ್ ವಾಮಿಟಿಂಗ್ ಅಂಡ್ ಗಿಡಿನೆಸ್ ಎಂಬ ಅಭಿಪ್ರಾಯವನ್ನು ನಾನು ಯಾವ ಆಧಾರದ ಮೇಲೆ ಬರೆದಿದ್ದೆ ಅಂದ್ರೆ ಆ ಗಾಯಾಳು ರುಕ್ಷಾನ ಕಾನಂರವರು ಹೇಳಿದ ಆಧಾರದ ಮೇಲೆ ಬರೆದಿದ್ದೇನೆ.
ನಿಶಾನೆ P5 ದಾಖಲೆಯಲ್ಲಿ ಪ್ರಿವಿಯಸ್ ಇನ್ ನೇಚರ್ ಎಂದು ಬರೆದಿರುವ ಅಭಿಪ್ರಾಯಕ್ಕೆ ನನ್ನ ಪರೀಕ್ಷೆಯಲ್ಲಿ ಯಾವುದಾದರೂ ವೈದ್ಯಕೀಯ ಪುರಾವೆ ಸಿಕ್ಕಿದೆಯೋ ಹೇಗೆ? ನಾನು ಗಾಯಾಳುವಾಗಿ 20 ದಿನಗಳ ಕಾಲ ಬ್ಲಡ್ ರೆಸ್ಟ್ ತೆಗೆದುಕೊಳ್ಳಲು ನಾನು ಸೂಚಿಸಿದ್ದೇನೆ. ಈ ಸಂಗತಿಯೇ ಆ ಗಾಯಾಳುವಿಗೆ ಆಗಿದ್ದ ತೊಂದರೆಯ ಪ್ರಿವಿಯಸ್ ಇನ್ ನೇಚರ್ ಎಂದು ತೋರಿಸುತ್ತದೆ.
ಅಂದ್ರೆ ನೀವು ಅಡ್ವೈಸ್ ಮಾಡಿ ಡಾಕ್ಟ್ರು 20 ದಿವಸ ರೆಸ್ಟ್ ಅಲ್ಲಿ ಇರುವಂತಂದ್ರೆ ದಟ್ ಅಮೌಂಟ್ಸ್ ಟು ಎ ಗ್ರೀವಿಯಸ್ ಇಂಜುರಿ ಅಂತ. ನೀವು ಲಾ ಹ್ಯಾಸ್ ಟು ಬಿ ಇವಾಲ್ವ್ಡ್. ಡಾಕ್ಟರ್ 20 ದಿವಸ ನೀವು ರೆಸ್ಟ್ ಮಾಡು ಅಂತಂದ್ರೆ ಇಟ್ ಅಮೌಂಟ್ಸ್ ಟು ಎ ಗ್ರೀವಿಯಸ್ ಇಂಜುರಿ ಅಂತ. ಆಯ್ತು ಬನ್ನಿ 498 ಗೆ ಬನ್ನಿ. PW 307 ಏನಿಲ್ಲ.
498 ಲಾರ್ಡ್ಶಿಪ್ ಡಿಸ್ಕಷನ್ ಆಫ್ ದಿ ಜಡ್ಜ್ಮೆಂಟ್ ಪ್ಯಾರಾ 30 ಇಂದ ಇದೆ.
30 ಹೇಳಿ. ಟ್ರಯಲ್ ಕೋರ್ಟ್
ಪ್ಯಾರಾ 30 in view of the page 27 In view of the foregoing appreciations of evidence and documents available on record, I am of the opinion that the charge allegation leveled against accused number 2 and 3 is not established with the prosecution for two important reasons. That is, as admitted by the CW1 herself in her deposition stated that the accused number 2 and 3 were not present in the house when the incident was taking place, and on appreciating the overall evidence of CW1, whose complainant, it can be seen that there is no serious or major allegations against accused number 2 and 3 insofar as ingredients under section 498 are not is concerned. That's only for A2 and 3. In other words, as per the deposition of CW1, it appears that she had cordial relationship with her in-laws, accused number 2 and 3, and also stated that accused number 2 and 3 used to console her whenever accused number 1 and CW1 quarrel, and used to so and so. Then next thing, the only allegation against accused number 2 and 3 as per CW1 is that sometimes accused number 2 and 3 used to remain mute spectators, even though the accused number 1 used to harass CW1 in their presence. Therefore, in my opinion, nearly
ಇದೆಲ್ಲ A2 A3 ಗೆ ಅಕ್ವಿಟ್ ಮಾಡಕ್ಕೆ ರೀಸನ್ಸ್ ಕೊಟ್ಟಿರೋದು. A1 ಗೆ ಎಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಅದು ಹೇಳಿ.
Insofar as oral evidence 29 insofar as oral evidence and materials available on record pertaining to charges leveled against A1 is concerned, in my opinion, the prosecution is successful in establishing the ingredients of section 490K against him. However, in so far as the charge leveled against 307 of IPC is concerned, I am of the opinion that the prosecution has not established beyond reasonable doubts about the intention and knowledge on the part of the accused number 1 to commit the murder of CW1. On the contrary, upon appreciating the evidence available on record, more so the deposition of CW1, according to her own statement, accused number 1 was repeatedly doubting the character, and in the latter part, that is after Muslim community reconciliation that took place to resolve their differences, it is established that accused number 1 intensified the harassment on her both physically and mentally for want of additional money for setting up the new business. In fact, from the deposition of CW1, it can be seen that the differences between CW1 and accused number 1 got intensified after reconciliation attempt and only thereafter the accused number 1 started harassing her more on the monetary aspects, clubbed with his exciting suspicion over her character. Even prior to the Muslim community reconciliation, this could be an acceptable proposition that the accused number 1 wanted to bounce back the grudge and continued to harass CW1, if not suspecting her fidelity, but for additional money. Therefore, I am of the opinion the prosecution was successfully established in the act of harassment, cruelty on the part of the accused number 1 on his wife, that is CW1. Hence, I will answer point number 1. This is what.
Go to exhibit P1.
Complaint. That is page.
Exhibit P1.
119. Skipping first 10-12 lines for all. ನನಗೂ ನನ್ನ ಗಂಡ ಅಬ್ದುಲ್ ವಾಸಿದ್ ಮದುವೆ ಆದಾಗಿನಿಂದ ಸಂಸಾರದಲ್ಲಿ ಅನ್ಯೂನ್ಯತೆ ಇಲ್ಲದೆ ಯಾವಾಗಲೂ ನನ್ನ ಗಂಡ ಸಂಶಯ ಪಡುತ್ತಿದ್ದು ನನ್ನ ಮೇಲೆ ಹೊಡೆದು ಬಡಿದು ದೌರ್ಜನ್ಯ ಎಸಗುತ್ತಿದ್ರು. ಆದರೂ ನಾನು ಕ್ರಮೇಣ ಸರಿ ಹೋಗುವುದರಿಂದ ಅನುಸರಿಸಿಕೊಂಡು ಜೀವನ ಮಾಡಿಕೊಂಡು ಬಂದೆ. ಆಗ ಹಾಲಿ 2 ಮಕ್ಕಳಾದರೂ ಸಹ ನನ್ನ ಗಂಡ ನನ್ನ ಮೇಲೆ ಆಗಾಗ್ಗೆ ಹೊಡೆದು ನಿನಗೆ ಯಾರ ಜೊತೆ ಆದ್ರೂ ಹೋಗ್ಬೇಕೆನ್ನು ಆಗಿದ್ದರೆ ಅವನ ಜೊತೆ ಓಡಿ ಹೋಗು ಎಂದು ನನಗೆ ಹೋಗು, ನನ್ನ ಮನೆಯಲ್ಲಿ ನೀನು ಜಾಗವಿಲ್ಲ ಇತ್ಯಾದಿ ಕಿರುಕುಳ ನೀಡುತ್ತಾ, ಜೊತೆಗೆ ನನ್ನ ಮಾವ ಅಬ್ದುಲ್ ಗಫಾರ್ ಮತ್ತು ಅತ್ತೆ ರಫಿಯಾ ಬೇಗಂ ಅವರು ಸಹ ಮಗನ ಜೊತೆ ಸೇರಿಕೊಂಡು ಹಾಗಾಗಿ ನನಗೆ ಕಿರುಕುಳ ನೀಡುತ್ತಾ ತಮ್ಮ ಮಗನಿಗೆ ಕುಮ್ಮಕ್ಕು ನೀಡಿ ಸದರಿಯವರ ಎದುರಿಗೆ ನನ್ನ ಗಂಡ ಹೊಡೆಯುತ್ತಿದ್ದರೂ ಸಹ ಬಿಡಿಸದೆ ಮೂಕ ಪ್ರೇಕ್ಷಕರಾಗಿ ವರ್ತಿಸುತ್ತಿದ್ದರು. ಈ ವಿಚಾರವನ್ನು ನನ್ನ ಮದುವೆಯಾದ 3 ವರ್ಷದ ನಂತರ ನಮ್ಮ ತಂದೆ ತಾಯಿಯವರಿಗೆ ತಿಳಿಸಿದ್ದೆ. ಸದರಿಯವರುಗಳು ಈ ಸಂಬಂಧ ನನ್ನ ಗಂಡನನ್ನು ಕರೆಸಿ ಬುದ್ಧಿವಾದ ಹೇಳುತ್ತಿದ್ದರು. ಅಲ್ಲದೆ ನಮ್ಮ ಅತ್ತೆ ಮಾವನವರ ಜೊತೆ ಸಹ ಅನೇಕ ಬಾರಿ ನ್ಯಾಯ ಪಂಚಾಯಿತಿ ನಡೆಸಿದ್ರೂ ಸಹ ನನ್ನ ಮೇಲಿನ ದೌರ್ಜನ್ಯ ನಿರಂತರವಾಗಿ ಸಾಗುತ್ತಲೇ ಇತ್ತು. ಹೋದ ವರ್ಷ ಸಹ ಇದೇ ರೀತಿ ನನಗೂ ನನ್ನ ಯಜಮಾನರಿಗೂ ಗಲಾಟೆಯಾಗಿ ನನ್ನನ್ನು ನನ್ನ ಮಕ್ಕಳನ್ನು ಕಾರಿನಲ್ಲಿ ಕರೆದುಕೊಂಡು ಹೋಗಿ ನನ್ನ ತಂದೆ ಮನೆಗೆ ಹೊರಟು ಬಂದಿದ್ದರು. ಆನಂತರ ನಮ್ಮ ತಂದೆ ಮತ್ತಿತರರು ನನ್ನನ್ನು ಕೊಳ್ಳೆಗಾಲಕ್ಕೆ ಕರೆದುಕೊಂಡು ಬಂದು ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ನ್ಯಾಯ ಪಂಚಾಯಿತಿ ಮಾಡಿ ಸ್ವಲ್ಪ ದಿನ ನನ್ನ ತಂದೆ ಮನೆಯಲ್ಲೇ ಇರುವಂತೆ ತೀರ್ಮಾನ ಮಾಡಿದ್ರು. ಆಗ ನಮ್ಮ ಯಜಮಾನರು ನಮ್ಮ ತಂದೆ ಮನೆಗೆ ಬಂದು ಹೋಗುತ್ತಿದ್ದರು. ಅಲ್ಲದೆ ನಮ್ಮ ತಂದೆ ಮನೆಯಲ್ಲಿ ವ್ಯಾಸಂಗ ಮಾಡುತ್ತಿದ್ದ ನನ್ನ ಮಕ್ಕಳಿಗೂ ಕೂಡ ಮನಸ್ಸು ಕೆಡಿಸುತ್ತಿದ್ದರು. ಹೋದ ಜುಲೈ ತಿಂಗಳಲ್ಲಿ ನನ್ನ ಯಜಮಾನರೇ ನನ್ನ ಮಕ್ಕಳನ್ನು ಕೊಳ್ಳೆಗಾಲಕ್ಕೆ ಕರೆದುಕೊಂಡು ಬಂದು ಮಕ್ಕಳನ್ನು ನಿಸರ್ಗ ವಿದ್ಯಾನಿಕೇತನಕ್ಕೆ ಸೇರಿಸಿದರು. ಕೊಳ್ಳೆಗಾಲಕ್ಕೆ ಬಂದು ಸ್ವಲ್ಪ ದಿನಕ್ಕೆ ನಾನು ಊರಿನಲ್ಲಿ ಬಿಟ್ಟು ಬಂದಿದ್ದ ಎಲ್ಲಾ ಒಡೆಗಳನ್ನು ತೆಗೆದುಕೊಂಡು ಅವುಗಳನ್ನು ಮಾರಿ ನನ್ನ ಮಗನನ್ನು ಬೇರೆ ಯಾವುದಾದ್ರೂ ವ್ಯಾಪಾರ ಮಾಡಲಿ ಎಂದು ನಮ್ಮ ಅತ್ತೆ ಮಾವ ಪೀಡಿಸುತ್ತಿದ್ದರು. ಜೊತೆಗೆ ನನ್ನ ಗಂಡನೂ ಸಹ ಹೋಗಿ ತರುವಂತೆ ಪ್ರತಿನಿತ್ಯ ಜಗಳ ಮಾಡುತ್ತಿದ್ದರು. ನಿನ್ನೆ ದಿನ ರಾತ್ರಿ ಮಾಮೂಲಿನಂತೆ ಅತ್ತೆ ಮಾವನಿಗೆ ಊಟ ಬಡಿಸಿ ನಂತರ ಡೈನಿಂಗ್ ಹಾಲ್ ಕ್ಲೀನ್ ಮಾಡುತ್ತಿರುವಾಗ ನಮ್ಮ ಯಜಮಾನರು ಬಂದು ಯಾಕೆ ಯಾರನ್ನು ಎಂದು ಜಗಳವಾಡಿದರು. ನನ್ನ ಮನಸ್ಸಿಗೆ ತುಂಬಾ ಬೇಸರವಾಗಿ ಬೇರೆ ಬೇರೆಯಾಗಿ ಮಲಗಿಕೊಂಡಾಗ ನನ್ನ ಮಕ್ಕಳನ್ನು ಹೇಳಿಸಿ ಕರೆದುಕೊಂಡು ಇವಳಿಗೆ ನಮ್ಮ ಜೊತೆ ಇರಲು ಇಷ್ಟವಿಲ್ಲ, ಬೇರೆ ಕಡೆ ಹೋಗೋಣ ಹೊರಟು ಇವಳಿಗೆ ಅಲ್ಲದೆ ಇವಳ ಅಪ್ಪ ಅಮ್ಮ
ಇದರಲ್ಲಿ ದುಡ್ಡು ತಗೊಂಡ್ ಬಾ ಅಂತ ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ನಿಮ್ಮ ಎಕ್ಸಿಬಿಟ್ P1 ನಲ್ಲಿ ಫಾರ್ ಇಸ್ ಬಿಸ್ನೆಸ್ಗೆ?
ಇಲ್ಲಿ ಒಂದೇ ಲೈನ್ ಸ್ವಾಮಿ,
ಅದು ಇಲ್ಲ ಒಂದೇ ಲೈನು, ಬರೀ ಒಡವೆ ತಗೋಬಾ ಅಂತ.
ಎಲ್ಲಾ ಒಡವೆಗಳನ್ನು ತೆಗೆದು
ಕೊಳ್ಳೆಗಾಲಕ್ಕೆ ಬಂದು ಸ್ವಲ್ಪ ದಿನಕ್ಕೆ ನಾನು ಊರಿನಲ್ಲಿ ಬಿಟ್ಟು ಬಂದಿದ್ದೆ, ಎಲ್ಲ ಒಡವೆಗಳನ್ನು ತೆಗೆದುಕೊಂಡು ಬಾ,
ಅವಳನ್ನು ಮಾರಿ
ನನ್ನ ಮಗ ಬೇರೆ ಯಾವ್ದಾದ್ರು ವ್ಯಾಪಾರ ಮಾಡಲಿ ಎಂದು ನಮ್ಮ ಅತ್ತೆ ಮಾವ ಪೀಡಿಸ್ತಿದ್ರು ಅಂತ. ಒಡವೆ ಬಗ್ಗೆ ಇಲ್ಲಿ ಏನ್ ಬರೀತಾರೆ ಪ್ಯಾರಾ 33 ಅಲ್ಲಿ 33 and 34. Accused one started harassing her for on the monetary aspects, clubbed with his existing suspicion over the character even prior to the Muslim committee reconciliation. This could be an acceptable proposition that accused number 1 wanted to bounce back with grudge and continued harassment CW1 if not suspecting her fidelity but for additional money ಅಂತ ಬರೀತಾರೆ.
ಇದ್ರೆ ಒಡವೆ ತಂದು ಅದನ್ನ ಸರಿಯಾಗಿ ಪಾಠ ಕಲಿಸುತ್ತೆ ಅಂತ ಹೊರಟೋದು. ನಾನು ರಾತ್ರಿ ಎಲ್ಲ ತುಂಬಾ ಯೋಚನೆ ಮಾಡಿ ದಿನ 29
ಈಗ PWN ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ PW1 ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಗುಡ್ ನೈಟ್ ಕುಡಿಸಿದ, ಮಾರ್ಟಿನ್ ಸ್ಪ್ರೇ ಮಾಡಿದ ಅಂತ ಇದೆ ಎವಿಡೆನ್ಸ್ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್. ಅದೇ ರೀತಿ ಎಕ್ಸಿಬಿಟ್ P1 ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಗುಡ್ ನೈಟ್ ಅನ್ನು ಕುಡಿಸಿದ ಮತ್ತೆ ಮಾರ್ಟಿನ್ ಅನ್ನು ಕುಡಿಸಿದ್ರು ಅಂತ ಹೇಳಿ ಬಂದು ಅಲ್ಲಿ ಕಾಂಟ್ರರಿ ಆಗ್ಲಿಲ್ವಾ, ಕಾಂಟ್ರಡಿಕ್ಷನ್ಸ್ ಆಗ್ಲಿಲ್ವಾ?
ನೈಟ್ ಕುಡಿಸಿದ್ದು ಕರೆಕ್ಟ್ ಆಗಿದೆ, ಆದ್ರೆ ಸ್ಪ್ರೇ ಮಾಡಿದ್ರು ಅಂತ ಅಲ್ಲೇ ಹೇಳ್ತಾರೆ, ಇಲ್ಲಿ ಕುಡಿಸಿದ್ರು ಅಂತಾರೆ. ಬಟ್ ಗುಡ್ ನೈಟ್ ಕುಡಿಸಿದ್ದಂತ ನಿಜ.
ಡಾಕ್ಟರ್ ಮುಂದೆ ಹೇಳ್ತೀರಾ? ಡಾಕ್ಟರ್ ಮುಂದೆ PW8 ಮುಂದೆ ಅದೇ ದಿನ ಬೆಳಿಗ್ಗೆ 9 ಸಮಯದಲ್ಲಿ ರುಕ್ಸಾನಾ ಖಾನಂ ರವರು ಮೇಲೆ ಹೇಳಿದ ಮಾರ್ಟಿನ್ ಅಂಡ್ ಗುಡ್ ನೈಟ್ ಎಂಬ ದ್ರವ ರೂಪದ ವಿಷವನ್ನು ಕುಡಿಸಿದ್ದರು ಮತ್ತು ಕುಡಿದಿದ್ದರು ಎರಡು ಬೇರೆ ಬೇರೆ ಮೀನಿಂಗ್ ಅಲ್ವಾ?
ಕುಡಿದಿದ್ದರು ಅಂದ್ರೆ ಸೆಲ್ಫ್ ಕನ್ಸಂಪ್ಷನ್, ಕುಡಿಸಿದ್ದರು ಅಡ್ಮಿನಿಸ್ಟ್ರೇಷನ್. ಹೌದಾ?
ಮತ್ತು ಆ ವಿಷಯವನ್ನು PW1 ರುಕ್ಸಾನಾ ಖಾನಂ ರವರೇ ನನ್ನ ಬಳಿ ಹೇಳಿದರು. ಇಲ್ಲಿ PW1 ಹೇಳ್ತಾರೆ ನನಗೆ A1 ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ ಮಾತಾಡ್ಲಿಕ್ಕೆ ಅವಕಾಶ ಕೊಡ್ಲಿಲ್ಲ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ. ದಿಸ್ ಆಲ್ಸೋ ಕಾಂಟ್ರರಿ ಟು ದಿ ಓರಲ್ ಟೆಸ್ಟಿಮನಿ ಆಫ್ PW8 ಡಾಕ್ಟರ್. ಆಮೇಲೆ PW8 ಸುಳ್ಳು ಹೇಳ್ತಾನೆ ಅನ್ನೋದಕ್ಕೆ ಏನ್ ಮೆಟೀರಿಯಲ್ ಇದೆ? ವಾಸ್ ದೇರ್ ಎನಿ ಅನಿಮಾಸಿಟಿ ಬಿಟ್ವೀನ್ PW1 and 8? ಇಲ್ಲ. And doctor was not cross-examined as to his oral testimony as he deposed contrary to the prosecution case. ಕೇಳಲಿಲ್ಲ. ಮತ್ತೆ
ಗುಡ್ ನೈಟ್ ಕುಡಿಸಿದ್ದಂತ ನಿಜ ಇದೆ. ಮಾರ್ಟಿನ್ ಕನ್ಫ್ಯೂಸಲ್ ಸ್ಪ್ರೇ ಮಾಡಿದ್ರು ಕುಡಿಸಿದ್ರು ಅಂತ ಗೊತ್ತಿಲ್ಲ. ಅದನ್ನ
ಅದು ಗುಡ್ ನೈಟ್ ಅದು ವಿಷದ ರೂಪದ ದ್ರವ ಅನ್ನೋದೇ ಯಾರು ಹೇಳಿದ್ದಾರೆ?
FSL ಅಲ್ಲಿ ಇಲ್ರಿ, FSL ಅಲ್ಲಿ ಇದೆಯಾ? ಮತ್ತೆ ಇವನ್ ಡಾಕ್ಟರ್ ಆಲ್ಸೋ ಸೇಸ್ ಸದರಿ ರುಕ್ಸಾನಾ ಅವರು ಪೆಸ್ಟಿಸೈಡ್ ಕುಡಿದಾಳೆ ಎಂಬುದು ಯಾವುದೇ ವೈಜ್ಞಾನಿಕ ಪರೀಕ್ಷೆಗಳಲ್ಲಿ ಕಂಡು ಬರಲಿಲ್ಲ.
ಒಡವೆ ಮಾರಿ ದುಡ್ಡು ತಗೊಂಬ ಬಿಸ್ನೆಸ್ ಮಾಡ್ಬೇಕು ಅಂತ ಹರಾಸ್ ಮಾಡ್ತಿದ್ರು.
ಅದು ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಇದೆ. ಹೌದಾ? PW1 ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಇದೆಯಾ? ಏನಂತ ಹೇಳ್ತಾರೆ ನೋಡಿ. Is it not an improvement after the father had arrived to the hospital?
Other has come at about 7 o'clock in the evening.
ಅದೇನೆ
5 ಗಂಟೆಗೆ
5 ಗಂಟೆಗೆ ಬಂದ್ರು. ಕಂಪ್ಲೇಂಟ್ ಎಷ್ಟು ಕೊಟ್ಟರು? 7:30ಗೆ.
ಕಂಪ್ಲೇಂಟ್ 7:30 ಕೊಟ್ಟರು. ಬಟ್ ಡಾಕ್ಟರ್ ಮುಂದೆ ಹೇಳಿದ್ರು ಬೆಳಿಗ್ಗೆ 9:30 ಆಗಿದೆ.
9:30 ಏನ್ ಹೇಳಿದಾರೆ ಅವಾಗ?
ಈ ತರ
ಸ್ಟೇಟ್ಮೆಂಟ್ ರೆಕಾರ್ಡ್ ಮಾಡೋದು 6ರಿಂದ 7.
ಅದೇ 6ರಿಂದ 7.
ಆದ್ರೆ ಬರೋದು 5
ಆದ್ರೆ 5 ಗಂಟೆಗೆ ಬರ್ತಾರೆ. ಆಮೇಲೆ ಸ್ಟೇಟ್ಮೆಂಟ್ ರೆಕಾರ್ಡ್ ಮಾಡ್ತಾರೆ. When the patient went to the hospital, she was conscious. That is the evidence of the PW.
Before that, my lord, 9:30 or 10 o'clock, before the doctor, she gives the history.
ಏನ್ ಹಿಸ್ಟ್ರಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಹೇಳಿ?
ಇಲ್ಲಿ PW 8 ಅಲ್ಲಿ ಇದೆ ಸರ್.
ಅದು ಏನ್ ಹಿಸ್ಟ್ರಿ?
Exhibit P5.
What is the history? Exhibit P5 ಗೆಲ್ಲ ಕ್ರಾಸ್ ಮಾಡಿದಾಗ ಅವರು ಏನ್ ಹೇಳಿದ್ದಾರೆ? PW ಎವಿಡೆನ್ಸ್ ಹೋಗ್ಬಿಡಿ ಎಲ್ಲ 8 ಗೆ.
ಇಲ್ಲಿ wound certificate page 129, exhibit P5. Wound injuries found on the person of so and so, accompanied by brought by
9:30 ಸಮಯದಲ್ಲಿ ಸದರಿ ರುಕ್ಸಾನಾ ಖಾನ್ ರವರು ಬೇಲೆ ಹೇಳಿದ ಮಾರ್ಟಿನ್ ಮತ್ತು ಗುಡ್ ನೈಟ್ ಎಂಬ ದ್ರವರೂಪದ ವಿಷವಸ್ತುವನ್ನು ಕುಡಿದಿದ್ದರು ಮತ್ತು ಆ ವಿಷವನ್ನು ರುಕ್ಸಾನಾ ಖಾನಂ ರವರೇ ನನ್ನ ಬಳಿ ಹೇಳಿದರು ಅಂತಿದೆ ಚೀಫ್ ಅಲ್ಲಿ.
129 ಒಂದು ಸರ್. Page 129.
ಎಕ್ಸಿಬಿಟ್ P5 ಅಲ್ಲಿ.
Accompanied and brought by her husband Abdul Bashi, for a report of so and so. Instead of having consumed 1 bottle of liquid Martin and liquid good night mosquito repellent at 9:30 a.m. on 29/2013 at her residence in so and so, which was forcibly fed by her husband Abdul Bashi and in-laws at Kurubarabidi, Kolegana Tal.
That is the one exhibit P5 wound certificate ಅಲ್ಲಿ ಹೇಳಿರೋದು.
Also,
ಹೌದಾ?
it is at about 10 o'clock in the morning. Not after his father.
ಆಯ್ತ್ರಿ, ಫೋರ್ಸಿಬಲ್ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಷನ್ ಆದ್ರೆ ಏನು ಇಂಜುರೀಸ್ ಏನೋ ಆಗೋದೇ ಇಲ್ವಾ?
Civil administration.
ರೆಸಿಸ್ಟ್ ಮಾಡ್ತಾರಾ ಇಲ್ಲ? ಕಾಮನ್ ಸೆನ್ಸ್. As an ordinary prudent man, you make submission before the court. If it is a forcible administration,
ಅದನ್ನ ನೋಟಿಸ್ ಮಾಡಿಲ್ಲ.
ಏನು ಇಂಜುರೀಸ್ ಒಂದು ಇಲ್ಲ.
ಇಲ್ಲಿ ಎರಡು ಹೇಳ್ತಾರೆ, ಒಂದು
ಏನು ಅದು ಐಡೆಂಟಿಫಿಕೇಶನ್ ಮಾರ್ಕ್ಸ್ ಅಷ್ಟೇ. ಐಡೆಂಟಿಫಿಕೇಶನ್ ಮಾರ್ಕ್ಸ್, ನೋ ಇಂಜುರೀಸ್ ಅಟ್ ಆಲ್. ನೋಡಿ, heard the counsel appearing for the accused as well as complainant counsel as against the conviction and acquittal. ನೀವು A2 A3 ನು ಅಕ್ವಿಟ್ ಮಾಡಿರೋದು ತಪ್ಪು ಅಂತ ನಿಮ್ ಕೇಸ? ನೋಡಿ, the factual matrix of case of prosecution is that the marriage of the husband and wife was solemnized in 2002 and they lived together for about 11 years. Lived together 11 years illa, madhyadalli ಏನೋ ಬಂದು ಹೋಗಿ ಏನೋ ಆಗಿದೆ, ಅದಿಲ್ಲ. Marriage was performed in the year 2012. That on 29/2013 at about 9:30 in the morning, within the limits of complainant police, the accused number 1 is alleged to have forcefully administered mosquito repellent liquid good night within bracket and Martin bracket close into the mouth of the PW1 by closing her nose / nostrils with an intention to eliminate her permanently. The background of this incident is that PW1 was given in marriage to the accused number 1, and prior to this incident and thereafter, accused number 1 and PW1 were living in their matrimonial home at Kollegal town, and accused number 1 was in a habit of doubting fidelity / character of his wife and frequently suspected her to having illicit relationship and used to treat her with cruelty both physically and mentally, and was locking her in a room / house to ensure that she doesn't come in contact with any of his family members, outsiders. In this background of the matter, on the previous day of the incident, when PW1 was cleaning the dining table after dinner, the accused number 1 is said to have picked up a quarrel with her, stating that she was trying to entice his male family members and provoke her to commit suicide. Suicidal, which led to administering the liquid of Goodnight and Martin. It is also the allegation that accused number 2 and 3, being the parents of accused number 1, were always witnessing the harassment, were sitting mute spectators to the cruelty meted out to her by the accused number 1. And on the several occasions also, accused number 2 and 3 provoked the accused number 1 to intensify, inflict cruelty by accused number 1, more so in respect of getting money from the parents of PW1, since accused number 1 desired to start a new expand his business, and hence invoke the offence under section 498A and 307 read with section 34 of IPC. The police, based on the statement of the victim, as per exhibit P1, registered the case and investigated the matter and filed the charge sheet. The accused persons were secured and they were on bail, and accused did not plead guilty and claims trial. The prosecution, in order to substantiate their case, examined PW1 to 12 and also got marked document exhibit P1 to 8, MO 1 and 2. The trial judge, having closing the evidence of prosecution, recorded the statement of accused under section 313 of CRPC, but accused denied the incriminating evidence put to their mouth and also not led any defense evidence. The trial court, having considered both oral and documentary evidence of the prosecution witnesses, comes to the conclusion that it is not a case of invoking the offence under section 307, and the fact that accused number 1 forcefully administered the Goodnight and Martin into the mouth of the PW1 by closing her nostrils with an intention to eliminate her permanently was not accepted, and acquitted the accused
Number
2 and 3 and also the accused number 1 for the offence punishment section 307. However, the trial court, taking into note of material of cruelty, comes to the conclusion that there is a case against only accused number 1, that to invoke the offence under section 498A, and convicted the accused number 1 for the offence punishable under section 498A and imposed the sentence of 3 years and a fine of rupees 10,000 as against accused number 1, and also ordered to pay the fine amount to the victim PW1. Being agreed by the conviction, criminal appeal number 1988 of 17 is filed before this court. The counsel appearing for the appellant would vehemently contend that though trial court disbelieved the case of the prosecution with regard to the offence under section 307, but committed an error in upon the evidence of PW1 with regard to the cruelty is concerned. the council would vehemently contend that there was an incompatibility in between the appellant and PW1. And the same will not amounts to a cruelty. The council also would vehemently contend that the appellant is not a literate and the PW1 is a graduate and having the computer course training also. And due to this reason only, the incompatibility was found between the accused and PW1. The council would submit that marital discord or incompatibility of temperament in between the spouse cannot be treated as cruelty. The act of cruelty must be intentional or willful with an intention to harass and pester wife to commit suicide. The council also would vehemently contend that having noticed that PW1 was pretending that she has consumed the Good night and Martin informed the accused and immediately the accused appellant rushed to the spot and taken her to the hospital. And no dispute with regard to the fact that accused only shifted her to the hospital. The council also vehemently contend that it was only a pretended that she has consumed the same. And doctor evidence of PW8 is also very clear that no such material is found with regard to the consumption is concerned. And the evidence of PW8 is also very clear and the same has been appreciated by the trial court while rightly coming to the conclusion that it was not administered by the accused. However, the trial court committed an error in invoking section 498A against the appellant. The council also vehemently contend that PW4, the father-in-law, who is economically sound, was insisting his daughter to visit his house very often, and her ornaments were taken by him. And regarding this, some differences were developed. And the appellant was also insisting his wife to follow religious practices and to remain in home, which was not liked by the PW1. And hence, a false allegation is made that she was confined in a room and not allowed to move out. And the same also exaggerated by the prosecution. The council would submit that independent witness who have been examined as PW7 and PW9 have PW7 and 9 have denied any panchayat was held regarding the quarrel of PW1 and appellant. They have not supported the case of prosecution. The trial court, when comes to the conclusion that the evidence of PW7 and 9 is not supported the case of prosecution, and ought to have comes to the conclusion that there was no any material before the court to comes to a conclusion that there was a cruelty. And hence, the interference of this court is required to the accused for the offence punishment under section 498A. For contra, the counsel appearing for the victim in criminal appeal number 736 of 2018, amicus sir, and amicus curiae would vehemently contend that the trial court committed an error in acquitting the accused for the offence punishment section 307 of IPC, and also acquitting the accused number 2 and 3 for the offence punishment section 307 and 498A, and proceeded in an erroneous approach, only convicting the accused for the offence punishment section 498A. The trial judge has failed to consider the fact that to constitute an offence under section 498A of IPC, it is sufficient that if the husband or any of his relative by any willful conduct of such a nature, which is likely to cause grave injury or danger to life, limb or health of the woman, Stop. In the instant case, it is the specific allegation made by the appellant that accused number 1 was treating her with cruelty by casting aspersions on her character and constantly demanding for dowry. The council also vehemently contend that though it is not specifically mentioned with regard to the dowry in the exhibit P1, but it is very clear that both the husband and also the in-laws were insisting her to get the gold ornaments from the house of her parents. That too in order to expand the business. The council also vehemently contend that the trial court committed an error in acquitting the accused number 2 and 3 when the specific allegation is made in the complaint exhibit P1 as well as PW1 categorically depose the same, and also the mother and father who have been examined as PW4 and 5 also reiterated with regard to the forcing her to get the gold ornaments. The council also would submit that PW6 uncle of maternal uncle also supported the case of the prosecution. The council would submit that even though Panchayat Dars 11 and 9 have not supported the case of prosecution, but committed an error in acquitting the accused persons, and hence it requires interference of this court to convict the accused 1 to 3 for the offence punishment section 307 of IPC and section 498 of IPC. Both accused number 1 as well as accused number 2 and 3. And it requires interference of this court. Having heard the appellant's counsel in both the appeals and also on perusal of material available on record, including the charges, ನೀವ್ಯಾರಿಗೆ ಮೂರಿದೆಯಾ ನಿಮ್ದು ಒಂದಿದೆಯಾ ಸ್ಟೇಟ್ ಅಪೀಲ್ ಒಂದಿದೆ ಮತ್ತೆ ನೀವು ಸುಮ್ಮನೆ ಕೂತ್ಕೊಂಡಿದ್ದೀರಿ ಏನು ಹೇಳಲೇ ಇಲ್ಲ ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರೆ 307 ಅವರು ಚಾಲೆಂಜ್ ಮಾಡಿದಾರಲ್ಲ ಸ್ಟೇಟ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರಿ 307 ಮಾಡ್ಲಿಲ್ಲ ಅಂತ ಆಯ್ತು. The counsel for appearing for the state, that is additional SPP in criminal appeal number 1844 of 25.
96. State has filed 96 of
96. 96, one second. 936 of 2018. Would vehemently contend that trial court committed an error in acquitting all the accused for the offence punishable under section 307. ನಿಮ್ದು ಬರೀ ಓನ್ಲಿ 307 ಗ 2 and 3 ಗೇನಿಲ್ಲ. And counsel also would vehemently contend that the trial court not proper in a proper perspective not appreciated both oral and documentary evidence of the prosecution witnesses and committed an error, and this requires interference of this court to reverse the finding of the trial court in respect of the offence under section 307. Having heard the respective counsel appearing for the appellant and also the counsel appearing for the respondent in appeal, the point that would arise for the consideration of this court are whether the trial court committed an error in acquitting the accused number 1 to 3 for the offence punishable under section 307, and so also in respect of accused number 2 and 3 for the offence punishable under section 428A, as contended by the counsel for the complainant as well as the state, and whether it requires interference of this court. Whether the trial court committed an error in convicting the accused for the offence punishable under section 498A, and whether it requires interference of this court. What order? Having heard the respective counsel, and we have also given answers consideration to the both oral and documentary evidence available on record. Having considered the material on record, no dispute that there was a marriage between the PW1 and the accused number 1 that took place in the year 2002. It is also important to note that having acquitted the accused number 2 and 3, accused number 2 also passed away and hence appeal against A2 is abated. Now this court has to consider only the material against accused number 1 and 3. Accused number 1 is the husband and accused number 3 is mother-in-law of the PW1. It is also not in dispute that incident was taken place on 29/2013, almost more than 11 years of the marriage. It is also the case of the prosecution that in the previous date of incident, that is 19/9/2013, there was a quarrel between the husband and wife. It is also the case of the prosecution that accused only administered the good night and also the Martin, holding her mouth oblique nostril and made her to consume the same. It is also the case of the prosecution that, and the same was a forceful act, but no explanation on the part of the prosecution that if it is a forceful act of administering the good night and also the Martin, there were no any injuries. Even also there is any scratch mark. The wound certificate issued by the doctor who treated the injury also, except mentioning the identification marks and not stated anything about the injuries caused to her. It is also important to note that the evidence of the doctor PW8 is very clear that not found any substance of consumption of both the good night as well as the Martin. However, counsel appearing for the complainant brought to notice of this court that PW1 categorically deposed that made her to consume the good night but not the Martin. No doubt such answer is found in the evidence of PW1. And court has to take note of not only the chief evidence and also the cross examination. But in the cross examination of PW1, there is an admission on her part when the accused sprayed the Martin container spray. She made an attempt to escape from the clutches of the accused. At that time, cap was fallen down. And MO1 was also there on the showcase in the previous day. And so also MO2. But claims that he administered the same in the hall. And also doctor has inquired what had happened. What had happened. But claims in the cross examination that accused insisted not to disclose anything with the doctor and caused the threat. But she was conscious. But she was tired. But doctor also got omitted. And the same was not seized. The PW1 also admits that accused only shifted her to hospital. And police also taken her statement and signature to exhibit P1 at 7 p.m. But while giving the statement, she gave the statement that accused only administered the same. But in the cross-examination, she says that panchayat was held. In her side, only her parents have attended. But she claims that she was lacking in the house. But categorically admits that when the dispute was started after 3 years, herself and her husband started living separately. And this Galata was not known to anyone except her parents. It is also illustrated that prior to lodging of this complaint, she says panchayat was held in the Kollegal town police station. But she is not having any document. It is also her evidence that when she was staying along with her children at Nanjangudu in her parents' house, accused used to come and go. And also admission was given that thereafter her children were admitted to Nanjangood school, not forcefully. And accused only got held the panchayat. However, she was having life threat. It is her evidence that in the previous date questioned why she was standing in a particular place and enticing anybody. And on that date, she slept separately, and husband slept along with the children. But she claims that at that time A2 and A3 were there in the very same house. But categorically given the admission that not administered the Martin, but only administered the good night. Having taken note of these admissions on the part of PW1, and when the evidence of PW8 read conjointly, only PW8 says that on enquiry she revealed that husband only forcibly administered both Martin and good night. That is the chief evidence of PW8. And also it is very clear in the first para that victim came to hospital with the history that she has consumed the Martin and good night. And there are two versions. One is that victim has consumed, and another version that victim had informed the doctor that accused only forcibly administered the same. But PW8 also says that on enquiry, PW1 says that her husband Abdul Bashir, and also the in-laws forcibly administer the same. And the same is mentioned in Exhibit P5. Having considered this evidence, it is an improvement against all the accused that the PW1 given the version. And having considered the different versions of PW1 before the doctor, and different versions are given, and all the accused number 1 to 3 administered the good night and Martin, and one breath says that it was consumption by the victim, and another breath it was by the husband, and once again it was all the 1 to 3. And when such inconsistent evidence is available before the court, and the same is also not corroborates with the evidence of PW 8 as well as the evidence of PW 4, 5, 6 who are the relative witnesses. And the evidence of PW 1 cannot be relied upon with regard to forcibly administering the good night and Martin, and the doctor evidence also very clear that the said substance was not found in the FSL, and FSL report goes against the state, and hence the counsel appearing for the state cannot contend that trial court has committed an error in acquitting the accused 1 to 3 for the offence punishable under section 307. Now this court has to consider the aspect of invoking of 498A, and in respect of the allegation against A1 to 3 for the offence punishable under 498A, and considering the statement Exhibit P1 complaint, allegation is made against all the accused number 1 to 3, but in order to substantiate the same, nothing is found against accused number 2 and 3. And trial court, while considering the material on record, particularly in respect of A2 and A3, in paragraph number 27, taken note of PW1 in her cross-examination, stated that accused number 2 and 3 were never there in the house when the incident took place, and also with regard to the allegations of harassment on section 498A. And so also taken note of when the complaint was lodged, Exhibit P1, that too in the evening, not immediately after the incident. A statement was made before the police that accused number 2 and 3 were forcing her to get the gold ornaments from the parents' house in order to expand the business. But in order to substantiate the same, except the oral evidence of PW1, nothing is stated. And the same is taken note of by the trial court in paragraph number particularly 30 of the judgment, that against accused number 2 and 3 is not established by the prosecution, that PW1 herself in her deposition stated that accused number 2 and 3 were not present in the house when the incident took place, that is on 20th. And only allegation that they were witnessing the same, the cruelty as a mute spectators. But no such instances was given when they were sitting idle, when the cruelty was meted to PW1 by her husband. And only an omnibus allegation is made against accused number 2 and 3. And the same is also taken note of in paragraph number 31 of the judgment of the trial court. And hence we do not find any ground to reverse the acquittal passed against accused number 2 and 3. Now coming to the aspect of 498A against accused is concerned. Sorry, accused number 1 is concerned. And it is the specific case of the PW1 that there was a quarrel in the previous day on 19/9/2013. And also the incident was taken place on 29/2013. We have already taken note of the immediate statement was given by the victim and also particularly the document of wound certificate, which is marked as exhibit P5, no doubt, wherein said to have been cast on and due to having consumed one bottle of liquid Martin and liquid Goodnight at 9:30 a.m. And specific allegation is made that on 29/2013 at her residence, which was forcefully fed to her by her husband. And though it is stated that and in-laws and the same was noted at 10:15 a.m. and this court already comes to the conclusion that no corroborative piece of evidence with regard to the accused number 1 only administer the same. But with regard to the relationship was strained between the parties is concerned and the same is not disputed. During the cross-examination of PW1 itself, it is suggested to the PW1 that relationship was strained. The counsel appearing for the respondent appellant accused also in his argument would contend that mere relationship is strained is not amounts to a cruelty to invoke the offence under section 498A. And also there is no any material before the court that she was treated cruelty. But in the complaint itself, she has stated in exhibit P1 that after providing the food in the previous date on 19/9/2013, having provided food to the in-laws when she was cleaning near the dining hall, accused came and questioned why she is standing there and also quarreled to whom she is enticing and quarreled with him. As a result, she was humiliated in view of the act of the accused and also got her children and to teach a lesson to her and her in-laws. He left the house. But it is the specific case of the accused that she was staying alone and he took the children and slept separately. And hence it is very clear that there was an incident in the previous day. And though suggestion was made to the witness PW1 that no such incident was taken place. And also even doubting the fidelity of the wife amounts to a cruelty. It is also important to note that it is an admitted fact that due to the differences between them earlier when the harassment was made to the PW1, though no document is produced before the court, but it is clear that matter was even gone to the police station, Kollagal town police station. And thereafter she went and stayed in a parent's house. And also it is emerged during the course of evidence that subsequently the accused went and brought the PW1 and got admitted the children to the Nanjangud School. And these are the factors clearly discloses that they were not in cordial term. And also the reason is assigned by the PW1 that he was suspecting her fidelity and also telling her to go and live with anybody else. And when all these materials were taken note of, and no doubt the trial court comes to the conclusion in paragraph number 33 that 34, while considering the case of accused number 1 is concerned, that accused number 1 got intensified even after the conciliation and brought her back, started harassing her. Though it is held in para 34 that on monetary aspects and but for additional dowry, but the trial court taken note of suspecting her fidelity. And apart from that, considering the documents of exhibit P1 complaint which was given in the evening in the hospital, wherein also categorically deposed with regard to get the gold ornaments from her parents in order to expand the business, and nothing is elicited with regard to the contents of the document of exhibit P1, and also in the cross examination of PW1 demand is concerned and subjecting her for cruelty. And when such material is taken note of, though it is mentioned it is for the monetary reason, but the allegation of insisting her to get the gold ornaments subsequent to the PW1 brought to the house of accused is not specifically controverted. And when suching the case and material available before the court, we do not find any grounds to interfere with the findings of the trial court in respect of the offence punishable under section 498A. The PW1 also in her evidence specifically deposed before the court that the husband is having the husband suspecting her character. That she is having a illicit relationship with her husband, father, and also the brother. And he used to lock her in the room, putting the latches, and also abusing her in a filthy language and assaulting. And the said act was continued. And the intention of the accused is not to come out from the said room. And if any person comes to the house also, making an allegation that she is having an affair and used to quarrel with her taking the same. So also narrated in page 4 of the PW1 that the harassment means abusing and also making an allegation of affair. And so also particularly in respect of the incident referring that 1909-2013, questioning why she was standing near the dining table when she was cleaning, and this evidence clearly discloses that the allegation made against the accused in her chief evidence, and the same has not been specifically controverted in the cross-examination of PW1. And though the order of the trial court is cryptic with regard to in arriving for a conclusion of invoking of 498A, and cross-examination is also only concentrating on an attempt made to administering the poisonous substances. But with regard to the harassment is considered, same is not controverted in the cross-examination of PW1 in respect of the references which have been made in the chief evidence. When such being the material available on record, though the order of the trial court is cryptic with regard to in coming to the conclusion of invoking of offences in 498A, and the contention of the appellant counsel for the accused cannot be accepted, that the same will not amounts to a cruelty, and it amounts only a differences between the accused and PW1, and the same is a strained relationship between both of them, and the said contention cannot be accepted when specific evidence is deposed by the PW1 with regard to meeting her to the cruelty. And when such being the material available on record, we answer the points accordingly, that the state as well as complainant have not made out any ground to convict the accused for the offences punishable under section 307, that is accused number 1, and also reversing the judgment of the trial court in respect of accused number 3 is concerned, since accused number 2 is already abated, and the trial court not committed any error in convicting the accused for the offence punishment section 498A. In view of the
Here-
discussions made above, we pass the following order.
My lord, one submission. This offence, my lord, is of 13 years old it is. My lord, 498A, it is not punishable for death or life imprisonment. Maximum, my lord, only 3 years it is. My lord, the beneficial provision of Probation of Offenders Act is to be invoked. My lord, he has no antecedent, your lordship. My lord, it is a matrimonial.
Antecedent means this is a continuous offence.
Yes, yes, it is. This is
But
only.
earlier also they have approached the police, every time they goes to the police station, and
This is, my lord, it is an husband and wife quarrel, it is a family dispute. It is a matrimonial dispute it is. He is not a habitual offender of committing any offence and all that. My lord, in such circumstances, my lord, Supreme Court has exercised discretion, my lord, that to release on probation recently also, since long time, my lord, your lordship may kindly. Here also, my lord, a case of 498A and 304B was there, 304, 498A. The lordship considered the scope of 360 and section 4 of the Probation of Offenders Act. Lord, kindly go to paragraph 27, 28, my lord.
Yes.
Hello, paragraph.
Paragraph number ಯಾವ್ದು ಹೇಳಿ?
28.
28 ಹೇಳಿ.
Yes, please.
Summing up the legal
Summing up the
position.
legal position, it can be said that while an offender cannot seek an order for grant of probation as a matter of right, but having noticed the object that the statutory provisions seek to achieve by grant of probation, and several decisions of this court on the point of applicability of section 4 of the Probation Act, we hold that unless applicability is excluded in a case where the circumstances stated in subsection 1 of section 4 of Probation Act are attracted, the court has no discretion to omit from its consideration release of the offender on probation. On the contrary, a mandatory duty is cast upon the court to consider whether the case before it warrants releasing the offender on fulfillment of state circumstances. The question of grant of probation could be decided either way. In the event the court in its discretion decides to extend the benefit of probation, it may, upon considering the report of probation officer, impose such condition as deemed just and proper. However, if the answer be negative, it would only be just and proper for the court to record the reasons therefore. For the foregoing reasons, in the light of the factual matrix, we are unhesitatingly of the opinion that Session Judge and the High Court were omitting to consider whether the appellants were entitled to the benefit of probation occasioned a failure of justice. Consequently, there was no worthy consideration as to whether the appellants could be extended the benefit of probation. We are conscious that in MCD Supra, since followed in the state of Madhya Pradesh with Mansingh, this court has held that the report of probation officer referred to in subsection 2 of section 4 of the Probation Act is a condition precedent, and therefore must be complied with by the trial courts and the high courts. Importantly, it has also been held that the courts may not be bound by such report. In such view of the matter, we need to make appropriate direction. Accordingly, while maintaining the conviction recorded against the appellant, but looking to the facts and circumstances, we are inclined to remit the matter to the High Court for limited consideration of the question of grant of probation to the appellant upon obtaining a report of relevant probation officer. It is ordered accordingly. My Lord, one more decision, my Lord, 2016, this is also Supreme Court, my Lord, where the benefit of probation for 498A. My Lord, considering the facts and circumstances of the case, my Lord, that was. Kindly, my Lord, go to paragraph 10, your Lordship, there. Lord, they have considered, my Lord, paragraph 23, my Lord, 23. Yes. The previous judgment, my Lord, of 2000 has been considered. Paragraph 23, your Lordship. We have referred to the aforesaid authority to stress the point that the court, before exercising power under section 4 of the POR, has to keep in view the nature of offence and the conditions incorporated under section 4 of the POR. It stated in Dalbir Singh versus State of Haryana and others, year 2000 Supreme Court 1677. It has been held that Parliament has made it clear that only if the court forms the opinion that it is expedient to release the convict on probation for the good conduct regard being had to the circumstances of the case, and one of the circumstances which cannot be sidelined in informing the said opinion is the nature of the affair. The court has further opined that the discretion has been vested in the court to decide when and how the court should form such opinion. Yet the provision itself provides sufficient indication that releasing the convicted person on probation of good conduct must appear to the court to be expedient. Explaining the word expedient, the court held thus: the word expedient had been thoughtfully employed by Parliament in the section so as to mean it as apt and suitable to end in view. In Black's dictionary, the word expedient is defined as suitable and appropriate for accomplishment of a specified object, beside the other meaning referred to in earlier. In the state of Gujarat was Jamandas. Learned judges have observed in paragraph 21 thus. Again, the word expedient used in this provision has several shades of meaning. In one dictionary sense, expedient means apt and suitable to the end in view, practical and efficient, politic, profitable, advisable, fit, proper, suitable to the circumstances of the case. In another shade, it means device characterized by mere utility rather than principle, conducive to special advantage rather than what is universally right. It was then held that the court must construe the said word in keeping with the context and object of the provision in its widest amplitude. Here the word expedient used in section 4 of the POR in the context of casting a duty on the court to take into account the circumstances of the case, including the nature of the offence. This means section 4 can be resorted to when the court considers the circumstances of the case, particularly the nature of the offence, the court forms its opinion that it is suitable and appropriate for accomplishing specified object, that the offender can be released on probation of good conduct. We have highlighted these aspects for the guidance of the appellate court, as it has exercised the jurisdiction in a perfunctory manner. We are obligated to say that the High Court should have been well advised to rectify the error. At this juncture, learned counsel for the appellant respondent would submit that no arguments and merits were advanced before the appellate court except seeking release under PWAC. We have made it clear that there is no minimum sentence. Hence, the provisions of PWAC would apply. We have also opined that the courts has to be guided by the provisions of PWAC and the precedents of this court. Regard being had to the facts and circumstances in entirety, we are also inclined to accept the submission of learned counsel for the respondent that it will be open for them to raise all points before the appellate court on merits, including seeking release under PWAC. Resultant, the appeal is allowed, the judgment and order of High Court and the appellate court are set aside. Matter remitted to appellate court for disposal in accordance with law. My lord, here the conduct, my lord. As soon as he learned that she has consumed poison, my lord, he has taken her to hospital. My lord, it is, my lord, in the sense of his understanding, my lord, he was in the right side. She claims, my lord, that this man is something a different person. My lord, it all depends upon individuality. This is not a crime, your lordship. Man lives in his own forum. This is to be taken into note of. It, in his sense, my lord, he justifies, my lord, he was rightfully taken care of, wife, my lord, never treated. She developed all these, my lord, that being intelligent. She developed all these kind of story. Try to withstand, my lord, in spite of effective cross-examination. My lord, this cannot be lost sight of. Circumstances of the case, he has a aged mother, my lord, two children are there. He is still in visiting terms with the children. ಅಲ್ಲಿ ನಂಜನಗೂಡು ಇದ್ದಾರೆ, ಇವರು ಹೋಗ್ತಾನೆ ನಂಜನಗೂಡಿ ಅವ್ರ ಹತ್ರನೇ ಇದ್ದಾರೆ, ಈಗಲೂ ಹೋಗ್ತಾರೆ. ಆದ್ರೆ ಇವನು ಅವ್ರ ಹತ್ರ ಮಾತಾಡಲ್ಲ.
Children ಈಗ ಯಾರ ಹತ್ರ ಇದ್ದಾರೆ?
Wife
and
mother
children are living separately.
Yes, but he visits, my lord, he has a touch with them. They have affection towards him. Well, this kind of some bondage, my lord, it should be maintained. 13 years is over. After separation also, every festival, my lord, he never miss. He will go. That's what the information he got it. Well, this should continue it is. And he is not a vagabond. Well, for earning, well, he does welding work and all that. As a fabricator.
Yes, what is
well,
it?
This is not the first incident, my lord. Since from 11 to 12 years she is suffering. Day to day, every day they are suffering. Harassment is there.
Third, having dictated the judgment of this court, at this juncture, the counsel appearing for the appellant brought to notice of this court judgment of the Apex Court 2025 Supreme Court, Supreme within bracket SC 685. Invoking of section 360 of CRPC and section 4 of Probation Act. And brought to notice of this court, paragraph number
28 and 30.
28. Wherein the Apex Court discussed with regard to the invoking of section 4 of the Probation Act and also the legislative wisdom to consider the same. And also in this judgment, it is made it clear that the question of grant of probation could be decided either way. In the event, the court in its discretion decides to extend the benefit of probation, it may, upon considering the report of the probation officer, impose such conditions as deemed just and proper. That means the question of grant of probation could be decided either way. The other judgment which has been relied upon by the Council 2016 Supreme SC 989, wherein also scope of section 4 of Probation Act also discussed in para 23, and council brought to notice of this court, wherein also the Apex Court taken note of the earlier judgment in Dalbir Singh versus State of Haryana and others reported in the AR 2000 SC 1677. wherein also it has been held that Parliament has made it clear that only if the court forms the opinion that it is expedient to release the convict on probation for the good conduct regard being had to the circumstances of the case, and one of the circumstances which cannot be sidelined in forming the said opinion is the nature of the offence. The counsel appearing for the complainant would submit that the harassment is continuous harassment, and also records clearly reveals that not only the particular incident was taken place, and even in the earlier date also the harassment was made. Thereafter the victim and also the children left and settled in the parental house earlier, but accused only in spite of it having made panchayat brought her back to the matrimonial home and again continued the same, and hence this court has to take note of the same. Having heard the counsel appearing for the appellant as well as the counsel appearing for the state, and no doubt having considered the provisions of penal provisions of section 498A, and the same is extendable to for a period of 3 years and maximum punishment is given, and shall also be liable to fine. And in the case on hand, this court has to take note of the fact that only the particular incident was taken place in between the PW1 and the accused. The material emerges before the court that earlier also the wife had left the company of the accused along with children and staying along with her parents, and subsequently after lapse of some of the years brought her back but continued the same, and hence the principles laid down in the judgments referred supra are not comes to the aid of the appellant. And if it is a first incident, there would have been a force in the submission of the counsel appearing for the appellant, and no doubt incident was taken place in 2013, now almost 13 years. But the fact is that children and the wife are living separately and not along with the accused even after the expiry of 13 years of the particular incident. And when such being the case, it is not a case for invoking of either section 360 or section 4 of Probation of Offenders Act. However, taking into note of maximum punishment awarded by the trial court, ought to have considered the same in a lenient approach, since both of them lived after the marriage of 2002 together, and thereafter differences were arisen between them and relationship was strained, and hence it is appropriate to reduce the sentence of 3 years to 1 year with a fine.
May I intervene, my lord?
With a fine of rupees.
May I intervene, my lord?
Really.
He has suffered, my lord, 20 days of imprisonment.
Set up ಕೊಡೋಣ ಎಷ್ಟು ದಿವಸ
20 ದಿವಸ ಅಂಡರ್ ಟ್ರಯಲ್ ಆಗಿತ್ತು
ಕೊಡೋಣ ಸೆಟ್ ಅಪ್ ಕೊಡೋಣ
ಮಿಲಾಡ್ ಅದೇ ಮಿಲಾಡ್ giving that period already undergone
with a fine of rupees 30,000 and hence
the fine can be enhanced, my lord, lordship may kindly pass, my lord, period already undergone
set up ಮಾಡಕ್ ಬರಲ್ಲ
ಅದಲ್ಲ period already undergone with my lord fine, my lord, which can be deposited in the name of children,
and hence directed to pay fine of rupees
10,000, my lord.
30,000 10,000 already trial court ಅವರು ಹಾಕಿದ್ದಾರೆ.
ಅದೇ ತಾವು ಇಲ್ಲಿ ಎನ್ಹಾನ್ಸ್ ಮಾಡೋದು
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅವರು ಹಾಕಿದ್ದಾರೆ. ಈಗ ಮಾಡಿದೀವಲ್ಲ ಸೆಂಟೆನ್ಸ್ 2 ವರ್ಷ ಕಡಿಮೆ ಮಾಡಿ 20 ಇದ್ದಿದ್ದು 30,000 ಮಾಡಿದ್ವಿ ಅಷ್ಟೇ. ರಿಡ್ಯೂಸ್ directed to pay fine of rupees 30,000 and the same is payable to the PW1 on depositing of the amount. 30,000 also payable to the PW1 only. Amicus curiae, the registry is directed to pay fine of rupees, the fees of rupees 10,000 to the counsel who appear on behalf of the appellant in criminal appeal number 736 ಅವ್ರದ್ದು 736 of 2018 for giving able assistance in disposal of the case as amicus curiae. Next. ಡೇಟ್ ಯಾವಾಗ ಕೊಡ್ತಾ ರೆಡಿ ಇದೀರಿ? 5 ಗಂಟೆ ನಾವು ರೆಡಿ ಇರ್ಬೇಕು. ನಾಳೆ ಆಗಲ್ಲ, ನಾಡಿದ್ದು ಆಗ್ಬೋದಾ? ನಾಡಿದ್ದು ಮತ್ತೆ ಫ್ರೈಡೆ ಆಗುತ್ತೆ, ಬೇಡ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಕೊಡಿ. ಏನ್ ಹೇಳಿ? ಅಲ್ಲ ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್ ಹಾಕೋಬೇಕು ಮೇಡಮ್. ದಿ ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್ ಫಾಸ್ಟ್ ದಿ ಫಾಲೋಯಿಂಗ್ ಆರ್ಡರ್ ಅಂತ ಮಾಡಿ, appeal filed by the state and complainant are dismissed. The appeal filed by the appellant accused is allowed in part anta ಮಾಡಿ, the sentence is reduced to 1 year by enhancing the fine amount from 10,000 to 30,000. The entire amount of fine amount is ordered to be paid in favor of the PW1 on proper identification anta haki. ಅದು ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್. ಯಾವ್ದು ಡೇಟ್ ಹೇಳಿ?
November 19.
19 ಯಾವ ಇಯರ್ದು? 2018 ಯಾವಾಗ? 18/2. 21/2 ಇದರಲ್ಲೇ ಡೇಟ್ ಕೇಳಿರಣ್ಣ ಬೆಳಗ್ಗೆ ಯಾರಲ್ಲ? ಆಯ್ತು. 21/2
21, 22, 23,
21 21 ನಲ್ಲಿ
21 ಅಲ್ಲ 26/2
21.1 lots it has to be updated ಅಂತ.
ನೀವೇನ ಪ್ರೆಸ್ ಚೆಕ್ ಮಾಡ್ತೀನಿದ್ರಲ್ಲ?
ಅದಾಗಿದೆ ಸರ್. There is no fine in this lots, so it can be.
No fine also.
ಇಲ್ಲ.
Told. The counsel appearing for the appellant in criminal appeal number 484 of 23 connected with criminal appeal number 995 of 23 reported the death of the appellant and no fine is imposed against the appellant, and hence and the counsel appearing for the state HCGP Srimati Rashmi Patel also confirms that he is no more, and hence case against the appellant in criminal appeal number 484 of 23 is abated. The registry is directed to delink the criminal appeal number 995 of 23 and list this matter for final hearing on 26/2. But ಇವರು ನೀವು ಅಮಿಕಸ್ ಕ್ಯೂರಿ ಅಲ್ಲಲ್ಲ?
ಇಲ್ಲ ಲೀಗಲ್ ಸರ್ವಿಸ್.
ಬಾಕಿದೆಲ್ಲ 26/2. ಯಾವ್ದು? ಅದರಲ್ಲಿ ಒಂದು ಸೆಂಟೆನ್ಸ್ ಸೇರಿಸ್ಬಿಡಿ ಮೇಡಮ್. ದಿ ಅಕ್ಯೂಸ್ಡ್ ಈಸ್ ಎಂಟೈಟಲ್ಡ್ ಫಾರ್ ಸೆಟ್ ಆಫ್ ಅಂಡರ್ ಸೆಕ್ಷನ್ 428 ಆಫ್ CRPC. ಈಗ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಡಿಕ್ಟೇಷನ್ ಮಾಡಿದ್ವಲ್ರಿ, ಅದರಲ್ಲೇ ದಿ ಅಪಲೆಂಟ್ ಅಕ್ಯೂಸ್ಡ್ ಈಸ್ ಎಂಟೈಟಲ್ಡ್ ಫಾರ್ ಸೆಟ್ ಆಫ್ ಅಂಡರ್ ಸೆಕ್ಷನ್ 428 ಆಫ್ CRPC. ನಾಗರಾಜ್ ರೆಡ್ಡಿ ನಿಮ್ ಕೇಸಲ್ಲಿ 302 ಫೈನ್ ಹಾಕಿಲ್ಲ?
ಫೈನ್ ಹಾಕಿರ್ಲಿಲ್ಲ ಸರ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್.
ಫೈನ್ ಹಾಕ್ಬೇಕೋ ಬೇಡ? 302 ನಲ್ಲಿ
ವಿತ್ ಫೈನ್
ಎನಿ
ವಿತ್ ಫೈನ್ ಅಂತ
ಡಿಸ್ಕ್ರಿಷನ್ ಟು ದಿ ಕೋರ್ಟ್ ಆರ್ ಅಂತಿದ್ಯಾ ಅಥವಾ
ವಿತ್ ಫೈನ್ ಅಂತಾನೆ?
ಇಲ್ಲ ಇವತ್ತಿಗೆ.
ಹಾ 13/2ಗೆ ಏನಂತ ಮೆಸೇಜ್? ಯಾವಾಗ ಯಾರು ಕಳ್ಸಿದ್ದಾರೆ? ಯಾರು ಕಳ್ಸಿದ್ರು? ನಾವಂಗೆಲ್ಲ ಯಾವ್ದು ಮೆಸೇಜ್ ಕಳ್ಸಕ್ಕಲ್ಲ. ಇಲ್ಲ ನೋಡಿ ಸರಿಯಾಗಿ ಮೆಸೇಜ್ ಒಂಥರ ಕಳ್ಸಲ್ವಲ್ಲ? ಮೆಸೇಜ್ ಯಾರು ಕಳ್ಸಲ್ವಲ್ಲ ಸರ್? ಏನಾಯ್ತು ಅದು?
ಮತ್ತೇನ್ ಮಾಡೋದೀಗ? ಅಲ್ಲ ಇವಾಗ ಏನ್ ಮತ್ತೇನ್ ಯಾವ್ದು ಕನೆಕ್ಟೆಡ್ ಯಾವ್ದು ಹಾಕೋದು? ಯಾವ್ದು ಕನೆಕ್ಟೆಡ್ ಇಲ್ವಾ? Twenty-one, 26 2. ಅಲ್ಲ ಇದು ನಂಬರ್ ಮೇಲ್ಗಡೆ 736 ಕೊಡಿ ಹಾಕ್ತಿರ್ತೀನಿ. 736 ಹೇಳು ಹೇಳು